who testified at the bond hearing.
Correct. And he was listed, and even though he wasn't formally listed after, they are on notice that he's a witness. And not to mention, Judge, if you recall, they are the ones who introduced the record contract that was done by Mr. Shites.
Well, that has not been introduced into evidence. Let's just make that clear. That was used to refresh a witness's memory. It's not been shown to the jury.
But just like on the state, throughout the course of the past 2 weeks, we bring up something in particular that will not a discovery violation because it's been provided to them in this version of the discovery. Just because an automatic exclusion just because of taking someone as a witness,
I am aware that that is not the go-to sanction for failure to disclose. I'm trying to right now just get a baseline understanding so I can conduct my Richardson hearing and make my 3 required findings. So first and foremost, I understand. You're saying Mr. Shipes was listed for a bond hearing. You would acknowledge he was not listed as a Category A witnesses for purposes of trial. And Ms. Robinson was not listed at all in any way, shape, or form during the 5-year pendency of this case.
and that I will concede. However, I will also make the argument because I've dealt with this many times where they're like, oh, but that witness is listed in the supplemental report, so you are on notice. This is Mr. Robinson, Abdul Sr.'s biological daughter.
Okay.
She's living in the house. She is the one that was dragging the wives and father. They have been on notice that she has information from this case from its inception. Nothing prevented them from going and speaking to her. I will concede, Your Honor. We never listed her.
And look, I'm going to give both sides the opportunity to make argument. I just need the simple fact of was she listed, was she not listed? Okay. In addition, and of course, the rules of discovery 3.220 require both parties to have that obligation to list the witnesses that they intend to call at trials category A. I think we can all agree on that. I will also add in there that my trial orders that I have entered throughout the pendency of this 5-year case, first done in February of 2023 and most recently done on February 19 of 25, also requires the parties to provide to the court the list of witnesses that might possibly testify, so I could read those names out to the jurors to see if any of the jurors are related by blood or marriage to the witnesses or have any business or social relationships with them. And I read out this complete list of names. And I asked the state, I asked Defendant Whitaker, I asked Defendant Robinson, are there any other names? You would acknowledge that Mr. Shipes' name and Ms. Robinson's name were not read. Okay. That being the case, I need to conduct this Richardson hearing because these witnesses were not listed. Okay. So I need to understand first for Mr. Shipes and then for Ms. Robinson how you came to know about them, when you decided to list them or call them as a witness, and why, so I can determine whether this was willful or inadvertent.
So the decision to call them is strictly because of the evidence that was brought out when the state was doing their rebuttal of Abdul Sr.
And what specifically?
When they asked Abdul Sr., which was a subject, I think, of my motion to eliminate, about people opining on who the shooter is if they are not there. Okay? So they have
You mean looking at the video and identifying Mr. Robinson?
correct.
Okay.
No issue with Byron doing that. He was there. Any other witness who was present, because it's not an improper opinion because they actually saw it. So we were not, they didn't even bring it up in the direction. It was in their rehab after we crossed that they specifically brought up that video. Mr. Abdul Sr. testified he had not seen him all day. So then they asked him, in your opinion, based on his body movements and things like that, even though he's never testified he's seen his son running or anything to that effect, gives this opinion, which in my opinion, coming from his father, is extremely prejudicial, and him just giving his lay opinion, yes, that's my son in a video where I cannot identify that. That's my son, and in my opinion, that looks like him, even though there's nothing identifiable. We did object immediately, Judge.
Yes, and let me clarify though, that came out both during the state's direct of Mr. Robinson and on redirect. So it came out at both occasions where they showed him the video and he identified. And we came sidebar, I think, on the first occasion to hear the objection, and I ruled then, explaining, of course, that the law allows somebody who is familiar with the subject to look at a video or a photograph and identify the subject. So are you telling me that the court's ruling was a surprise that this was going to happen? Because I know you all have deposed Abdul Sr., I think the first time in 23, so over 2 years ago, and then again in 24. He was deposed twice, was he not?
He was.
Okay. And presumably testified that he would be identified or would be identifying his son in the video. So that could not have been a surprise to now in the middle of trial decide, oh, he's identified him in the video. Because let me just say this, you all are smart lawyers, but you all know the case law. And 2nd DCA, 3rd DCA, 4th DCA, 5th DCA have all said that a witness can identify someone from the video. It does not invade the province of the jury. There have been cases where police officers have been able to identify. Parking security guards have been able to identify in video or in photographs if the predicate can be laid that they are familiar with the person, that they know the person, that they have some special relationship with the person that maybe a common person or a juror seeing it for the first time would not have. And that's especially true in cases in which the video or the photograph are not clear or don't particularly show the individual. And I'll just for the record cite a couple cases for these propositions that I'm stating, or not propositions, for the law that I'm stating. From the 3rd District Court of Appeal, we have Kopp, K-O-P-P versus State, and that is at 334 Southern, I'm not wearing my reader, so excuse me, Southern 3rd, 453, that the testimony of a parking garage security guard who identified the defendant on surveillance footage did not invade the province of the jury. The state is allowed to present this type of identification witness who is capable of independently identifying an individual from photographs, tape recordings, or similar evidence, or to simply support other identification evidence when that might be subject to challenge, assuming the state has laid the foundation.
And in that case, I believe that individual was a witness to the actual crime. That's where our issue was. I don't have a problem with people who are actually there, opining that the person looks like the person that they saw in real life.
I don't know if this witness was an individual to the crime, but I'll cite just for the record, Day versus State. That's from the 2nd District, 105 Southern 3rd, 1284. Again, a police detective could testify that she recognized the defendant as one of the perpetrators in a surveillance video of a theft. Obviously, the detective was not a witness, but the predicate was laid that she was familiar with him from other communications and contacts. Likewise, in the 2nd District, Ratcliffe versus State. No, sorry, that's not the case. Anyway, and I'm only saying that to understand, knowing what Mr. Robinson would testify, knowing the law of the state, when and why did it take in the middle of trial, after the state is rested, after JOA, to list Ms. Robinson as a witness?
Well, Your Honor, if you recall, when we were at sidebar and we were addressing this issue, that Mr. Ksoo specifically said, if you are going to open this door, you have a courtroom of family members who are in a similarly situated position to give their opinion as to whether or not that is him. That you are now opening that door. So when it was going on, we actually raised that issue to them and reiterated there's a bunch of family members here. So I'm just letting you know. So we put them on notice
Well, they are required to before I allow that to come in.
And understood, this is just for us to gauge it. This wasn't willful. It was not willful, Judge. So that's why I'm saying that in the moment where we sat, and if that was on the defense counsel for not knowing that specific case law, then that would mean that we were ineffective in not listing her before. So, and I will concede that, if that's the situation.
So is her testimony, because I understood you were calling her for reputation. Are you calling her to look at the video and say that's not Mr. Robinson? Are you calling her for reputation evidence against Mr. Robinson Sr.?
I don't want to get into an area, Judge, where it's going to be opening any doors. I will say that she is, I'm not going to ask her, you were sitting here and watching your father and opine on whether any, that's inadmissible.
Yes, I just want to be sure about that, because you all kept saying yesterday that you might be calling someone from the audience for reputation, and that's a whole other decision I need to make in pretrial ruling of admissibility that I'd need to consider before allowing that in to see if that predicate is laid for reputation. So that being out the window then, your intention for calling Ms. Robinson is to show her the video to say that is not Mr. Robinson.
Correct. And the state is aware, and I will make her available. I asked her to sit outside this morning. If the state's in between and I want to take a break to be able to speak to her since they're arguing, we haven't been able to take her depositions. They can speak to her before. Not taking deposition isn't, you know.
And then to be clear, since you've stated she's not here now, she has been here during the pendency of this trial this week and last week.
Yes, my understanding is, and I would have to ask her, is I do believe when she did at some point during his testimony get up and walk away when he said that he had no family in the courtroom. That's just, you know, I believe that she may have left during a portion of it. She is his biological daughter. Just to let the state and the court know the parameters of where I would go, I would say she was living at the house as well at that time. She saw Hakeem very frequently. She's very familiar with him. She was able to see the video on the media on multiple occasions. And in her opinion, is that her brother, Hakeem Robinson?
Okay. And tell me, state then, how you've been prejudiced or what other alternatives. If I gave you a break to depose her now, to speak to her now, to proffer her entire testimony here right now before we present it to the jury. It's that, or a mistrial or exclusion. As you know, and I will acknowledge, I think all parties can, exclusion is the last resort, it's the last remedy, and it could cause a reversal if I have not considered other less restrictive sanctions for the discovery violation.
I understand, Your Honor. All right, a couple things. I want to go back to, because are we still talking about Shipes as well?
We can talk about both of them, but admittedly, you will acknowledge Shipes testified not once, but twice at Mr. Robinson's bond hearings back in, I don't even remember, 2021 perhaps?
We shared with the court and counsel one of the YouTube clips, I believe of, I guess it was maybe the second bond hearing.
That was the second bond hearing.
And so I don't think we have anything from the first bond hearing, but we have that. And in reviewing that bond hearing, the defendant repeatedly objected to the state's questions as being beyond the scope of the bond hearing. In addition, the court, rightfully so, but the court cut off the state's questioning as being far afield of what the issue was. So and if you watch that, we were exploring his basis of knowledge about how he knows, in his opinion, that the video is not the defendant. And those were objected to and then subsequently cut off by the court because of, we're here for a bond. It really doesn't matter to me the guilt or innocence of the defendant. The question is whether or not you can bond this guy out. We would not be able to depose this person because he's never listed. So, I mean, the fact that he's a record executive that would be willing to bond the defendant out gave us no notice as to what he's coming into this court and testifying to. I put him in the exact same boat as I do the daughter of Abdul Robinson. I think it is indistinguishable, those two.
And why, and what is the purpose of calling Mr. Shipes? Are you calling him for what? Are you going to show him the video and ask him to say that it is or isn't Mr. Robinson? But he wasn't with him on the day. Well, but that's the argument you're making about Senior, that Senior wasn't with him on the day, so he shouldn't have been able to identify him, but you're going to put on Mr. Shipes, who wasn't with him on the day, was out of state in New York, to identify or not identify Mr. Robinson?
But Your Honor ruled against us and said that he didn't have the basis of knowledge, so it should also apply to Mr. Shives. He was with him the months leading up to it. He spent probably more time with him than Abdul Senior. So now, because you allowed that in, he does have the basis to put in, and just so that the state is aware.
So are you telling me that you could not in any way, shape, or form have anticipated or were prepared in your case to present witnesses to look at the video to say, that's not Mr. Hakeem Robinson? You weren't going to do that unless someone was going to identify? And you didn't know Abdul Sr. was going to identify his son on the video?
I didn't believe that they were going to try to introduce what I thought was improper opinion testimony. And Your Honor, I know Mr. Rossi says, well, they weren't listed, I couldn't take their depo. The laws don't say that. If they are free to take anybody's deposition they want, they don't need the eve of the court, they don't need to be listed as state witnesses. As if they have a reason to believe that the person has first-hand knowledge, then they are allowed to send a subpoena, speak to them. So the fact that they weren't listed does not mean that they can't take his depo.
How are they to guess that you were going to show the video to a New York music executive and ask him to identify or not identify Mr. Robinson in that video?
I think he said it at the bond hearing, but Judge, it's reasonable. Everyone has seen that video.
I don't recall hearing that at the bond hearing because I think I sustained an objection.
He did say that, and then we tried to explore the basis of it, and that's when the objections were sustained.
All right.
So Judge, they're on notice. They were on notice from back then that he was able to make that opinion for something that they believed was admissible evidence because they sought to bring it up.
What I don't like is, I will tell you honestly, I expect both sides to follow our rules of discovery, to follow rules of professional conduct, ethics, civility, professionalism. This is not trial by ambush. To have a witness listed at 8:18 p.m. or sometime after 8 o'clock p.m. that has never been listed in the 5 years of this case, after the state is rested, after the arguments of JOA, I can tell you I don't like it. I can tell you the appellate courts don't like it. Now, whether or not I'm excluding, I haven't decided at the moment. I still need to hear further argument, but this is not how we handle trials here. Period. End of story. So I need to know from the state, if I give you the opportunity to depose Mr. Shipes, to depose Ms. Robinson, if we break now, the jury can wait, I suppose, for you to talk to these people. Will that be sufficient to satisfy any procedural prejudice that you believe you have suffered due to the defendant's lack of listing these witnesses for purposes of trial?
The answer is no. It will certainly help, and we'll do it as quickly as we can do it. The answer is no, because deposing someone 5 minutes before they go on the witness stand isn't the purpose of depositions. I can respect that the defense is proffering what they're going to say. What we need to do after putting them under, we have thousands of photographs we can show these witnesses and go through and see if they can identify other things. We have then background research to see whatever else this person has done in their life, talk to people that they deposed our witnesses for days, multiple times, and now in the absolute, when Mr. Robinson says, that's my boy, they're countering that with people that we've never even talked to. If we talk to them 5 minutes before, we don't have transcripts, we can't go and follow up on all the evidence that we have here and show those witnesses. It will take hours to depose these people properly. And so that's the prejudice. Our entire trial strategy may change because of this, which is completely unfair to the state. Maybe we wouldn't have asked that question. Maybe we wouldn't have asked Mr. Robinson that question, if we knew that other people were countering it. So there's a whole trial procedure from opening. We haven't mentioned these witnesses in opening. If we knew these witnesses existed, maybe we would have mentioned them in opening. Maybe we'd have gone through the process of all of our witnesses in our case in chief of building around how Mr. Robinson knows more than these other witnesses know, but we couldn't anticipate that they would call witnesses they haven't listed. That is the prejudice, and I know the court is aware of what trials are, especially this case more than others. The amount of time, effort, evidence that we've put into this case is unusual. This isn't a PFCF case where there's 2 witnesses or something like that. This is hundreds and hundreds of hours. I would also point out that the defense motion in limine that was filed in July that we heard. Paragraph 2, they actually anticipated this exact issue by saying that they filed a motion saying that no officer should be permitted to give their opinion. And so it's shocking to me that the word no witness could have been included instead of no officer. That, the court can render its own judgment about whether that was intentional for what we're dealing with here today, or whether or not that was merely accidental that they just said officer instead of witness, knowing the only person in the case that was identifying someone from that video was a witness. And they filed a motion in limine saying no officer. And that was this defense motion in limine that was filed July 13th.
And Your Honor, I don't misquote cases, so the case that I cited to, the officers, so I wouldn't put something in there more about the state of the case all the time.
I was not saying she was misleading the case law. What I'm saying is, if they believed that Abdul Robinson's testimony was inadmissible, they 1,000% would have put it in their motion in limine. And that was the only direct evidence of someone identifying someone was Abdul Robinson. Yet they took the time to put in a paragraph, no officer will identify him, when none of the officers identified him from the video. So I submit to you that this was intentional. They intentionally did not put no witness because they didn't want the state to know that other witnesses would come into this court and give an opposite opinion of Abdul Robinson.
So he says I'm not saying it's intentional, but just argue that it's intentional as a defense to that, Your Honor. I am saying that that is what I put in there based on the case law that I was aware of at the time. In my opinion, I did not believe that Abdul Robinson, just because Joe Cooper says, is that him in the video, doesn't make that statement admissible. So I didn't believe that that was a proper that he was a proper person to make that opinion.
Despite the case law that says he can absolutely do that?
Judge, the case law that you're citing to, as you can see, I'm trying to differentiate it on the fly right now.
Okay.
So, and in those cases too, I would submit, and without looking at them and digesting them and studying them, almost positive that I could differentiate that with the fact that this is not the same situation where you have a video of someone who is completely covered. There are nothing about what he can say. He is not, for him to say, oh, he's running and his body morphology, that is what he tried to find. We objected to it because we truly believed that it wasn't admissible evidence. That there, Your Honor, is indicative of what you believed at the time would have been admissible evidence. So it's for them to argue that this was done on purpose is extremely disingenuous of an argument to me. We have been going through this trial. There are things that have been popping up on the fly that we have argued they should have let us know and changed the testimony of certain witnesses, and that has all been allowed. So I'm just, if they're saying that, oh,
Listen, I'm not saying, I'm here for this. I'm not going to rehash what testimony has already come up. Witnesses are impeached in trials all the time if they change their testimony from what it's been from deposition to current. Because that has occurred in this case for some witnesses, not others, I'm not, that doesn't play in my consideration. It's not like, oh, judge, because they did it, we can do it. Two wrongs don't make a right. I am here to decide these witnesses. They were not listed. What they have to say, whether it was inadvertent or willful, whether what they have to say or whether this violation was trivial or substantial, and then how and to what extent the state was prejudiced, and then what sanctions I can impose for the violation. It's already been determined they weren't listed. So that's why we're having a Richardson hearing, because witnesses who are intending to be called by the defense were not listed by the defense as witnesses in this trial. Their names were not provided to the court. And further, at least as with Ms. Robinson, the rule of sequestration has been violated because she's been sitting through the course of the trial, and you all invoked the rule of sequestration. Again, I realize that violating the rule of sequestration in and of itself is not sufficient for the exclusion of a witness. I'm looking at this in the totality. And again, I just go back to the issue, Ms. Kawas, with all due respect, of the defense being surprised to be admissible by Mr. Robinson. from all of these circuits is abundantly clear, and I will give you time if you need to read them. I don't want you to be on the fly about them, but I would think that from the Third Circuit, y'all's circuit, or the Second, or the Fourth, or the Fifth, y'all would be familiar that witnesses who have a specialized knowledge of the subject can opine about that witness's identification. And further, the appellate courts have specifically said that the state may introduce such identification testimony when a video does not provide clear images of the perpetrator. That's especially when it's most important, assuming the predicate is laid. And in this case, the state asked Mr. Robinson, and he testified that he'd been living with his son, that he had seen his son walk. He has been with him through other times. Admittedly, he served 10 years in federal prison sometime in the 90s based on another a conviction of his. So yes, he admits he was absent for 10 years, but otherwise, at least according to his testimony, if it is to be believed, to lay the predicate for the admissibility of his identification, the predicate was established. I understand you now want to call two witnesses that were not listed to look at that same video and say, no, that's not him. And so my question is, why couldn't you, separate and apart from Mr. Abdul Robinson Sr.'s testimony, have done similarly? Listed them, anticipated that you wanted to call them. Why now, in the middle of trial, after the state's closed and after JOA, are you now thinking, let me call two witnesses, Mr. Shipes from New York and Mr. Robinson's sister, to now look at the video that everyone has had for 5 years and say, no, that's not him? Yes, it is. Do you have a case law rule or statute that says that rebuttal witnesses don't have to be listed?
Judge, I'm relying on the cases that I have where it specifically indicates that not listing a case I sent you, Judge, was an alibi witness where the rule requires that that witness should be listed 15 days prior to trial. Was listed falsely as I was before he was called to testify, and he was allowed to testify.
Okay, well, all facts are different. I'm going by Ratliff versus State, 561 Southern 2nd, 1276, that holds that rebuttal witnesses are not accepted from the requirements of Florida Rule of Criminal Procedure 3.220.
And Judge, in response to that is, I can't know who I'm going to exactly deem a rebuttal witness until I see what they put on. We are in a different posture than the state of Florida. We have zero verdict. This is a criminal case. I have no idea what they're going to do. They are at liberty to put on which witnesses they want and prove the case whatever they want, but they also have an obligation to do a full investigation. They were on notice of Shipes from years ago. They are also on
So does that then remove the need for the defense to list witnesses?
No, Judge, this is a unique circumstance, I'm just taking it by step by step by step. If there was a witnesses that we could have just rested, just like Mr. Wisco, but we don't know who were, I didn't have any clue that they were going to fail to call half of the eyewitnesses in this case. So we had to now push on our case and call those witnesses. They didn't tell us who they weren't calling. They would just tell us, oh, the next day we're calling this person. Don't call Raekwon Howard. Don't call Tara Williams. Don't call Shakira Smith. None of those witnesses were called.
Are they obligated to tell you who they're not going to call as a witness?
They're not, but Judge, I am obligated to tell them when I know I'm going to call someone. And I found out the moment that that witness entered that evidence, and frankly speaking, as to Mr. Robinson, I was just talking to all of the family members yesterday to see which one. That's the reason I got today. But Miss Robinson is someone that's within their control, not within their control, but someone that they were aware of. The wife and Paula that senior spoke about, it's her car. My daughter's car, that's her car. So that's someone that they were aware of at first-hand knowledge as it relates to this case. The fact that you only go to one family member and ask his opinion whether or not that's his son, that's on them for lack of investigation. However, we are here now, Judge, and they have been on notice. For them to now come in here as to Mr. Shanks and say, well, we could have accomplished that over the weekend when we put you on notice when that testimony came up. As it relates to Ms. Robinson, she's outside, you can speak to her. The very narrow area of where I'm planning to ask her about the fact that she knows. I'm not too sure what other investigation, what you're going to show her 800 other videos of a covered up Hakeem Robinson to ask if that's him too?
They're entitled to ask whatever the questions they want in deposition. It's discovery purposes. This is what we're going to do, because it's now 9:40, and we have to do this test run with Ms. Ahmad, who's in the country of Jordan, I'm going to ask the state, well, first, we're going to call Ms. Jordan, or the defense is going to call Jordan, Graham, and Gibson. Then we're going to take a recess, and I'm going to ask the state to make its best efforts at deposing these two witnesses. Ask whatever questions you want to ask of them, take however long you want to take with them. We will have to recess these two juries. They will just be sitting in their jury rooms waiting. And then let me hear from you. If you have obtained whatever sufficient information you think you have, I'll hear further argument on prejudice, and then I'll make my decision. But I think we should at least take this first step of you talking to them, deposing them under oath, and doing whatever else you think you need to do to be prepared to question them should I allow them to testify. But so far, we've now wasted not 40 minutes of this jury's time. Let's do this Zoom test with Ms. Ahmad, and then let's get started with trial, at least with these first three witnesses for whom there are no issues.
Can Your Honor, one of the defense counsel step out with me while I...
Okay. All right. Do we have Mike here? Who is doing the test run with Ms. Jordan?
Your Honor, I haven't heard from Jordan yet.
Oh, were they going to be calling in at 9:30?
We're reaching out to Mr. Chris or ourselves.
Okay. Mr. DeCoste, have you gotten any type of call from Ms. Ahmad and Jordan? Okay. All right. Well, then I guess no test run on her.
So, Your Honor, again, in those, there was an asterisk next to Ms. Ahmad and Gibson based on Graham's testimony.
So you want to call Graham first?
Please, yes.
Okay. And who, Mr. Mizrahi, or do you need to be in court? Are you going to be out of court? I mean,
Those witnesses are being handled by Mr. Atkinson and Mr. Cooper, so I can step out and talk to...
well, no, I want to do it however y'all want.
I need to find stuff.
I understand. Go ahead and get whatever you need.
appear to be at risk. If she was, I would have brought her onto the bus. Just dragged the mom at screaming.
All right, so Beta wants a little synopsis on what happened this morning. So basically, on yesterday, the defense after. Okay, so yesterday during testimony, the defense before lunch, the defense basically said that they wanted to call some witnesses to kind of impeach or rebut against Senior's testimony. And the judge was basically like, you should have already disclosed who your witnesses were going to be before your case in chief, etc. So she then said that she was going to take the ruling under advisement, and for them to go and get them some case law. So today, it sounds like the defense has added another witness and added them late at night, and so they were just basically arguing about if those people, which is one is Ksoo's daughter and his mother, and I believe the role manager too, or the manager too, if they were going to be able to testify. And so she basically is going to give the state an opportunity to depose a couple of the witnesses that was brought up, and then she's going to make a decision on if they're going to be able to testify or not. CB, I'm not going to argue with you today. I'm not, because the way that it works and the way that jurors work and what they are told is that it is 100% their decision on which evidence they choose to use and which they don't. They are the fact finders. So as a 13th juror, you should understand that if you were in a jury room, everybody in that room is not going to weigh the evidence as you would. I don't think that Ksoo was the shooter. I don't. And there's nothing that you can say or point out from this case that will make me think that. So like I said, I'm not considering Ksoo's father pointing him out as evidence, because I think he's a liar and he's got more motive to say whatever the state wants him to say than to tell the truth. He does not know what Ksoo looked like that day. He testified himself that he hadn't even seen him all that day. So yeah, I'm not weighing it and I'm not arguing about it. So take your opinion and go do with it as you will. So we're going to jump back over to the Ali trial closing and see if or how they do it over there on Verdict Watch.
And crying. She didn't get in my way. She didn't impede. Elijah, I didn't see the adult females. Eric, she just looked like she was watching from the looks of it. Caleb, question. Did you see Zara Ali attempt to get people to stop punching her husband in the head? Not that I'm aware. Athena, the person whose arm was under the neck and the person yelling, my husband, do you know who that was? I'm not sure anymore. Now, what's interesting is in the state's closing argument, they said that I asked a confusing question and I was the one that elicited that response. I actually watched it last night and went back to it. It was actually on redirect from Ms. Zoe. And if you can all look at your notes and see, when she expressed her confusion, it was in response to a state's question, not the defense. No appear point. She appeared to have her arms wrapped around her upper torso.
All right, sir, if you'll come forward and be sworn. All right, so if you'll sit closely to those microphones and be sure to speak loudly and clearly into them. Thank you.
Yes, ma'am.
You may proceed.
Thank you, Your Honor. Good morning.
Good morning.
If you could introduce yourself to the two juries.
My name is Tim Graham.
Yeah. Sir, back in January of 2020, were you working for the Jacksonville Sheriff's Office?
Yes, I was.
What was your position?
I was a police officer.
Around that time, were you training other police officers?
Yes, I was.
Specifically on January 15th, 2020, were you training a recruit?
Yes, I was.
Do you remember his or her name?
Prater.
Do all police officers train recruits?
No, sir.
You were tasked with training?
Yes.
Was Officer Prater fresh out of the academy?
I don't remember if he was fresh, but maybe a couple months out.
Does the academy include physical training?
Yes.
Was Officer Prater, in your opinion, fit at that time?
I believe so.
Now, turning your attention specifically to January 15th, 2020, was there a point in time when you responded to a call that was being dealt with by a former colleague, Jimmy Collins?
Yes, sir.
You could explain to the juries what transpired.
Officer Collins put out a call, shots fired at shopping center at Maryland Townsend. He was in a vehicle pursuit. We responded southbound on Townsend. Officer Collins got into a pursuit on foot. We got to that location near the 900 block of Townsend. We saw Officer Collins pointing in the direction west of Townsend near Carlotta of a male subject running west. We started to drive towards Carlotta and we saw a male subject running.
Now, I want to make sure for the jury that we have the reference. So we'll use it north, east, south, west, okay?
Yes, sir.
Townsend pretty much runs directly north to south.
That's correct.
And Carlotta, is that west or east of Townsend?
Well, yes, sir. It runs east and west, west and east. Yes, sir.
The area that you responded to, was it west of Townsend?
It was west of Townsend. Yes, sir.
And so I'm going to have you pick it up in what you were explaining to the jury. You and Officer Prater in your vehicle respond west and see somebody.
Yes, we saw a male subject running.
What was the distance?
We saw the male subject running from our vehicle.
The closest that you saw this male subject running that morning, how far?
50 to 75 yards.
Using this courtroom, how far would you say? If you could estimate it.
The closest we got was to the door once we closed the gap. But the first initial time that we saw him was past the courtroom.
We're talking about the closest you ever got. The closest you ever got was 50 yards?
The closest we got was 50 yards.
Estimate. All right. Can you use this courtroom? Would that be from that corner to that corner?
If that's 50 yards, possibly.
Do you think?
Possibly.
All right. But you were able to see this person?
From the backside. I never saw the front of the subject.
You were able to observe that person's movements?
Yeah, he was running.
Yeah. And from that person's movements, were you able to make any assessment as to his physical fitness, his or her physical fitness?
I don't understand your question.
Did you see this person jump a couple of fences?
Absolutely.
He was able to evade Officer Prater?
And me.
No. As you're responding and viewing this person, did you call out over the radio a description of what you saw?
Yes, sir, I did.
Do you remember what that description was?
Yes, sir.
If you could please tell the jury what that description was.
He was approximately 5'8" to 5'10", black male, wearing a black.
I'm sorry to interrupt. Can everyone in the audience please make sure that your electronic devices are turned off? Thank you. You may proceed.
Yes, ma'am. Black male, I believe it was a gray shirt with black sleeves and black pants.
Tried to chase him on foot, right?
We tried to chase him on foot, and we were in the car initially when we saw him. So
Was this person that was jumping fences, that was 5'8" to 5'10", were they able to evade you?
yes, sir. Yeah, he did.
Now, the build on this person,
Yes, sir.
do you remember giving a description on the build?
I don't think I did it over the radio, but I think I've previously testified to that.
Do you remember the build of the person that you saw?
Yes, sir.
And what was the build of the person? Were they very fit?
I'm sorry.
Very fit?
I would say fit, yeah, medium build.
Would you say, quote unquote, very fit?
I guess so, yes, sir.
Would it refresh your recollection to take a look at the deposition?
Yes, sir.
Council, pages 87. Your Honor, may I approach?
Yes.
Mr. Graham, you can just take a look at this. Starting line 14.
Okay, very fit. Yep.
You just said a moment ago, I want to make sure that it goes with the question. Would you describe the person as very fit?
It says very fit, and before that it says rather fit too.
So very fit, right? And again, I'm not here to put words in your mouth. The person that you saw was rather fit, very fit. They were fit,
They were fit.
fit enough to outrun you.
Fit enough to jump fences. Yes, sir.
Did you author a report in this case?
Yes, sir, I did.
Before you retired from the force, you're no longer on the force now?
I retired in October of 24. Yes, sir.
All right. So the purpose of police reports, are they to make sure that the knowledge that you obtain at that time is memorialized for the future?
Yes, sir.
Was there anything in there that you remember where you say 5'8", 5'10", fit, jumping fences, but I'm not sure? Did you equivocate in any way?
No, sir. Not that I recall. I mean, it's been 5 years, sir.
Would it refresh your recollection? Take a look at the report?
I looked at the report already, sir.
All right. So was there anything in there in your testimony where you're saying to this jury, look, I gave that description, but I'm not sure?
Sir, I could have been wrong on the height. He could have been 6'2", 6'4". He was running.
But on that day when you wrote the report, you wrote it and that's what you believed it to be, right?
I believed it to be. He could have been 5'4", but he was running.
And regardless of the height, regardless of the weight, it was somebody that was fit enough to be jumping fences and evading.
Absolutely. Yes, sir.
All right. One brief moment, Your Honor.
Okay.
Nothing further, Your Honor. Thank you.
All right, cross-exam.
Officer Graham, you were with the sheriff's office for a long time.
24 years. Yes, sir.
Wrote a lot of reports.
Yes, sir.
In your reports, is it like a diary where you write your emotions and your feelings about how you feel about something?
No, sir.
It's your best effort to write in a short narrative what you observed.
That's correct, sir.
Okay. And when you saw the suspect for the first time, you were still in your police car,
That is correct.
and so was Officer Prater.
That is correct.
And you said that the suspect, at best, you got 50 yards in distance. At worst, when you first saw him, you were 75 yards away.
That's an estimate. Yes, sir.
Okay. And you don't believe that you ever got a good look at this person?
The whole time, correct. It was from the backside.
Okay. At all times, this person was running away from you.
That's correct. Yes,
It
sir.
was in a crouched running motion.
That is correct.
People run standing straight up.
They could, but this person was running away.
Okay.
So,
They're trying to run away from the police.
that is correct.
They're in full sprint.
Yes, sir.
Okay. You said his back is towards you at all times.
That is correct.
So you never saw him from the side or anything like that.
No, sir.
You said that he jumped a fence.
2 fences.
So by the time that you get to the first fence, he's already in the process of jumping the second fence.
That's correct.
So again, at all times that you're seeing this person, he is running away from you and is either in running motion or is jumping a fence.
That is correct.
And you described this person as not slim,
That's correct.
not skinny.
That's correct.
You said that he was repeatedly told defense attorneys he was medium build.
That's correct.
Okay, if you'll rephrase your question.
You repeatedly said that he was medium build.
Yes, sir.
Overruled.
At the defense counsel asked you on direct examination that he was very fit. He was wearing a tracksuit, so you couldn't see what his muscular tone was.
No, sir, I could not.
In fact, you said that he did not look like a person who always lifted weights.
That is correct.
You described him as a person who didn't look like he ever missed a meal.
That is correct.
I don't have any other questions.
All right. Any questions from for Mr. Whitaker? No, Your Honor. Thank you. Any redirect?
Yes, Your Honor. So, Mr. Graham, what you're saying is he didn't look like a malnourished person.
That is correct.
Now, you as a police officer, when you're giving a description, you're giving it so that your colleagues can help find the person, right?
I'm not a police officer anymore.
When you were.
That's correct.
All right. Because this person, this shooter, is running through neighborhoods, and that could be a threat to all of the residents of Duval County.
Absolutely.
All right. So when you're giving the description, you're taking into consideration, you as a trained police officer, things like the fact that the guy was running, right?
Yes, sir.
You didn't say, you know, it could be a taller guy, but he was crouched. You gave your best estimate at the time.
Did the best I could, sir. Yes, sir.
Yes. And you also had points of reference, like the fences, right? You saw this person run, approach a fence, and jump over.
It's 75, 50 yards. Yes, sir.
I understand that, but you saw the point of reference, right?
Sir, I did.
And you took all of that, the totality of the circumstances, to come back to your best estimate. You didn't say specifically a height. You said 5'8" to 5'10", right?
Yes. Yes, sir.
Thank you, Your Honor. Nothing further.
All right, may this witness be excused?
Yes, Your Honor.
All right, thank you, sir. You are excused and free to go. All right, you may call your next witness.
Your Honor, our next witness is
Who's 5'8" then? So Jamie Reed, that's the initial description that they gave. Literally yesterday when I was looking through the transcript, they were looking for someone between the height of what did I tell y'all? Let me go back and look at it. Between the height of 5'5" and 5'8" for months. And when they found Ksoo, they was like, oh, you are much bigger than what I thought. Like everybody literally thought that the person was short, 5'5" to 5'8". Like that's a huge, in my opinion, that's a huge. Okay, we got ambulance rolling through here. Just kind of scared me. Huge difference.
All right, let me look at the exhibit and let me clarify when you say present sense impressions, and that, since that is not an exception to hearsay, which of the three are you talking about? Number one, spontaneous statement. Number two, excited utterance. Or number three, then existing mental, emotional, or physical condition?
So I would go, one brief moment, Jeremy,
Okay.
pull up the note. Your Honor, I pause because humbly, I would disagree that present sense impression is not a hearsay exception. It would also fall with an excited utterance because both of them testified that they're calling out over the radio while they're chasing somebody and going through that adrenaline of chasing somebody. So I would say that it could also fall within the parameters of excited utterance.
I'll have to look up my notes on Officer Collins, but I don't recall former Officer Graham testifying to that. That wasn't asked of him.
I just asked him, Your Honor, that, and I'm happy to recall him, I can text him and bring him back in, that he receives a call out in the radio, and contemporaneous to that, we all know that the officers are conveying information on the radio, and the information that Your Honor will see from these CAD notes is exactly what he just testified to. And those are the only two officers that witnessed somebody in that area.
I understand. I'm just trying to understand which of the hearsay exceptions you believe the CAD notes fall under, because of course they are hearsay, because those CAD notes are an out-of-court statement offered to prove the truth of the matter asserted. But if it fits under one of the numerous exceptions under 90.803, that's what I'm trying to specifically understand. So you're saying excited utterance, subsection 2, and you're saying public record under subsection 8 or some other subsection? Tell me what is your argument as to why the CAD report should come in, under what exception to hearsay, so I can appropriately rule.
So we would say for the purpose of authentication, we've laid the predicate for business record. That was done through Smith. As for the hearsay exception, it would be twofold. I believe that it falls within present sense impression, being an exception to hearsay in the state of Florida, in the event that that
Which
is...
subsection under the statute is that?
Oh, give me a second to pull that up then.
Okay.
And Your Honor, if you want me to, while I'm pulling that up, I can publish to you what's in the CAD notes.
That'd be great.
Great. I'm getting better, AJ. Yeah. So, Your Honor, right here, 5686, they put in the badge number of Collins, which the state brought out in their direct. And that is 100% consistent with what he stated, 55 to 59, west from Townsend.
So this is a 53-page document. Are you redacting portions of it? Because it includes more than just these two officers.
Correct. I could either redact, or if it's done, the same way that we would do a stipulation, that there was call action detailed notes stating just this. I mean, I could do it in its separate memo. The other statement, which is consistent with Graham, black male, gray sweatshirt, black sweats, 5'8" to 5'10", westbound on West Lawn, last seen jumping fences.
How do we know those statements are from those officers? Because it's not identified on this CAD report.
On the first one, it is.
Let me see, go back up there.
5686 is Collins's badge number,
How do we know that?
because he testified to it on direct examination.
He gave his badge number?
Right, literally the first question was asking his badge number. I was surprised. It saved me a question, but it was brought out.
Okay.
Five, 686 is his badge number. Literally, if Your Honor goes back, literally, he gets up there, Jimmy Collins, badge number 5686.
All right. And all right, so let me go back to your request for admissibility under what particular exception?
Your Honor, I'm pulling that up now so that I can give you the specific number.
Okay.
803.1 and 2, I believe.
So spontaneous statement and excited utterance.
Yeah, I'll use my computer, it'll be faster. Yes, Your Honor. So I'd go with Florida Statute 90-803-1, which allows for the admission of a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. And I don't, the only times that it would be inadmissible is if it lacked trustworthiness, but the cumulative evidence in this case between their testimony of what they stated, the reports that support it, there's no question that it's trustworthy.
All right, so those two exceptions, so not business records.
No, Your Honor, we'd move to admit it of those two in conjunction.
I'm sorry, in conjunction with what? With business records?
Together, yes.
Okay.
We add in the business record exception given the fact that that also goes to authenticity because the government's stating that it may not be accurate, but we know from Officer Smith, and I did ask the questions, the predicate for business record.
And let me ask about this. Were those records obtained with a business certification?
Yes.
Okay.
That it was provided by the state to me, I can show it to them. Specifically for there's digits at the top of all the cat notes, and it was authored for, like at the top it says, JSO 200115000343354. The business record certification we have specifically has that in the title, and then on the left-hand column has all the other CAD notes that were provided.
Is it a certification, though, that comports with 90.902 subsection 11? In other words, signed under oath by the custodian of records? The typical business certification that one must have to enter any kind of business records.
Yes, Your Honor, I can put it on the overhead.
Okay.
So if Your Honor sees, and I've got two of the documents up here, the 34354. Put them side by side.
All right, and last question then. How do I, what's the word I'm looking for? As you know, typically, police reports are inadmissible in evidence. They contain inadmissible hearsay, and indeed, in 90.803 in particular, with reference to these public records and reports in subsection 8, it says that it is excluded in criminal cases matters observed by a police officer or other law enforcement personnel. How do I jive those two provisions when police reports in and of themselves are not admissible in a criminal trial?
Your Honor, it's twofold. First, the call action detail notes are made in the moment. Officers can write reports much later in time. But more importantly, The second point, that reports are created in anticipation of litigation, whereas call action detail notes are made in the moment. I think the fear was it was a two-edged sword that they were concerned about, that officers could create documents to strengthen a case because you can do a report. I mean, sometimes the reports are months, years later, whereas the call action detail notes, they only happen in the moment. You can't go back and change it later.
All right, so then I'll hear any further argument from the state. Otherwise, I'm going to go ahead and rule on this exhibit.
Your Honor, the only thing I can add, similar to a 911 call or body cam.
Okay. So the 55-page exhibit obviously cannot be moved in to its entirety because it contains other statements by other individuals whom we don't know and who have not testified here today. So that would be an admissible hearsay. I will allow the first one that is identified by Officer Townsend's badge number. I honestly don't recall that he gave his badge number, but I'm going to take your word for it.
Collins, not Townsend.
Oh, Collins, excuse me, right. Talking about Townsend Road, getting the names mixed up. The second one is unidentified as to who said it, so I'm not going to allow the second statement because it doesn't show in the record who made that statement. So we don't know. But the first one, if identified as Officer Collins's, I will allow you to excise just that line out of the entirety of the 55-page document, and you can move that in to evidence on an exhibit if you have it.
So let Your Honor know, and I do have it, it's already up there, but what I could do is this, where the first page I black out pretty much everything except the information that shows that it's CAD notes, delete out all the other pages, and just have that 1 second page and black out everything on that page. I think it's better than blacking out 50 pages.
I agree. I mean, State, I understand you object to this exhibit coming in, but knowing my ruling and as explained, are you acceptable with that? Okay. So if you will make just the 1 page with everything blacked out other than Officer Collins's description given at the moment. All right. All right, so we will just await. Is Mr. Mizrahi deposing the witnesses outside? What's happening?
Mr. Mizrahi, in my presence, was able to speak to Ms. Robinson and complete that one. So we're now trying to actually get any Mr. Nichols' assistance to get Mr. Scheitz just on the phone. They're just doing it on the phone in the side room.
And what's the time frame for him? I know he's in Europe. Where in Europe? What's the hour delay?
Your Honor, I think he came back just recently from Europe, so now he's in New York.
Oh,
That shouldn't be an issue.
okay.
I spoke to him yesterday, he had just come back. I believe he's in New York.
All right.
So, and that other didn't take too long.
And just from clarity of record on the issue of the CAD report, since 3 hearsay exceptions were delineated, and so the appellate court knows my ruling. As for spontaneous statement, I will allow it. As for excited utterance, I will not. There was no testimony from Officer Collins establishing excited utterance. And for business records, I'll allow it. So that's why I'm allowing it with the edits that I have already described.
Your Honor, understanding that we have the jury waiting, I'll make sure that very quickly, can you step up so I can make that call?
Yes.
And then just right when back, I'll edit that document. It should only take me minutes.
And that's going to be what, defendants 2, 4, what number? Okay, we don't have a defendants 2. I just want you all to know we've skipped. We have defendants 1, which is the photo of Chris Brown, and defendants 3, which is the video from January 14.
Correct. Defense 2 was a disc that was CAD notes, but it's unedited. So I don't know if we just leave it as 2.
Not if it's going, I mean, if you want to make it part of a court exhibit for appellate purposes, that's fine, but let's not confuse the numbers for the jury. I mean, I'll let you number it, I guess, how you want.
We'll do 4, and then that one, at least it's in the record, the other note that we were trying to get in.
You mean the 53 pages?
That's what's on the disc.
Okay.
Unfortunately, I can't rewrite the disc once it's written, but I'll put together the other document.
All right, so for the record, defendants 2, which is not, let's call it not a number. The numbered exhibits are evidence, lettered exhibits are for identification. So we can call this defendants A for identification. So the record is clear. It is the complete 53-page CAD notes that are not being moved into evidence, correct?
Correct.
All right. Or however many pages, 52, 53?
I believe 53 exactly.
Okay. All right, well, if any of the court staff need a recess, we'll take this time to be in recess while we do these things. Thank you.
Thank you, Your Honor.
The only person who said that she saw my client strangling her daughter was Zayla Carter. Now, that's interesting because what I want to do, I'm going to rewind, and I want you to remember Zayla Carter. In all black, she's got the beige backpack. And what she's really doing is trying to manage Isaiah. She intervenes when he is yelling at Haneen, pulling him away, getting him away from Haneen. She then walks around and walks towards the front, comes back, and then when she sees Isaiah go hands-on with my client, she then intervenes. So you tell me, or you decide for yourselves, as to whether she's actually paying attention to what's happening. So I will go back all the way to the point of where my client and Josh Wagner. Now remember how long my client is standing up before she's even down on the ground with her daughter.
You need to get the time, please.
Yep. Thank you, Your Honor. It is 2:13:58 hitting play. So there you see Ms. Carter dive into the pack. In front of the bus driver. She's standing over in the far left, behind Isaiah. Haneen starts filming. Isaiah begins to attempt to punch. She pulls Isaiah back at 2:14:37. She's holding on to Isaiah. Isaiah disengages from Haneen. She's having a spirited conversation with Haneen. She then walks away. Back to the whole incident. She then confronts Haneen again, starts pushing her, pointing, turns to her right, looks to her left. Stopping at 2:15:30. I wasn't watching at all. I mean, I don't blame her. There's a lot going on. She's taking care of Isaiah. Haneen is arguing back and forth with her. State also relies on Mary Wagner. This wasn't intentional. I just happened to stop it at 2:15:30. She has now decided to run across the street and start, saying, "Hey guys, knock it off." Everybody who was around there, nobody said that they saw my client strangling. They said, "Yeah, I saw her grabbing her, saw her holding her." Her daughter to the police at the hospital that night. My mom was holding me. I was in pain. I had just woken up. I was confused. I tried to speak, but words couldn't come out. My voice was raspy. I wanted my mom to let go of me. I was in pain. She wasn't trying to hurt me. She was protecting me from the chaos. I can't imagine an attempted murder charge where the alleged victim is telling law enforcement that night, I don't think the person's trying to hurt me. There was chaos. I had just been rendered unconscious from a previous struggle that my mom wasn't involved in. So let's take a walk through the jury instructions. I will be the first to acknowledge, or maybe not even the first to acknowledge, that there is a lot here, okay? Even as somebody who's been doing this, state, defense, the court, there's a lot to this. And the court instructed you that every single instruction matters. There's no one instruction that's more important than the other. Many of the instructions refer to other instructions. A couple of trials ago, I described this as a book, which I think is helpful. If you think of this as kind of, when you read a book, there's an introduction, right? Instruction number 1, it's your duty to decide the facts in this case based on the evidence presented to you during this trial, right? So that's the introduction. Judge talking about her role. I'm not ever intended to comment on the evidence. If you think I did, don't do that. I don't take that way. How you evaluate evidence, how you assess credibility, lawyers' remarks, objections, evidence. So that really kind of like, okay, basic stuff. So then we talk about jury instruction number 2. As jurors, here's your job. Your duty is to discuss. Number 3, every charge is different, and not a verdict on one charge determines the verdict on the other. Instruction number 4, reasonable doubt. Okay? Everything has its place. So then we get to around 13. We talk about accomplice liability, and then the first one is a 2 convict instruction for Mr. Ali, and that's 15. Okay. So if you're taking notes, you can take notes or you don't have to. But there are 5 2 convict instructions for my client. Attempted murder in the second degree, 2 convict is instruction 16. The assault 2 is instruction 30. Unlawful imprisonment is instruction 35. And I'm going to walk us through some of these. Burglary in the second degree is 46. And violation of the court order is 48. And so we often spend a lot of time talking about those because that is the ultimate roadmap for you as to how you decide, in order, has the state proven beyond a reasonable doubt the following elements? And then it refers to other instructions. So then you get to the end, and then it kind of is a concluding instruction, and it tells you, okay, here's how you deliberate. Select a presiding juror, kind of the order in which you consider things, when you do a special verdict, when you consider a lesser, okay? Now, there will be times where I can imagine a juror saying, well, what about this? The answer to that question, if there is an answer, is somewhere in here, okay? You have every right to ask the court a question and say, as the foreperson would write the question and say, you're asked the following information. And as Ms. Doan alluded to, we are very limited in the ability to answer those questions. I'm not saying you're not going to get an answer, but very often it will be, please refer back to your instructions, because we have to be careful to not influence your process and give undue attention to a certain instruction. Or if there's a mistake, it will often be clarified. But if you get a response to say, please refer to your instruction, the answer is somewhere in there. And maybe it's unsatisfying, but that's kind of how this works. Okay, so I want to be conscious of time, so I'm going to kind of walk through the 2 convict instructions. Turning to 16, which is attempted murder in the second degree for my client. Okay. Now, if there is a reasonable doubt as to any of these elements, you're up. The state hasn't established beyond a reasonable doubt. And Mr. Kading talked about it a little bit, but the reasonable doubt instruction is instruction number 4. You don't need to turn to it, but I'll just tell you. So that's where it talks about the presumption of innocence. The state has the burden. A reasonable doubt is a doubt, can be singular, for which a reason exists. Okay? So it's not just some doubt that's made up in thin air. You have a reason for it. And your reason can arise from the evidence, testimony, exhibits, or the lack of evidence. Well, how come we didn't hear from this person? We weren't given this, okay? So the question is, if you have a reasonable doubt, the state hasn't satisfied its burden. Now, as a principal or accomplice, did she take a substantial step toward the commission of murder in the second degree? Instruction number 11 defines substantial steps. Conduct strongly indicates a criminal purpose. So when she walked up there, was she acting as an accomplice? (13) defines accomplice. Did she aid? More than mere presence and knowledge of criminal activity of another must be shown to establish that a person present is an accomplice. She didn't solicit, she didn't command, she didn't encourage, she didn't request her husband to commit murder in the second degree. Did she aid or agree to aid in his attempt to murder his daughter? Well, the state has acknowledged that there was no plan. Mr. Ali didn't arrive there with the intent to murder his daughter. So, in the seconds that she walked up there, after seeing her husband being punched, she said to the officers, "I saw that." As she approached, her husband's on the ground, her daughter's on the other side, there's kids in between. Mr. Wagner, coming from the other direction, had a clear view of Fatima. The state would have you believe that in those mere seconds, that she formed the intent to say, "Wow, I'm going to help my husband kill my daughter," by kind of standing around, trying to push Isaiah off, who had just been punching her husband in the head. Or that she, while she's holding her daughter, crying, my daughter," in a voice that Fatima described as sad, and told the police that she was trying to protect her from the chaos. In the state's eyes, that's attempted murder. Ladies and gentlemen, this is why we have juries. It's not her decision. It's not the court's decision. It's not my decision. It's your decision. It's your responsibility to hold the state to its burden, that we start from a presumption of innocence. Constitutionally, we walk in this door and we say that my client has not done anything. What did she do? She ran across a parking lot, through a crowd of kids, said that she could see her husband being punched, not 30 times, not 40 times, towards the end, stood there, as we saw in the video when it zoomed in, kind of with Mr. Wagner. Wagner goes in, frees his daughter. If that's attempted murder, we're all in trouble. The mother going to the aid of her daughter, checking on her husband, who a mob has surrounded and kicked repeatedly and beat, and there's no evidence that she could actually see her face from where she was standing, that in those seconds it's attempted murder, submit that it's not. Next is the assault suit. Instruction 30. State has to prove. On or about October 18, 2024, the defendant, Zara Ali, intentionally assaulted her daughter by strangulation. Isaiah Williams. Her arm was around her neck and around the upper chest. Would you describe it as up against her neck? No, sir. Are you concerned about what you saw previously was potentially going to happen again? Absolutely. And that's why you intervened. Not because she was being strangled, but you wanted to break her free and you were worried about her. Instruction 35, unlawful imprisonment. Did mom substantially interfere with the liberty of her daughter? That the restraint was without legal authority, and that the defendant knew such restraint was without legal authority. We revert back to instruction 21. And that is the parental discipline. Discipline isn't really, I think, an appropriate term, because you think of it in terms of somebody who's been bad. But in terms of basically when do you get to hold your child? So physical discipline of a child is lawful when it is reasonable and moderate. And it is inflicted by parents for the purposes of restraining or correcting a child. She's not trying to correct her. I don't even know she's really trying to restrain her. I think she described that, Fatima described her mom's actions perfectly. She was trying to protect me from the chaos. Wailing, my daughter, that seems to run entirely counter to criminal intent, acting unlawfully. The defendant knew that such restraint was without legal authority. Okay, I want to turn to the burglary. And I know I'm going fast, but you guys have been sitting here all day, and I want to be respectful of your time. Okay. Front page of the instructions. State of Washington versus Zara Ali in the case number. Okay? This isn't Fatima Ali versus Zara Ali. Daughter doesn't bring charges. This isn't Timberline High School, North Thurston School District versus Zara Ali. This is the state of Washington, as represented by these two prosecutors, okay? This is the state that is electing to bring the charges, and they are the ones choosing to bring the charges, okay? There are two, we heard about the no contact or the trespass order that was issued by the vice principal. We can question all day the wisdom of that order, but that order was in place, right? In response to School Resource Officer Howard, I was there basically as a show of force. I handed her the letter, said you can't come to school. She appeared to understand that she couldn't come to school. Okay. And the letter, which you have in evidence, says you could be charged with criminal trespass if you violate this order. If we were here talking about count 4, defendant Zara Ali is charged with the crime of criminal trespass, I'd be like, yeah. The state has proved beyond a reasonable doubt that she's guilty of trespass. But that's not what they chose to do. They chose to try to, for whatever reason, go for more.
Objection. Sustained.
So they didn't charge criminal trespass. They're charging burglary. So criminal trespass is the first piece. I can see. She didn't have permission to be in the school. The second piece is that her entering the school or remaining at the school was done with the intent to commit a crime against a person or property therein. Okay? State in their closing said, okay, there's 3 potential crimes that she could have committed while she was there. She could have run in to try to assault her daughter. Really? Do we really think that she was running in there to assault her daughter? The woman who was holding her, protecting her from the chaos, is then going to run into the school and assault her. Isaiah. Maybe she was trying to assault Isaiah. She had no interest in Isaiah. Haneen was upset with Isaiah. You saw her interacting with Isaiah a ton in this melee. She was upset. There was pushing. There was a threat to punch by Isaiah. That was she didn't care about Isaiah. Her intent to go into that school was not to assault Isaiah. So then the only question is, the third option is a violation of the protection order. So this is where it gets interesting. The 2 convict for the violation of the court order in 48. You have the body-worn video, Exhibit 38, from the officer who handed the order to my client. You get to see, and this is the miracle of body-worn video, you get to see what she said. You don't have to rely on his interpretation. She's like, are you with the school? No, I'm not with the school. I'm not a school resource officer. What is this? Haneen comes and you can hear them talk in Arabic. State chose not to translate. They have it on video. They didn't bring in an interpreter to say what was being discussed. And she has questions. And he's just like, well, look, yeah, I know. So it just basically, it says, and this is what he's telling her. Don't contact him. Don't call him. Don't email. Don't stalk him. I don't even know if he said stalk, but he said, there's no mention of school. He never tells her school, never tells her 1,000 feet. And it's a little curious when state puts up the exhibit and says, oh, it's a really simple document. We know from Fatima, she says, yeah, mom speaks English, not nearly as well as dad. Does she read English? Nope. She gets handed a document, not written in Arabic, doesn't use a language line, doesn't say to Haneen, hey, look at paragraph 4 on page 4, whatever the number is, and make sure you understand that this could be bad if you go to the school 1,000 feet. None of that conversation happens. State, for whatever reason, never called Haneen to say, what conversation did you have with your mom? There is zero evidence. All that you can know is that she was said, don't have contact. So now we go back to the burglary. that the entering or remaining was with the intent to commit crime against a person or property therein. Did she run into that school to violate? I'm going to run into that school to violate with the intent to violate a protection order against Isaiah. She wasn't running in there to have contact with Isaiah. She was running in there. My daughter, I saw my daughter run in here. I had it on here, but you guys have it. You guys can watch the video from Timberline High School. She is in there for seconds. She runs in. You hear from the counselor. She gets in, closes the door. She could hear her yell, my daughter, where's my daughter? I know my daughter went in here. What does she do? She lingers for like 2 seconds, turns around, and walks out on her own. She wasn't being non-compliant. She then goes around to the other side. The principal's like, no, we don't know what he says, but we can kind of surmise. Like, no, go, can't be here, go. So in order to convict her of burglary, you have to conclude that she has the intent to commit a crime inside. Not that there was some order that she didn't understand written in English that said she couldn't be within 1,000 feet. That she had the intent to do something other than find out where her daughter is. You know, it's just interesting. Picking up themes. The state was constantly asking. She was more concerned about her husband. Really? She's holding her daughter. Her daughter gets ripped out of her hands by Isaiah. She runs, and she kind of shuffles towards the school. For somebody who's more concerned about her husband who has just been kicked, and she left him behind, goes to check on daughter, goes into the school. Where's my daughter? Where's my daughter? And the question is, well, did she ask her condition? Or she's trying to find her. So then we go to the final crime, the violation of the court order. Did she knowingly violate a restraint provision of the order prohibiting contact with protected? I'll be the first to confess, there's a 1,000-foot distance provision in there. That if she understood it, she violated it. She wasn't supposed to be there. What evidence is there that she understood it? You hand me a protection order, written in Arabic. I don't know what it says. What did she know? She knew that she couldn't call, she couldn't talk, she couldn't have contact with Isaiah. You watch that entire video. At no point does Isaiah say, I'm having a conversation with her. At no time does she reach out and try to have contact with Isaiah. Yeah, she was there. She stayed in the car. She stayed away. Daughter got in trouble. She ran over to her daughter. She went to the school to check on her daughter. She never talked to Isaiah. She never had any contact with him. Now, the state's going to be like, well, that's preposterous. Really? Is she there to have contact with Isaiah? She's there for her daughter. Sitting in that car, October 18th. She knows she's different. She's from a different country, speaks limited English, has limited success with navigating the school. She tried to do what was best for her daughter, tried to get her transferred to North Thurston. Couldn't imagine a scenario where her daughter went to school, was running away from a school that she could never even go to. She tried to get in-person school for her and was turned away. Went to the police, tried to get help, didn't work. Went to the school to try to intervene, wasn't told the condition of her daughter, wasn't allowed to see her daughter. Her husband was taken away. No idea that she would have to defend herself and her approach to her daughter and her approach to her husband, and that under a convoluted set of facts and allegations would be accused of attempted murder, assault in the second degree, and unlawful imprisonment. All because, as her daughter described, that she was trying to protect her from the killings. She went into the school to look after her. On the one hand, the prosecutor says she doesn't care about her, she cares more about her husband. But then when she runs into the school to check on her, she picks up an allegation of a fourth charge, a burglary. That could have been a criminal trespass, but no, we got to
Objection, Your Honor. Sustained.
has to defend herself against a burglary in the second degree charge. We talk about unconscious bias. My client is different. You can't allow yourself to look at her any differently and reach a decision because she's different. The decision has to be the same, whether or not her child grew up from kindergarten to junior year, played sports, was in the school. The mom was the head of the PTA. She was the head of the PTA. She did exactly like my client did. I don't think she would have been here. And that has to be concerning for each and every one of us. And that's what I love about our system. We have a presumption of innocence, and it is designed to safeguard, protect clients who may be different. To be a check on the government and to say, no, not this time and not this case. If you consider the facts, the circumstances, and the law, there is one verdict that applies for each and every one of the things. My client is not guilty. I think we can all agree that this is a tragedy, and we certainly could have done things differently, but that doesn't make this a crime. Again, I appreciate you being here.
Members of the jury, we're going to do a brief stand-up.
Over and over again what his client is thinking. You in fact have nothing about what his client is thinking. So you don't get to take that as evidence in any way. You get to look at his client's actions, her behaviors, and her statements, and you get to evaluate the evidence in this case based on that, not what Mr. Leary asserts to you his client is thinking during the course of this time. He says that this is her last chance to parent. That's what is probably happening on this day because they're getting ready to go to Iraq. I submit to you, this is in fact her last chance to isolate Fatima. You heard from Fatima, this wasn't just like, oh, you know, I'd rather go somewhere else, somewhere different. She had real fears about going back to Iraq. She had real fears about that. It was a one-way ticket. There was no intent or explanation or indication of return at that time. You heard her say, I'd been before and there were some things I liked about it, but mostly I did not feel safe. And when I have now been pulled from school, I am no longer around anyone. I've had my cell phone taken away. I can't communicate with anyone. I am at home where my parents can see me all the time. I don't have any adults to talk to. And now I'm going to a country where I don't feel safe. There might be family there, but as Fatima has demonstrated throughout this trial, and this evidence has demonstrated, those are not family members that support Fatima. That's not what she's expecting. And there is no return ticket to come home for a 17-year-old who has lived here for a long time. That was very concerning to her based on her own personal experiences, and she expressed that to you. There is, Mr. Leary referred to, going back to voir dire, the juror that talked about what his experience was with his runaway child. And let's be very clear, that's not evidence in this case. That's simply voir dire. But notably from that, at no point during his efforts to get his daughter home did you note that he said he strangled his child to do so. The evidence here is what has been presented to you from the witnesses and the testimony. Mrs. because of the evidence, not because of something different, because of the statements of witnesses, because the statements of the people that were present. He says, how could his client know? She just gets there. She has no idea. Yet every single other person that is present says it is obvious, immediately obvious. Not kind of obvious, no, I had to get around to a couple people to see. It is immediately obvious that this child is unconscious and being choked, but somehow mom is the one person of this whole thing that can't see it. She's the only one, she can only see what is happening to her husband, not to anyone else. When we talk about the kids who say they saw it, that's incorrect. Isaiah sees mom strangling with her arms around. She says she can't breathe, and that's part of why he in fact reaches down to help her. Athena specifically says mom has her around the neck and is pulling at her around the neck. When you go back and look at those exhibits, you'll see that in one of Noah's still shots, Fatima is sitting there and you can see mom's arms around her neck. Not in the same way dad's are, it's a different hold, but it is around her neck, and Fatima tells you she can't breathe. You will see also that at some point it looks like she's being pulled back and her leg is popping up because mom is in fact pulling on her. Athena said very clearly that mom is grabbing at her to get her, and it is overly aggressive. That was Athena's description of mom grabbing her by the neck. She says Fatima is flailing her arms around and mom puts her arms around her neck. She says ultimately when Mr. Leary was talking about confusing Athena, Miss Zos asked on redirect, you sound like you were confused. Because Mr. Leary, do you recall he went through second by second on the video with Athena and said, well, do you see it here? Well, do you see it here? Well, do you see it here? And Athena said, I know it was mom, but now that you show me the video, I can't see where mom is on the video, but I know what I saw in person and I know it was mom. But now I guess I'm confused. And Ms. Zoe came back on redirect and said, are you confused because you remember it being mom, but now you can't see the video specifically? Yes. So in fact, it was Mr. Leary that asked her second by second. But Athena Rich told you, in fact, that it was mom. And she was not confused about that. We heard Fatima say, I don't think she was trying to hurt me later at the hospital. But what she immediately says, and you heard Liz Robinson testify, that when she comes in, my dad was trying to kill me, my dad was trying to kill me, my mom was choking me. That's what Fatima reports to Liz Robinson, that's what Liz Robinson testifies to. And you remember when Fatima testified, she said, I didn't think she was trying to choke me at the time. And I said, Fatima, do you want to believe your mom is trying to kill you? Do you want to believe your mom is trying to strangle you? No, I don't. That is an absolutely reasonable response from a 17-year-old whose dad just strangled her into unconsciousness and a seizure. It is an absolutely reasonable response to want to believe that at least one of your parents is on your side. Absolutely reasonable. Doesn't mean that's what mom was doing. It means that that's what that child is hoping at her core, that there is a parent that is looking out for her. And that is not what happened on this day. Mom has just as long on scene as Josh Wagner. Mom actually has longer on scene as Josh Wagner to see what is happening. And when you look at that video, you see that she does not provide any aid at any time to her child. Zero aid. When she's standing there and counsel talks about her saying, my daughter, that is the explanation for, that's her expressing her concern. But at the time that that is actually happening, remember what is actually going on at that time. That is when Haneen and Isaiah and Zayla are having that confrontation, because Haneen comes in late. Haneen doesn't see anything that's happening. Wagner is already down, holding her dad down when Haneen gets there, and straight in puts the phone in Isaiah's face. And again, why is that? Because in this scenario, for this family, Isaiah is the bad guy. In every version of everything that you have heard, that complaint has been about Isaiah. So when defense counsel says, she doesn't care about Isaiah, she doesn't, whatever, he's whatever. That's not true at all. Every chance that she gets, Zara and Haneen provide information to law enforcement about how this is all Isaiah's fault. She says, go, go, go. He said, go, 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 and he took her. You know these people, they're rude. That's what she says. Those are their statements consistently. So this idea that somehow Isaiah doesn't matter, he's of no consequence, so she's not going in there to violate any orders or assault Isaiah or do anything to Isaiah. She absolutely is. She knows she's not supposed to be there. She knows she's not supposed to have contact. She just doesn't care because she does not like Isaiah. And she says that repeatedly. She says it to Officer Hang. She says it to Officer Bell. She says it to Officer Chavez over and over again. And keep in mind, this is the same Isaiah that in September, just 4 weeks prior, she's already had some kind of interaction with at the school that has gotten her trespassed in the first place. So we already know that she is in fact the focus. We know that she is the focus of Zara's behaviors and actions and ire. And this is an extension of that. And she thinks that he has Fatima and she's going to get him back from Isaiah. So during the course of that interaction then, when Haneen comes in and puts the phone in Isaiah's face, and all of a sudden, now, Zara is saying, my daughter. Who is she actually saying my daughter about? Is she saying my daughter about Fatima? Or is she saying my daughter about Haneen, who's in the middle of that interaction? We don't know. It could be either one of them. But her follow-on behaviors do not demonstrate this overwhelming concern for the condition of Fatima. It demonstrates a concern for getting her back as if she is a possession, because she wants to isolate her and control her. She doesn't want her talking to law enforcement. She doesn't want her making statements or any more statements about what is going on. When we look at her arrival at the school, how does she know to come running? According to Mr. Leary, she arrives at the school. She hasn't seen any kind of conflict happening. So presumably, Dad has called her and said, hey, I see her. She's here with Isaiah. She's at the bus stop. I'm going to go get her. Presumably, that's what happens, because how else does she even know to come to the school? There's no way for her to know that. And how does she know when the car parks to get out and start running for that scene? Because I submit to you, Dad has indicated to her in whatever way they communicate about discipline of their children that he is grabbing Fatima and it's going to be a fight, and he knows that. And she is running to assist. And when she gets there, that is exactly what she's doing. She doesn't have to know that he has the intent to kill Fatima prior to, but certainly if you run in and somebody is in the middle of strangling somebody and your first instinct is to remove the people who are trying to help your daughter, that is a substantial step as an accomplice to aid by presence and act. When counsel says, why didn't we call Haneen? Based on what you observed on those videos, do you think there's anything Haneen tells you that is plainly reliable or that doesn't speak to her parents' behalf, regardless of what information she says? Do you think there's anything? She's not there for the striking of her dad, yet she immediately shows up and starts telling law enforcement when they're there, they're hitting my dad, it's all on my video. She doesn't have a video of anyone hitting her dad. She's not even there when that happens. Do you think Haneen becomes a reliable witness to hear anything from? I submit to you that she would not be. When she goes to check on her child at the office, as Mr. Leary said, her first instinct is to go run and check on her child. The amount of time she spends in that school is grossly less than the amount of time she spends trying to get to her husband and screaming. Remember what Officer Bell's and Officer Chavez's cameras look like. Screaming over and over again. You let him go. He did nothing wrong. You let him go. Over and over. Her interaction, look at her demeanor and her body language when she gets in the school. It's angry pointing is what I submit to you. When she leaves that school, it is angry pointing at Mr. Dean. Then she turns around and she's gone. That's it. Remember what Officer Chavez says. I told her EMS was working on her child. What was her response? She didn't have one. No response. So where is this motherly concern that we keep hearing about for Fatima? I submit to you it doesn't exist. It's not there. Fatima told you that she could not breathe. She told Liz Robinson that she could not breathe, and that is consistent with what the other individuals that were present who identified it, because certainly some people said, I didn't see it. Listen, Mr. Denicola said, I saw mom grab, or who I assumed was mom, but then my focus was on dad. That's where I thought the immediate threat was. And Josh Wagner says, I'm staring at dad. This is where my focus is. I know something's over here, but this is my focus. So the people that are actually paying attention, at some point, even Isaiah says initially he's not looking at it. And you can see in the video, they're watching dad, because who expects mom to come in as an additional threat? They're not anticipating that until it actually happens. And now they have to intervene. And they immediately, when it happens, start talking about it. Athena says, you can't do that. Like, why are you grabbing her around the throat? You can't do that. Fatima says, I can't breathe. You hear Noah Wagner from across. Let go of her. It's done. At that point, Wagner is already on down. So let go of her is only directed at mom. He's watching it happen in real time. So you absolutely have the individuals that are seeing these things as they are occurring because they are far enough back to identify that. When we talk about crimes and the burglary, as we pointed out, as the state pointed out to you in your instructions, in order for something to be a burglary, you have to enter a building. So yes, a criminal trespass also occurred, but a burglary in the second degree occurs when she enters a building. Just like when she assaults her, that is also an assault in the fourth degree, but it is not only an assault in the fourth degree, and we talked about that. So that argument by defense counsel, well, you could have done this for criminal trespass, we could have also done that. It would have been yet another crime, and instead we didn't. We went with when she entered the building, which she is prohibited from doing. There is no requirement, and you won't find it in your jury instructions, that you have to receive your document in the language of your choosing. That is not how the law works. If you went to, let's say, France, and you got an order or a ticket from France, you wouldn't get to say, I don't know what this says. I get to ignore it. I'm not responsible for it. That's not how the law works. You don't get to create ignorance for your benefit. You are still subject to the laws of the state of Washington.
I'm going to object, Your Honor. As to misstating the definition of knowingly.
Definition is what?
Knowingly.
Haven't talked about knowingly.
I'm going to have a brief sidebar with the lawyers, and so you can stand and take another little move around break. Okay, we just had a sidebar after Mr. Larry's objection. The objection is really a misstatement of the law. We got to sidebar. Mr. Larry made a very short argument as it related to his objection. Ms. Stone started to respond, and then I just stopped the sidebar and said instead we'd have it on the record. So I am not summarizing verbatim what was argued at sidebar because I'm not going to rely on that. I will just have the argument here in open court. Anything to add to that, Mr. Larry? The sidebar itself.
Construction 48.
Nope. Anything first to add to the sidebar? Mr. Keating? Ms. Stone?
No, Your Honor.
All right, go ahead.
Okay, thank you. So instruction 48 is the to convict for violation of court order. Prong 3 says that on or about the said date, the defendant knowingly violated a restraint provision of the order prohibiting contact with a protected party. It's the state's burden to prove beyond a reasonable doubt each and every element. And so prong 3 is it's the burden on the state to establish that the defendant knowingly violated a restraint provision. My argument in my closing was that she was presented an order in a language that there's testimony from her daughter that she does not read. And the state in rebuttal argued that we don't believe the defense doesn't get to argue that it was written in the wrong language. The state said there was nothing in the instructions. It said that the order had to be written in her language, and used the analogy that if one of us was to go to France, we wouldn't be able to say that we have ignorance of the law because we don't speak French. The problem here is that's not, my client's not claiming innocent or ignorance of the law. The specific issue is the state has to establish a knowing violation of a restraint provision. And if it is contained in a document that there's testimony that she doesn't understand, the state hasn't established that it's a knowing violation. And to assert that somehow it's our job to prove, or it's somehow wrong for the defense to argue that because it was written not in Arabic, that's an invalid defense. This goes squarely to whether the state has established beyond a reasonable doubt the knowingly violated. And to undercut that diminishes their burden of proof, the presumption of innocence, and shifts the burden to us, and all three are in the wrong.
Thank you. Ms. Stone?
Thank you, Your Honor. Your Honor, first of all, I wasn't done making my argument. I was partway into my argument when counsel raised the issue. So it's unclear to the state how counsel can complain that the state hasn't made an appropriate argument when it hasn't let the state make, in fact, the argument. Second of all, he says very specifically during his closing that one of the ways that he is demonstrating that the state cannot prove that the defendant knew because it wasn't written in their language, as in specifically Arabic, her first choice of language. This is a direct response to that argument made by the defense, which the state is entitled to do. There are, in fact, additional arguments I'm making along with the same line that go to that. The state has not yet once misstated the obligation of the state as it relates to knowledge. I am talking about a piece of evidence that defense counsel presented, and I am responding to that directly and tying it into knowledge, which still has a significant amount of argument to go from the state. So at this point, not only is his objection not consistent with what the state's arguments have been, it is untimely because the state has not in fact finished that argument, and it is improper because the state is entitled to respond in rebuttal to the specific arguments that defense counsel has made, which is, well, if it's not essentially in her preferred language, then how can the state possibly show that she knew, and so she can't be held accountable for knowing? The state can't prove that because it wasn't in the language that she preferred. Those are all appropriate arguments for the state to respond to, and I was in the process of doing so when defense counsel untimely objected to the course of that argument.
Mr. Lurie, anything further?
I would just note that it's not her preferred language, it's that it was written in a language the testimony is that she doesn't read.
All right, I'm going to overrule the objection. I do not find that the argument that was made by Ms. Stone misstates the law as contained in the jury instructions and does not shift the burden of proof to Mrs. Ali in any fashion. And so please bring the jury in. Please be seated. I am overruling the objection. Ms. Stone, you may continue.
Thank you. So back to what we were talking about, you're not going to find in your jury instructions the requirement that any order be written in any particular language in order to establish knowledge. That is simply not the requirement. The state has to show that the defendant knew it, and you have been given sufficient and ample and overwhelming amount of evidence that she did. Specifically, she was offered the opportunity for an interpreter, and she declined that during the course of the trespass order service. She was then asked for Haneen expressly to be provided so that she could be aware of what the limitations were during the trespass order notice. Again, during the no contact order, as you see, she specifically wants Haneen there, and you see Haneen ask the officer, are you okay if I'm here? She likes to have me present, essentially, words to that effect, so that I can help her with this. And she says, yes. Counsel continued to tell you that the testimony from Fatima was that her mom doesn't read English. That was not Fatima's testimony, I submit to you. Fatima's testimony was she doesn't read it well, and she certainly doesn't read it as well as she speaks it, but Haneen usually helps her, and that is in fact her preferred version of that. You heard the school talk about they've had communications with mom. Those communications are consistently in English, so she absolutely is able to move around her universe in English. The expectation is that you are obligated to follow the laws of the state of Washington, regardless of what your first and preferred language is. I want to be very clear. That does not mean that somehow makes it easier for you. Mr. Leary made a big argument, I'll choose the word argument, at the end, that somehow Mrs. Ali, and Mr. Ali are being specifically targeted for some reason other than what their actions are. The laws of the state of Washington apply to them equally. Their actions are what are on trial, not them as humans, not them as people. You don't sit here as judges of character. That's not what your purpose is. You are here to determine if the actions that they took on October 18th, 2024 are consistent or inconsistent with the law, as the court has instructed you, and whether the state has proven that to you beyond a reasonable doubt, not whether you personally agree or disagree with anything about either one of them. That is not the standard, and you absolutely should not be doing that. We don't decide cases based on sympathy or prejudice. You absolutely should not be doing that. We decide cases based on evidence. This is a court of law, not a court of feelings, and so I would ask you to return to your instructions. Somehow, Mrs. Ali speaking a different language, it may impact your decision or your evaluation process in terms of knowledge, but likewise, the additional assistance that she was provided and offered, that she accepts, and the assistance that she declined, demonstrates to you in how she interacted with both law enforcement and the school as to both of those orders, that she understood absolutely what the parameters were for what behavior she was allowed to do and which ones she was not allowed to do. And she knows she's not supposed to be in that school. Absolutely knows she's not supposed to be there on October 18th. But she goes in anyway because she says Isaiah took her child and go, 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 and they went in there, run away. So she wants to go get her child back from Isaiah, and she is not allowed to do so when she gets in there by the faculty. She is prohibited from doing so when she gets in there by the faculty. When we talk about the behaviors actually at the scene of mom, again, Mr. Leary is described as like she is comforting her child. That's what she's there for. But you heard Fatima say, that's not what we do. There's no hugging in my family. Like, not just like, hey, it's only occasional here and there. There's no hugging in my family. That is what Fatima said. These are not arms that reach around and comfort her child. This is a different kind of hold. This is a restraint. This is a choking around the neck. And Fatima says immediately, I can't breathe. And Denicola says, I can hear her whispering something, but it's not coming out, right? Remember Athena's testimony also saying, I remember her saying, my husband, as it's happening. That's what I remember. Not my daughter, my daughter. And we know at the time, as we talked about before, Fatima has been isolated significantly at the time that contact is made. So when she runs into the school, again, mom is chasing her down and trying to pull her back. So the 4 weeks of isolation that she has had leading up to this one-way ticket out of the country, mom wants her back. Mom doesn't want her to talk to law enforcement, I submit to you, doesn't want her to talk to the school officials anymore. And that is what she is concerned about. Remember, she says, just let me talk to her. I just want to talk to her for 1 minute. That's what she's telling Officer Chavez. Not how is she, what is she doing? Just let me talk to her for 1 minute. Does that sound like a mom that wants to know about the condition of her child? Or does that sound like a mom who wants to make sure that she and her child are on the same page and they are able to get their story straight? So then let's go to Mr. Kading's arguments. Mr. Kading over and over again says, when my client was unconscious, my client had this head trauma, when my client had all of these things wrong with him. You heard no evidence of that. In fact, you heard Isaiah say, I thought he went unconscious. And when asked, is that something you did or is that something that happens later? He says, well, when we were striking him, nothing happened. Eventually, his eyes closed. And when is that? Well, Mr. Wagner was the one and he doesn't know his name, Mr. Wagner. He says, not the adult, not the bus guy, the other guy. When that guy gets there, everything stops. And Josh Wagner says, when he gets there, his eyes are open. He is choking that child. He is strangling that child. And when Josh Wagner does whatever special operations maneuver Josh Wagner does, that is when he releases. And everyone agrees with that. Denicola says, I'm trying to get his hands apart, but I'm not successful. I'm doing it on my own. And then another guy shows up at the same time. They all talk about the third individual that is present but has really no interaction. And you see that guy in the blue coat come.
In this deposition that he was not in the loop with this trial on a day-to-day basis, but in the week or so leading up to this case, he has had conversations with the defendant that were letting him know that the trial was going to happen. And then the discussion about testimony came at the end of last week, was his statements. Or over the weekend, it may be over, but I'm not 100% on that. Regardless, his European trip was canceled in, I think he said Sunday, maybe the weekend it was canceled. And so today's Wednesday. They have made no arrangements for him to be here. He certainly has the financial wherewithal and otherwise for him to be present here today. He is not present here. He is in New York on Zoom. I normally wouldn't object, but I'm objecting for a slew of other reasons, and that's just one more on top of it. The dealing with Zoom in terms of showing of evidence to the witness is very difficult. We had some difficulty even in depositions accomplishing it. And all of these things had been known for the defense for a long time. We are objecting to their testimony in entirety, but I have to acknowledge that I have deposed them now, and I know generally what they're going to testify to in court. Other things beyond our strategy, beyond going and doing background work and all that, I can't accomplish any of that, but I do know what they're going to say. If the court is inclined to allow them to testify, the state would ask for the remedial measure of letting the jury know that these names were not read to them, they were not listed by the defense. They were, we learned about they were listed by the defense last night, and there has to be some negative information given to the jury in instruction that these names should have been given earlier. There has to be some penalty for doing what the defense has done. If the court's not inclined to strike, which is what the state is asking for, we ask for that penalty to be some instruction about the late disclosure, which is not the state's fault and has prejudiced them.
All right, I'll hear from the defense as to the alternatives this court has, because as I see it and as I've thought about it, we took an hour and 15-minute recess to allow the state to talk to these individuals. I've now heard from the state about the remaining prejudice, even having now talked to the individuals. I could recess this court or this trial for the rest of the day into tomorrow to give the state an opportunity to conduct the investigation that they are entitled to conduct of these witnesses. I could grant a mistrial, as your case, Ms. Kawas, that you provided to me indicates I could do. And for the record, I will state that if a deposition during a break in the trial was insufficient to cure a procedural prejudice to the state, then the trial court should have declared a mistrial. That's the 2nd District Court of Appeal in Mosley v. State. Actually, I'm not sure if you gave me that case or I found it on my own perhaps, but it's 182 Southern 3rd, 797. But the other cases that you provided to me do talk about the alternatives. That is brief recess, day recess, mistrial to allow the state to then rebut or get witnesses or present their trial or case, now given the testimony of these two witnesses who have never been listed, have never been deposed, and have not been investigated. These are all options I've been considering. I'm sure all of us can agree none of us want a mistrial. I saw you shaking your head no. We've been here now. We're into our second week. Took 3 days to pick these juries and then to have this. So I am mulling over what should be the applicable sanctions. I've heard of something new. I've not ever heard of that before, Mr. Mizrahi, advising the jury that these names were not read to them, which they weren't at the beginning of jury selection, despite my court order asking for the names to be provided of any possible juror that might testify in this case. That, again, was in my trial order that I entered and that all parties received on February 19 of 2025. So tell me, what alternatives, what sanctions, what should I do from the defense perspective?
So, Your Honor, first, I did not hear the state move for mistrial, because that is the remedy that they wish to see. So they didn't move for mistrial. I still haven't heard any articulable prejudice other than we're not able to run background checks. They are the state of Florida and have an entire agency that works for them. I can advise them that Mr. Robinson has no trials. So I still haven't heard any real prejudice of what they would have done. We did make them available. Mr. Mizrahi had all the time in the world. He was limited in the questions that he wished to ask. I advised him of the scope of where I was going with these witnesses. He went way outside of that, was able to show them evidence that had been admitted into the trial, offer their opinion. There was nothing prohibiting him from asking anything he wanted. So him just not being able to go into the background, I don't think that that's a prejudice, Judge. The request to ask for a special jury instruction that the defense somehow violated the law is not supported anywhere in law, and I would say that that would constitute reversible error. But then to give an instruction from the judge in the form of jury instructions or an admonition by the judge is going to create, I think, more undue prejudice than anything else.
Well, let me ask you this, because I'm agreeing with you that a negative inference admonition, I don't know that I agree with that, but these names have not been read to this jury. And at the very least, I think I should, before these witnesses are called, simply state two other names of potential witnesses were not provided to you when we selected you all last Monday. I need to know if these jurors are related by blood or marriage to these witnesses or know them from any business or social relationship. Because if they are, I'm not going to allow that witness to testify if it's going to affect their ability to be fair and impartial in this case. And that was not inquired of them last Monday because we did not have these names last Monday.
And Your Honor, I would think that that's okay because that's something that the court has done. You know, at the beginning, I don't think that would have any negative connotation. It's just, it's come to our attention that there are two other potential witnesses. I need to read your names, if you could provide them. It's free cross-examination for Mr. Mizrahi to say the first time that you spoke to defense counsel was 2 days ago. Or something, he can say that, you've known about this, although he opens that door, it's free game for me to say, this case has never come and spoken to you, even though they know that you are Blue's daughter. So I am trying, Judge, to make sure to avoid any undue prejudice on their part. My intention is to limit it to that particular testimony, but if the court allows them to testify, obviously if they go into an area of cross-examination that then flings open the door, then I would allow to go back. But I still, as we stand here today, Judge, if they need more time, obviously I don't want to stretch this off, but if Your Honor is left with, I'm going to refuse to allow them to testify, or I'm going to break for the day so the state can do whatever investigation they want to do into these two individuals before they take this back tomorrow. That I would think, I don't think they need it, but obviously I understand, Judge, I would probably make the same request
But you, at least from what I just heard today, are you acknowledging that as of 2020, each of these two witnesses told you all that they had viewed the video and that it was their opinion that it was not Mr. Hakeem Robinson in that video?
So when I was speaking to Ms. Robinson back in 2020 as a family member to my client, to be honest, every one of them, pardon my language, said, hell to the F no, that's not him. So if that was what Mr. Mizrahi is talking about, I didn't have a formal meeting with each one of the my client's family members. I've had conversations like that with his mother. I've had conversations like that with his grandmother. It was in passing. And when he asked her, he said, yes, I've spoken to her before. And I basically was like, hell no, that's not my brother in the video. It was said in passing, Judge, not in like a formal, hey, listen, so you have this information and I'm going to now list you as a witness. It wasn't like that the way that Mr. Mizrahi was making it seem. It wasn't. That's the conversation I had.
And with Mr. Shapiro?
Mr. Shapiro, after the bond hearing, all conversations with him have been with Mr. DeCoste. As Mr. Shapiro said to Mr. Mizrahi on the oath, the conversations leading up to with Mr. DeCoste talking about this was letting him know the case is going to trial. It wasn't about him testifying. He actually said on the oath, when Mr. DeCoste asked me about testifying, it was 2 to 3 days ago, which it was a square within the weekend, which is right after Blue testified, and we were scrambling of what we were going to do with that. So, and the representation by Mr. Mizrahi that he said, oh, he was in Europe and he canceled from last week. He just said on the oath he canceled his trip Sunday. So, Judge, had we had the opportunity to fly him down here, we would have made those arrangements to do so. But Mr. Mizrahi, when we brought this to his attention at sidebar on Friday, that we would bring in Mr. Shites, didn't say, well, you better have him here in person. They had no objection to Mr. Ahmad appearing by Zoom over in a completely different country, so they wouldn't have had any problems showing her pictures or anything like that. And what this is about Mr. Shites is they're so adamant and now lobbing this objection, because just like we did yesterday when they spoke, we didn't object to certain things. I'd expect them to extend the same courtesy to Mr. Shites. If the court is going to reset, if we have to scramble to put him on a plane to come down here, we can question him about what his schedule is like. He is available to testify by Zoom today. And that was something that would cause a recess. So, Judge, in this moment, I don't think a recess is necessary because I haven't heard really any prejudice other than it's back in the state's case. We won't be able to find something to impeach them with. It just sat down with them and had all this time in the world. Not sure what it is that they haven't shown them already that they would use to be able to impeach them. They had free range to talk to them just now. So, in my opinion, I think they should be allowed to testify. Anything about them being listed late, Your Honor can just ask the names. They can bring out in cross-examination that, oh, you know, you spoke to Mr. Kawaz in 2020. I mean, if he brings that out, I'd be able to say, what did you tell me in 2020? That your immediate reaction when you saw that video was, hell no, that's not my brother. So, that's basically my position, Judge. Obviously, it's within your purview. I think exclusion is absolutely way too far above, especially in a case like this where the ultimate issue is the identity of the shooter, and they place this testimony that we're seeking to introduce square within the realm of these witnesses because their last witness last week is a family member who opined on who it is. And Mr. Shives also was very clear, Your Honor. He spent so much time with Mr. Robinson leading up to the day of the murder. So he does have the requisite knowledge to offer his opinion. And he would be so candid. He goes, listen, I'm not an expert. This is just my lay opinion from what I know of who Ksoo was back then and what I saw on that video.
And since Sunday, I guess, because there is an objection to Zoom testimony, and obviously Zoom testimony, I allow if both parties agree to it. Otherwise, this is a criminal proceeding. Witnesses are expected to be present unless there is some undue hardship or some other reason why the witness can't be here. Obviously, the woman in Jordan is, I think by all accounts, and both parties agreed, that's an undue hardship. And by the way, she was on Zoom earlier at 10 o'clock when we were speaking, so she was there. I just wanted you all to be aware of that so that your decision not to call her wasn't because she wasn't on Zoom, because she was. Okay. But as to Mr. Shipes being in New York, at least as of Sunday. What efforts have been made to get him here, and or what undue hardship exists that he can't be here because there is an objection to him testifying via Zoom?
So, Judge, as to the efforts made to bring him here, we weren't going to fly him down here when they have been adamant that they would be objecting. So there was no ruling by the court. The state didn't ask to litigate this before when we were brought to. So I'm not going to make arrangements and spend all this money to fly him down here for then the court to say he can't testify. And we actually learned last night at 7 p.m. that he wasn't in Europe. He was planning to be in Europe, Judge. It's just that he had told us one of his artists that's over there, that's a signed artist, got sick. He canceled that trip Sunday night. So, and obviously we have to reach out to Mr. Shives. We have to check flight plans. If Mr. Mazraki is adamant about him walking in here in person and testifying in front of that jury, we can get that information to see if that's feasible, Judge. Well, we have to reset it till at least tomorrow. I don't know what the flights are from New York to Jacksonville. So that's where that would be. I just find I understood the state was fine with Ahmad appearing by Zoom. I haven't heard yet what prejudice, the right to confront witnesses is a defensive right. So they don't have a right to confront witnesses, it's a constitutional right. But if that is their objection, I'm not hearing what the prejudice would be with him appearing on the screen as opposed to physically walking into this courtroom. But if that's the case, we have to step out, Judge, if you want to see if we are capable of bringing him here. I don't have that answer to that question, like, oh, yes, we can have him here tomorrow morning.
All right.
Your Honor, I can share on the hardship thing, at least noted part. I don't speak to him, although I'm certainly hardly in touch with him. Variety did a recent news article, and this supports what I'm about to share with the court.
I'm not relying on a Variety article.
Oh, no, just
Okay.
what it is as to the hardship, that he had just sold a comedy pilot in Movers
Okay.
to FX, and that is one of the projects that's being worked on. And I'm just sharing hardship with Your Honor, that was at least, I didn't have a full conversation as to the hardship, but that was one of the things that has him where he is right now.
In New York?
Correct.
Well, isn't that where he lives?
I believe it is.
Or LA and New York? I think. I don't know. When he testified at the bond hearing, those are the two locations he mentioned.
Correct.
Okay. Well, I don't know that that qualifies as a hardship if I were to believe the Variety article, but thank you for that. I'll give you one last opportunity to explain to me then, given what Ms. Kawasas just said, what is the prejudice to the state? Because let me say this. Again, Richardson hearing, I got to make 3 findings. Was it inadvertent or willful? I'll tell you right now, I'm finding it's willful. Was it substantial or trivial? I'm finding it was substantial because this is significant evidence that is now being introduced that was never listed. These witnesses were never deposed. It was known about since 2020, apparently, that these witnesses have seen the video and don't believe that it's Mr. Robinson, but I still need to determine what the prejudice is to the state. You've now talked to these 2 witnesses.
Yes.
You're asking me to strike them. You understand if the appellate court decides I have stricken them inappropriately, we are doing this trial all over again.
I understand, Your Honor, and that's why I gave up the other proposal about some type of instruction about these witnesses were not named and listed. There has to be a consequence in the state's opinion for this. The prejudice is perhaps we don't call Abdul Robinson Sr. Perhaps we don't ask him the question about seeing the video. I don't know those answers. We didn't have this information. If we had multiple witnesses that would have come into court and said, that's not him, or we knew somehow that was going to open the door to a listed witness that had that, that's a strategic decision the state can make and say, well, listen, we're not going to go into whether or not people can identify a hooded, masked individual on a video. But because there was nobody listed, we had no idea that any of this testimony was going to come, we said, well, I mean, if Abdul says he can do it, let's put that information in front of the jury. That's the kind of prejudice that can't be undone with time, with effort, or not asking for a mistrial. The state would be highly prejudiced by that, in that the time and expense and effort it is to go through all of this. So I'm trying to come up with the ability to give the defense a fair trial. And by the way, the testimony from Abdul Robinson Sr. is ripe for arguments about his ability to make the identification that he made. Just like the cross-examination, the testimony of these other witnesses is ripe with that. I mean, we are, I think everybody acknowledges, looking at a fully covered, masked individual from behind, from a dash cam video. It's, I mean, the weight of this evidence, I don't think it prejudices the defense that much to exclude them. But I understand the court's apprehension. I'm apprehensive about it. I believe that there has to be some indication to this jury that these witnesses were listed late by the defense, and there should be some type of negative inference. I can tell the court, I hate to do this, but I'm going to do it anyway, that I had a case where we listed a witness late, and the court's ruling was you can call the witness, but I'm telling the jury that you listed the witness late.
Did the appellate court ever pass on the propriety of that admonition?
It did not.
Okay.
So I have no case law support. I believe the defendant was found not guilty, so there was no appellate court.
Oh, okay.
I think that the instruction inured very poorly against the state. So I can let the court know that. We should probably win in this case too. There's probably a way to word it more innocuously as opposed to not criticize the defense. I don't, you know, there's nothing more in the next 6 hours that the state is going to do to change our position. We'd like to move forward. And I don't want to recess this jury any longer than we have to. But we believe there has to be some consequence when they intentionally, knowingly withheld this information, allowed the state to go forward in its case in chief, and then sprung these witnesses on us.
Well, I don't disagree with you there. I'm not at all happy about the proceedings as they have unfolded today, because we are all supposed to operate under our rules, under our laws, under our code of professional conduct. And springing the defendant's sister, by the way, who he has known has existed this entire time and who has been available to the defendant and his counsel since 2020. It's similar to the Scott case, which the defense provided to me. 17 Southern 3rd 766 from the 4th DCA, where the defendant's sister, who'd been willing and available all throughout the pendency of the case, was sprung on the trial on the prosecution at the last moment. In this case, was excluded, and that was affirmed. I'll state specifically, as the Westling court stated, and for the record, that's 877 Southern 2nd 877, that's a 4th DCA case from 2004, that the witness was not newly discovered. It wasn't as if they just found the witness who had been unknown to them. It was the defendant's sister. Her whereabouts were known, her willingness to provide information that was favorable to the defendant was known, but the defense provided really no justification for the 11th hour disclosure. That being said, I don't want to risk this case being retried. I am not going to strike the defendant's witnesses. I understand what I have ruled so far, but I gave the state an opportunity to talk to them. At least you have. You've deposed one. But let me say this. Their testimony shall be limited to what you've said it's limited to. If it's for impeachment or for rebuttal as to the identification of the video, that is all that is coming. Don't be delving into other areas that we have not discussed here already or that are not proper impeachment. Because as I recall from Mr. Shipes or Mr. Shapiro, in his testimony and bond hearing, he would keep saying, oh, he's a good kid, he's a good moral character, he's not violent, he wouldn't do that. As you well know, that is all completely inappropriate, inadmissible evidence during this trial. You ask him pointed questions and I expect distinct answers, or I will be sustaining objections as they're made, because he was going above and beyond the things that he was saying before. But tell me with specificity, because now if I'm going to allow the Zoom depo over the objection of the Zoom testimony over the objection of the state, What difficulty or what do you need to present him with? What documents so that we can get those to him ahead of time or send them to him now via text or email or whatever it may be? Because I do know and recognize the difficulty in showing a witness on Zoom an item of evidence. We can't show them.
I believe I can share a screen on Zoom.
Okay.
I believe I can from this. All right, so I think we can set it up.
Will that appear appropriately on all the jurors' monitors and everyone else? Okay.
So I think we can share screen. I won't be able to use the physical evidence as well because that you'll have to hold up to the camera, but I think most of what I need to show.
Yeah, and where would the camera for the Zoom be? Is it that one back there?
It will be on wherever you put it on. Yeah, it'll be that one, for sure.
Right, so no one can hold up a gun or a rifle or anything up to that thing.
I'll figure it out, Judge. I mean,
Does the Elmo show on the Zoom screen?
We can put whatever we want on the Zoom.
Okay.
I mean, we had a little bit of difficulty in the depth I was holding up to the camera.
I understand.
I mean, these are problematic things I appreciate and respect the court's ruling.
I am, however, going to tell them the names of the witnesses because I do need to know if they know them or not. I'm not going to say the defense failed to disclose the witnesses. I'm just going to say 2 additional witnesses have, let me see how I'm going to say this. 2 additional witnesses have just now been made known to the court whose names I need to advise you to make sure that you're not related to them by blood or marriage or know them from any business or social relationship. And then I will say their names. So I do need their full, complete names. What's Miss Robinson's name? Can you spell it for me? And then Mr. Shipes, AKA Shapiro, what's his first name?
It probably should be read Shapiro, also known as.
Okay.
Shapiro is his real name.
All right.
Are you ready, Your Honor?
Yes.
And so I believe it's pronounced Shardeja. Shardeaja. Then initial K, and then last name Robinson, regular stuff.
Okay.
And Your Honor, if I could post her testimony, just to make the same request that I have with other civilians, if her face cannot be placed on the camera.
Okay. We'll be sure not to show her face on the camera if we'll adjust it. Is that who you're calling next, or are we calling Mr. Shapiro?
Shapiro.
All right. Do we have Zoom ready?
Do not, Your Honor.
We do not. Okay. Well, do y'all have the number to give to our IT folks so we can get that set up?
I'm understanding he's already on.
Is he? Let me go check.
I don't see anyone on Zoom.
Go to Zoom now. I'm gonna admit you. Go ahead and join. I'll admit you. I can make you call.
Yes. Uh-huh. The Elmo cannot? Okay.
Whatever else is on the computer, yes.
Okay. Well, let's hope resolve that. All right. Good morning, Mr. Shipes. Can you hear me? And no, you can't see me. Hold on. I can see. Okay. I'm fine, thanks. So our jurors are not in yet. We're trying to get this set up and bring them out so that you can testify. I want to be sure that you can, A, hear and see me. Is that correct? Yeah, I can see you from a distance. I'm looking up, but yeah, I can see you. There's another square that just has me in it. Are you on an iPhone or an iPad? Okay, if you swipe, you'll see all the different squares. Okay. And then there is a square where you should be able to see Mr. Robinson with his counsel seated at counsel table. Do you see that? Okay. And let me confirm that counsel and Mr. Robinson can also see the witness on the Zoom screen. Yes. Okay. All right. Anything we need to take up before we bring the juries out? And has Mr. Shipes, I understand Mr. Shapiro is your actual last name? Okay, we'll go by your official name. That he has been advised about what he can and cannot say?
Well, Your Honor, we can do that right now. We've talked about it a little bit in abundance of caution.
Okay.
The only lines of questioning that we intend to get into with Mr. Shipes are this: his basis for knowledge leading up to January 15th, 2020, how he knows Mr. Robinson, whether he's viewed the dash cam video, what his opinion is on the shooter in the video. And Your Honor, there was another thing that we discussed. I'm not trying to throw this in now. We did discuss it. It impeaches Mr. Robinson. Mr. Shipes is the one that signed Mr. Robinson, or Mr. Shapiro, and Abdul Robinson Sr. said that he was, involved and he was managing it. And Mr. Shipes, his only testimony is he may have signed paperwork. I never met him. I may have spoken to him once or twice, but that he wasn't as involved as Mr. Shipe was with the music stuff. That we considered to be impeachment. We did talk about it in the back. I don't know if the government objects to that, but that would be the extent. Obviously, the previous portions are the biggest ones.
Okay. Any issue with that? I mean, understanding my ruling that I'm allowing this witness to even testify, even though... I'm sorry? Oh, yeah, very funny, Mr. Mizrahi. Okay, then we're going to bring the jury out. I'm going to first ask them about the two witnesses who are now going to be called, and then we will continue with Mr. Shapiro's. Right now, he does not need to be shown on the jury monitors just yet. So if you can turn it off on the jury's monitors until he's... No, you're fine. We can handle that. Then I will have them call him as a witness. He needs to be sworn in by the clerk, and then we'll turn on the monitors before he's sworn, obviously.
And Your Honor, just as we are right now, our next witness would be Ms. Robinson, and she's outside. Did you want me to proffer now anything, or are we going to take a recess just to advise the court of the area I'm going into?
All right, you may go ahead, tell me now, but I thought he was the next witness.
He is.
Oh, okay.
In case you want to just go into.
No, I don't want this jury to take another recess. They've been out almost 2 hours now.
So Judge basically introducing herself, how she knows Abdul Senior, like it's her father, how she knows Dean Robinson, the time that she spent leading up to the day of the event, that they were all living in the same house. That's going to come out. And when she saw the video, she's going to say she saw the video at the same time the world saw the video, and that what her opinion was as to from what she knows of her brother and of what her opinion is in the video. Now, depending on, I just want to be careful with what they go into in cross, because I know they did show her some videos. Depending on what their questions are and answers, obviously it would be a rehab and strictly to what they asked. And I may just build on that if they ask anything specific, but that is it, Judge.
You can redirect based on their cross. Okay. Okay. Then if there's nothing else, let's bring out the jury.
jury is entering the courtroom.
All right, you all may have a seat. Thank you. Let's wait for Mr. Whitaker's jury to come in.
Jury's in the courtroom.
All right, thank you, ladies and gentlemen. You may resume your seats. First, I want to profusely apologize for that very extended delay for you, ladies and gentlemen. You know, sometimes things come up at trial that have to be handled by me and me alone, and we take as little of your time as is necessary to be able to resolve those issues, and so please blame none of the parties and none of the attorneys, put it on me, but we needed to take up some matters outside of your presence. Those have been resolved now, so we will continue with the defense case. That said, I've also recently become aware of 2 additional witnesses whose names I did not read out to you last Monday when we were picking the jury. So I'm going to read them to you now as they are going to testify. And I do need to know if any of you are related by blood or marriage to either of these 2 witnesses, or if you know them from any business or social relationship. On Zoom, and he will be on those monitors in front of you. We're going to turn on those monitors now, and I'm going to ask the defense to call its next witness.
Jonathan Shapiro, also known as Johnny Shucks.
All right, let's confirm, Mr. Shapiro, that you can hear me and see me, correct?
Yes, ma'am.
Can you hear and see the courtroom on your Zoom screen?
Yes.
All right, and can all the jurors see the witness on your monitor? Yes, I'm seeing head nods. All right, if you will please raise your right hand to be sworn.
Okay. Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may proceed.
Mr. Shapiro, if you would please introduce yourself to the jury.
Jonathan Shapiro.
And sir, if you could very briefly explain to the jury about that record label, about what you do in the industry.
Yeah.
Have you been successful ever in developing a superstar?
Okay, just a minute. When there is an objection, and I know you're on Zoom, but I'll need you to stop speaking so I can rule on it. Okay, that's all right. So be sure, attorney, since this is on Zoom, that you speak into the microphone so that the witness can hear you. Do we have all your microphones on and working? Okay. All right. And the objection was relevance, and I will sustain the objection.
Mr. Shapiro, let's now talk about your artist, Hakeem Robinson, aka Ksoo. Did you get to know him before January 15th, 2020?
Yes.
How many weeks, months, years did you know him before that date?
I think it was 2 years.
Now, beyond the trip in New York City, did you ever spend time together? Did you happen to spend significant time with him in December of 2019 in California? Now, these times that you're working together in the studio, was it solely in the studio or would you hang out as well too? Did you ever see Mr. Robinson playing basketball? Did you ever see him swim in your pool? Assuming he was in a bathing suit and not wearing a suit like he is today? Oh, no, you answered it. I was pausing for the next question. So now turning your attention to January 15th, 2020, was there a point in time that you had the opportunity to see a dash cam video related to this case of a shooting? Yes. Now, did you come to, based on your knowledge of Mr. Robinson, the time you had spent to him, did you come to an opinion as to whom that shooter was? Were you basing that solely on the height of the person in the video, or were you taking into consideration all aspects? Were you taking into consideration the fact that you were looking on a screen as opposed to in person? Any of your work within the media industry, does it ever involve things on video? So I don't know if that was a question to me. I apologize. Experience on viewing things on video to see what looks good and what works. Now, put that on me. To change gears now to the last topic of the signing of Mr. Robinson, you signed him to your music label? Yes. You were the CEO of that label? Yes. What involvement, if any, did Abdul Robinson Sr. have in Ksoo Hakeem Robinson's career? Did you ever meet him in person? One moment, Your Honor.
All right.
Nothing further, Your Honor. Thank you. Back to yours.
Okay, cross-examination.
I'll use this podium.
Yes. As long as you speak into that microphone.
Good morning, Mr. Shapiro. Alan Mizrahi again. I want to show you a series of pictures and see if you can identify them. Mr. Kruger, if you could help me.
Share screen?
Yeah, let me see here. Share, but I want to use the PowerPoint. Do you remember which one it is? We're going to start with this one. I think we spoke earlier today, and I showed you some videos with regard to a gray and black. Can you see that? Are we sharing the screen? And you would agree that you have seen the defendant Hakeem Robinson in this black and gray sweatshirt? And that is Hakeem Robinson in that? Okay. I also want to show you what's been entered as State's Exhibit 230. Mr. Cooper, which one's that? Which PowerPoint's that going to be? Oster tags? I got it. All right, do you see that PowerPoint now, Mr. Shapiro? Okay, I'm going to show you a photograph that's contained within that. Essentially. I thought I had it. There it is. The last one, right? Do you see those two people? Yeah. And can you identify the one that appears on the right side of the screen? And does that fairly and accurately depict the way he looked in January of 2020? You testified that you spent 3 to 6 months with him in the time leading up to this. You can't say whether or not States 230 appears the way Mr. Robinson looked at the time of this incident? Right. Okay, well, I'm asking from your memory, is it consistent with the way he looked back then? Do you know the person in the red sweatshirt? I think you said he looked familiar. You saw photographs of him with Mr. Robinson. So before your testimony here today, you've been watching social media about this case? So we established that. I'm going to show you, get PC, defense exhibit number 3. I'll try to, it's still sharing. It's going to take me some time to get to that other one. So just be patient with me. Okay, do you see two different pictures now? I have to get rid of you, me. Okay. So the jury can see the photographs. And showing you defense 3, Mr. Shapiro, does that fairly and accurately depict Hakeem Robinson on January 14th of 2020? Does it fairly and accurately represent the way he looked when you were with him in the months leading up to this? Okay. Stop sharing. The other thing I wanted to discuss with you, Mr. Shapiro, is the concept of drill rap. And sometimes, are you objecting? Would you agree that Ksoo would sometimes participate in rap songs that depicted violence and death? For entertainment purposes, of course. Yes. And that the defendant, Hakeem Robinson, was part of the ATK rap group. Okay. Well, you would agree, I understand. You would agree that Hakeem Robinson and Kenyatta Bullard in the ATK rap group did not like the group's 6 block. You would agree with that? And so 6 block was a rap group, ATK was a rap group, and they would both do diss songs making fun of the other members' deaths, correct? Sure. But the trash involved the deaths of real people, correct? So it doesn't matter to you whether children are killed as a result of these rap songs?
Yeah, just a minute. There's an objection. There's an objection, Mr. Shapiro. Just a moment. And what's the ground for the objection? All right, I'll sustain the objection. We'll move on from that question.
But you were aware that the two groups, 6 block and ATK, had bad blood between them? And is it fair to say that you signed the defendant, Mr. Robinson, in part because you wanted to make money on his record sales? Sure. Well, sir, you were protecting your investment, fair? Okay, Mr. Shapiro, you've answered my question. Thank you. I have no further questions.
Okay, is there any redirect?
Mr. Shapiro, 2 quick questions. Are you here testifying out of financial motivation?
Your Honor, objection, relevant.
All right. Okay, I'm going to sustain that objection. If you'll just answer the question asked, Mr. Shapiro, thank you.
I think we got the answer, Your Honor. I can go to the next question.
Okay.
Mr. Shapiro, you were asked about a Nike jacket. You remember that on cross-examination? Yep. Going back to January of 2020, specifically within the music community, were Nike Tech fleece suits popular? That colorway, the black and gray, is that a common colorway or is it unique? Now, with respect to Mr. Robinson's size, do you have any personal experience or knowledge with what size clothes he wears?
Objection, Your Honor. He just said he's speculating.
All right, if you know, you may answer, but if you don't know, we don't want you to guess.
One moment, Your Honor. Mr. Shipes, last line, or Mr. Shapiro, last line of questioning, you were asked about drill rap. And within the music industry, are there rappers that try to co-opt the life of others to sell records? One more. It sells better than what I've referred to in this courtroom earlier as happy rap. Nothing further, Your Honor. Thank you, Mr. Shapiro. We're all set with you here today.
All right. Thank you. May this witness be excused then?
Yes, Your Honor.
Okay, sir. You may zoom off now. Thank you. All right, defense, you may call your next witness.
That was difficult and definitely hard to listen to, literally, because they absolutely did not have that Zoom hooked up to the mic. So we can only speculate as to what his answers were based on some of the questions that was asked. So I don't know. I don't really know what to take from that, or even if we can really use it as heavyweight um, in the trial at this point, just from our viewpoint, right? The jurors are always going to look at what they are seeing differently as they're in the room. They've been able to look at the evidence as well as the witnesses, and also, kind of weigh and judge their mannerisms and body languages. And we just didn't have that luxury this time.
Do you know someone by the name of Hakeem Robinson?
Yes,
How do you know him?
that's my brother.
So we now know that the sister is on the stand, and I can't tell if they got a little clipping of her, but we should be able to get the audio. So hopefully they bring that back.
Three to four bedroom.
How many people lived there at the time that you knew?
So it was my dad, Kenyatta, which is his baby mom, my brothers, me. All of us had access to the home. So
So when you say all of you had access to the home, is it all the siblings or is it everyone or?
all the siblings and kind of whoever close to us too, but all of us all the siblings, we all had keys.
Who would be the closest, would you say, in that group that would be coming and going, just so that we have an idea?
My siblings.
Okay, so I'm just going to throw out some names. How many siblings do you have?
It's a total of 11 of us.
Okay, so Abdul Robinson Jr., is that a sibling of yours?
Yes, that's my brother.
Okay. Was he living in the home?
Yes.
Okay. Does he have also a nickname?
Yes, Kareem.
Kareem, okay. Was Hakeem Robinson living in the home?
Yes.
Was that the only home he was living in at the time?
He always was in between his mom and his dad, well, our dad.
Okay, but his mother is a different location?
Yes.
So you'd bounce back and forth?
Yes.
I know there's another Abdul Robinson brother. Did he live there too?
I believe he was incarcerated still around that time.
Okay. And then anyone else of importance that you know would come and go, that you can think of now? I know it's 5 years later.
All of my siblings, my dad, Kenyatta, the people who lived there.
Okay, now drawing your attention to, so during that time, would you see Hakeem Robinson a lot?
Yes.
Okay. You were familiar with, for example, his height and his weight?
Yes.
Okay, you'd see him in regular clothes, sleeping clothes, all type of clothes?
Of course.
Okay. And then there came a time later in September of 2020 where he was arrested,
Yes.
right?
Yes.
Was your dad arrested at the same time?
Yes.
At that time, was a video released on the media about what is the subject of the case that we are here for today?
Yes.
There were several videos that were released into the media,
Yes.
right? The one I want to focus on is the one that was depicted of a strip mall, which showed someone shooting the victim in this case.
Yes.
Did you see that video?
Yes, I did.
Okay. And how many times would you say that you saw that video?
It circulated around the world, the internet, so I would say I've seen it numerous of times.
Okay. And knowing what you know of your brother, when you saw that video, what was your opinion of who the person was?
I immediately said, excuse my language, hell no. I was like, wow.
And how did you, what was it about looking at the video and then knowing what you know about your brother that led you to come to that conclusion?
So if I can give a description of how I describe my brother, I would say that I call him fat, slew-footed, which we would say 2 left feet. I call him stocky and tallest. Tall. He's a giant to me.
Okay, and how tall are you, just to give the jury some reference?
I'm 5'4".
Okay. And so as you describe him to you, he's a giant.
Yes.
And so when you looked at this, is that what it was that, in your opinion, made you believe that it was not him?
It was honestly being a sibling and a sister. It was the intuition, the gut feeling of just like almost if you know, you know. So it was gutting, but seeing it initially, I was just like, hell no.
Okay, no further questions, Judge.
All right, cross-exam.
So, Ms. Robinson, it's true when Abdul Robinson Sr., your father, indicates that Hakeem Robinson was living with him. That's true.
That's true.
And you were there too.
Yes.
And your father certainly would have had contact with Hakeem Robinson during the period of time he was living with him.
He contacted all of us.
Yeah, okay. And is it fair to say that everyone in that house had multiple phones.
Yes.
And I think you've indicated that you even have multiple phones.
Yes, I have two.
And Abdul Jr. had multiple phones.
Yes.
And Hakeem had multiple phones.
Yes, we've had multiple.
And then Abdul Robinson Sr., that he would provide sometimes that for y'all as a father giving to his children.
For myself, I
Yes.
took care of myself.
Okay, well,
But he took care of his son, so yes, he would.
Okay, so he would provide them things like phones.
Yes.
When Charles McCormick, Little Buck, you've heard of him?
I heard of Charles McCormick.
Okay. And you were aware of, before your brother ever got arrested, you were aware of a disc track that he sang making fun of Willie Addison. You remember that?
Yes.
And you were aware of that.
Yes, I was.
And the defendant was aware of that.
Yes.
In fact, Leroy Whitaker was aware of that as well.
We all who are associated with each other are aware of that.
Okay. And just so to be clear, Leroy Whitaker and the defendant Hakeem Robinson are cousins,
Yes, they are.
and they're close.
Yes, they're cousins.
And so the whole group, including Abdul Sr., Abdul Jr., and the two defendants, were upset about this Charles McCormick making fun of the death of Willie Addison.
We all were.
Yeah. And so that was discussed among the group.
We all were upset.
Yeah. Okay. And one of the reasons for being upset is that McCormick was in 6 Block, this other group, correct?
We were upset that he was dissing my dead brother, Willie Addison.
Okay. And Leroy Whitaker was upset, and Hakeem Robinson was upset.
We all were upset.
Just want to make sure. And Hakeem Robinson was in, referred to the group was ATK, correct?
He was the brother of Willie Addison.
Okay, so Hakeem Robinson, this was his stepbrother, I think, correct?
Yeah, we all acted as blood.
Right, but he was like his blood brother. He was that close to Willie Addison.
Yeah, we were blood.
Okay. So he knew who he was.
Of course.
So, Hakeem Robinson, he's right-handed, right?
From my knowledge, yeah.
Yeah. I mean, you've lived with him for 20.
Yeah, that's my brother, so I would say right-handed, yes.
Okay. But it'd probably be weirder if he were left-handed. You would notice that, right?
I don't think left-handers are weird.
Okay, well, unusual, not weird. That's a better word.
No, not unusual. If he's left-handed, he's left-handed. If
He's right-handed.
He's right-handed.
Right, okay, let's get past that. So you saw the internet stuff, and you didn't participate in this crime in any way.
Absolutely not.
You didn't pick up Leroy Whitaker and Dominique Barner.
Absolutely not.
You didn't drive them away from the scene, any of that stuff.
I did not.
Okay. Showing you what's been entered into evidence of Stakes Exhibit 230. I'm just going to do it like this. You recognize?
Yes, I do.
And the person on the right is,
Hakeem.
and the person on the left is,
Leroy.
and do these photographs fairly and accurately depict the way Hakeem Robinson and Leroy Whitaker looked in January of 2020?
Yes.
Show you a couple more things. I think I have to use this. Where's the desktop? Okay, there we go. Okay, showing you what's been entered into evidence in Stakes Exhibit. Excuse me, Defense Exhibit 3. You see that photograph on your screen, Ms. Robinson?
Yes.
Does that fairly and accurately depict Hakeem Robinson in January of 2020?
Yes.
And what do we see in his right hand there?
A phone. Oh. A phone. Sorry.
And finally, Mr. Cooper may need, I think I can get to it.
Smith has the video. Another one. I'm showing you states 192. Do you see that on the screen?
Yes.
And you see Hakeem Robinson in the smaller box?
Yes, I do.
Is Mr. Robinson wearing a black and gray two-tone sweatsuit?
Yes, he's wearing a Nike sweatsuit.
And you've seen him wear that before?
Yes.
You've seen him wear that in the time period leading up to this homicide?
Yes. I just wanted to clarify because you said leading up to this homicide, like because you said.
Well, January of 2020 is the, yeah. Okay.
Oh, yes.
I wasn't trying to trick you. The defendant, Hakeem Robinson, as we sit here today, is bigger than he was in January of 2020.
Slightly, yes, but he's always been just about that size. He has picked up a slightly amount of weight, and his hair has grown, but he's definitely Hakeem that I know.
I understand that. He's put on weight since January of 2020.
Slightly, yes.
Okay. Well, you didn't tell me slightly an hour ago. You said he was bigger, and now you're changing it to slightly.
Well, you asked me, was he bigger? I clarified. Well, you said significantly, and I clarified that significantly was a big word to explain this person. So I clarified to you that he was about and slightly the same size. Because you said, did you use significant?
Yes. I'll ask a question, and you can respond, since we're in a little difficult position here. I asked you if he was significantly bigger, and you would not say that he was significantly bigger, correct?
Correct.
But then we both agreed that he was bigger today. And you never said
Yes.
the word slightly, correct?
All right, he's bigger today.
Okay. So you would agree that he's bigger today than he was in January of 2020?
Yes, not significantly bigger.
Okay. Well, I didn't ask that, did I?
Thank you.
Okay. Thank you, Ms. Robinson. I have no further questions.
All right, is there any redirect? Oh, I'm sorry, yes, of course. For Defendant Whitaker, go ahead.
I've been quiet for a long time this morning. And I like to talk. Good morning, ma'am. How are you doing?
Good morning.
Ma'am, you're familiar with my client, Mr. Leroy Whitaker?
Yes, I am.
Okay. And he's been over to your home on the one you used to live with your dad?
Yes, he has.
Okay. And you mentioned that, actually, first, let me back up. In terms of siblings, who's older, yourself or Hakeem?
Myself.
Okay. And if you don't mind me asking, how much older are you than him?
A year?
Okay. And Willie Addison was older than you, ma'am?
Yes, he was.
How much older than you was he?
Um,
And I realize this might
5 years. It's a lot of us. We rarely remember each other birthdays and dates, and we don't. So sorry if when you ask me about these times, because it's a lot of us. So the birthdays and stuff is a little.
completely understand. But you think roughly about 5 years older than yourself?
Yes.
And you're a year older than Hakeem?
Yes.
Okay. Leroy Whitaker is substantially younger than you, correct?
He is.
Okay. Back in 2020, Hakeem was 21 years old. Does that sound about right?
Yes, it does.
So you would have been about 22, right?
Yes.
Leroy Whitaker was 19, right?
Yes.
And so Willie, had he lived, would have been, if you were 22, he would have been about 27, 28.
Correct.
And it sounds like maybe about 27 when he was killed.
Right.
Okay. Leroy Whitaker didn't have any kind of a relationship with Willie Addison, did he?
Not from my knowledge at all.
Okay. I don't have anything further, Your Honor. Thanks.
All right, thank you. And redirect.
Ms. Robinson, As you sit here today, has Hakeem Robinson shrunk between 6 feet, 6 inches to a feet in 5 years?
No, he's still a giant.
Okay. Has he put on over 100 pounds since he is in the past 5 years?
No,
50?
no,
Slight, as you described it, right?
it's slight.
Okay. Now, the state got up and asked you about the relationship with Blue. Would it be fair to say that Blue started to get closer to Hakeem Robinson when his rap career started to take off?
Objection beyond the scope of cross.
And repeat the question?
If he became closer to Hakeem when his rap career started to take off?
I'm going to sustain the objection.
Okay. And the state asked you about multiple phones. Would you know whether or not Blue gave him those phones, or the phones that belonged to Hakeem were given to him by his mother?
I wouldn't know that. That's not something that he would do as far as go to get them phones, but I wouldn't know who actually got it.
He also showed you a couple of photographs of Hakeem with a sweatsuit on. Did everybody have a sweatsuit like that?
Around the time that pattern was popular, Nike was making this ashy gray and light gray black pattern way also with this orange. So around that time, the Nike colorway was popular.
I'm sorry to interrupt. I need to see court reporter and counsel at sidebar, and I need, yes, right now. Thank you.
Oh, damn. What just happened? See, this trial, every day is something different. We have an issue with a juror every day. And y'all, so when I got the transcript last night, I seen the thing about Scotty and the juror, but I was like, okay, this must not be right, because I know the juror had an injured child. So maybe this is just weird. Do y'all know that on yesterday, one of the jurors on Scotty's jury said that he made contact with Scotty and he felt that Scotty threatened him with a gesture and something that had to do with his neck. And I was like, what the hell? I was like, yeah, Kim sent it to me. And I was like, what the hell? So Kim sent me the video on TikTok, but it was even, and again, it was after the fact I had posted the recap. And I was like, hold the phone. This was in the transcript, but I don't know how we missed it. But I want to know what the hell just happened here to where she just put the court reporter over there and counsel over the sidebar. What the hell is going on?
All right, Ms. Robinson, I think you just answered the question. You were finished with your answer?
Yes, I am.
Okay, no further questions, Your Honor.
All right, thank you. May this witness be excused?
Yes.
All right, ma'am, you are excused and free to go. All right, and from defendant Hakeem Robinson? Well, let's take a recess then. It is now 12:30, ladies and gentlemen, and we are going to give you all a lunch recess for 1 hour. So I'm going to ask that you leave your notepads behind, lock them, secure them, and we will return them to you when we reconvene. Thank you for your patience throughout the course of this trial, ladies and gentlemen. Please be sure that during this lunch recess, you do not speak to anybody or allow anyone to approach you to say anything. Be very mindful, as I know you have been, about not watching or reading or listening to any news stories that might be aired. Audience members may have a seat if you don't mind. Thank you. And if you wish to remain eating in the jury rooms, you absolutely may do so. For those that need to go grab some to eat and bring it back, if you want to do that, that's acceptable. We will be back here. Let me do 1:45, a little bit longer lunch. We've got some other matters to attend to. So 1:45 is when we would like you all back here for continuation of the trial. So you are now excused for lunch recess. Thank you. All right, Mr. Whitaker's jury's out of the courtroom. Do we know if anyone from Mr. Robinson's jury is going to exit to eat, or are they all eating in there? Just one? Okay, we'll await that person's exit, but in the meantime, you all can have a seat. Court is not recessed yet. I have to inquire, Ms. Kashayla Robinson, are you present? If you will please raise your hand. Where is she? Oh, she did step out? Okay, she's not going to be allowed back into this courtroom. Her Facebook has been live streaming this proceedings and specifically live streamed this witness who asked that her face not be shown. That's why our cameras did not show her face.
What I've come to learn
Yes?
is that is actually the witness's account.
And how is her account live streaming her face? So that means someone in here has an electronic device that is on and functioning. And I have told everyone in here that they are not allowed to have that. So whoever has that phone and was live streaming this, you will not be allowed in this courtroom. Who has Ms. Robinson's phone? Someone obviously must have.
I don't know if it's just to inquire. I don't know if there's a way, because I know the case is live streaming.
Her face was not shown on the video screen that we have. The camera that we have up there has been showing the carpet, which I'm looking at right here on my monitor during her testimony. What I have been advised is that her face was being shown on a live stream of Facebook, and that could only occur if someone's electronic device in the audience was on. I cannot stress this enough, ladies and gentlemen, but unless you are credentialed media, you are not to be having any cameras, video, audio devices on in this courtroom. And if we find you with that, you will be excused from this courtroom. So we need to find out from Ms. Robinson who had a phone or who has her Facebook account, because you are excused. That is not acceptable when a witness has requested that her face not be shown on the camera. You all have to follow the court rules just like the attorneys do, just like the defendants do, just like the jurors do. Otherwise, you will be excused from this courtroom. Is that understood to everybody?
And just for point of clarification too, Judge, I initially made that request when I'd gone outside and asked Ms. Robinson, listen, I made this request. She had clarified to me that the only thing she didn't want was her name being broadcast. I did let Mike know that the camera wasn't an issue, but that her name was an issue. But now you're telling me that even the live stream was on the carpet anyway.
The live stream is on. Well, Ms. Robinson's in the courtroom now, ma'am. I'll just let you know, I was told you didn't want your face on screen. Your testimony was live streamed on Facebook.
Yeah, no, that's perfectly fine.
No, it's not perfectly fine, because I've said, excuse me, I've said no electronic devices are allowed to be on and used in recording in this courtroom. So whoever has your phone or whoever did that, you need to let me know who that is. Who is it?
Oh, well, I had my phone myself. My phone was placed in my bag. So
Okay.
I didn't have anyone recording. I have no knowledge of someone else recording besides the news. And what I was stating was that the actual testimony itself was perfectly fine to be recorded, but I did not want to introduce myself by my first and last name.
All right, well, your entire testimony was live streamed on Kashala, I don't know who that is, but it is on the Facebook of Kashala, spelled Kashayyla Robinson. Who is that?
I have my devices and both of them was powered off, so I'm not sure.
Is that you?
Yeah, that's my social media.
Okay.
I'm not sure where.
That was dumb as hell. It's her Facebook. She said she didn't want her name and stuff recorded, and she went and live streamed herself, had her phone in her bag and on playing on Facebook Live when she took the stand and recorded her own testimony. She is a daggone fool. You a fool. Which you didn't care about. You didn't care about concealing yourself for your safety. Yeah, that's what the Kashayla Robinson is her. That's her Facebook. That's what she told her. And she said her phone was in her bag. Silly. Just look, y'all. It's people who ain't never commented right now, y'all. People, everybody is appalled. Stop. Or giving it is most definitely morally shame. Or is giving you up there. You might, it might be your brother now. You got me worried. You got me confused. Yeah, I'm only going back to daycare next week. You got me worried about what the hell y'all got going on. Playing in these people's faces. Yeah, you lucky they don't hold you in contempt of court and lock your butt up. Now, what if they strike her testimony? And they did all that fighting to get you up there on that stand. I don't give a fuck. I have no idea. Why would you feel like you need to record it and it's already live streamed? It's already live streamed. Yeah, Marley, she ain't had no business doing that. Yeah. Clout. That's it, Breezy. Clout. Nene, this one is they clowning in her. They in here clowning, so it looks like they are officially in recess and folks are coming out. We don't need to see everybody boob, so we're gonna go ahead and switch streams. But good God.
The same time, but each of those kids indicate his eyes are wide open. Remember what Danicola says, the look on his face. This is not an individual who is unconscious and strangling. It's not an individual where there's any indication of head trauma. And Mr. Kading said, well, they didn't even check. Right, because he said he didn't need any. How in the world, why would they check for a head trauma when they've identified, would you like any medical? Do you need any medical? No. Because there's nothing wrong with Mr. Ali. There's no cerebral anything. There's no loss of consciousness. And remember what Dr. Gilbert says, when you lose consciousness, you lose control of your body. And you see exactly what happens when you lose consciousness. When you watch the video of Fatima, you go limp. Everything relaxes. You go limp. You heard Lisa Wall talk about that. When you lose consciousness, you relax, which is what makes strangulation even more dangerous when you lose consciousness because all of your muscles relax. You know what your muscles don't do? They don't hold on and pull even tighter. The scenario that Mr. Kading offered you over and over again is not reflected in the evidence in any way. Everyone that described how Mr. Ali was holding his daughter describes it in right to left, describes it in a headlock, a rear naked choke, armbar, and it's pinched back. Every single person did this. If he is unconscious, it all drops. It all lets go. And you didn't see that once. And when you listen to them talk about it, there's not a single person that says it looked like it was involuntary, that it was not intentional, that it was anything other than exactly what it was. He was angry, and the look on his face says so. He is intending to do those behaviors. Intent is reflected, I submit to you, by action. A lot of people can say a lot of things, but what we should be evaluating people are the actions that they take. And the actions, the force used by Mr. Ali was with the intent to murder his daughter. That action is taken, that intent can be formed at any point during the course of that. He does not simply walk over as his daughter is trying to run away from him and grab her by the wrist to take her home. That's not what he does. You see him in that video, and I'm not sure, Mr. Kading played it multiple times, and we must be watching a very different video, because when he says, look, he's just grabbing her, right, around the neck. She's bent down, and he immediately goes around her neck and immediately grabs her and maintains that hold on her throughout. So that is absolutely what he's doing. He is strangling her from the get-go. Isaiah and Caleb, those kids are watching, and they immediately know what's going on, and they immediately know that this is wrong. You actually see at one point Fatima, as they're starting to go back, her hands are here, and she's already at the neck. Her hands are already up because that's where his arms are. The kids see that too. So no, they're not attacking. This is not some mob that is beating up where Mr. Ali somehow is the victim in this case. Mr. Ali instigated this. He initiated these whole series of events, and he strangled his child in front of a large group of other children who know exactly what they saw when they saw it, and as kids knew that Fatima was in danger and had to intervene. That's what they were doing. They're not the initial aggressors. Mr. Ali is. He's not defending himself against Isaiah. He immediately grabs, as all of those kids described, Fatima aggressively, and Isaiah knows because he has the historical background on this family. He's not simply taking Fatima's words for what has been going on. And he told you that. I know what happens. I've seen my own information to corroborate what Fatima has told me. He's also had his own experience with mom to corroborate what Fatima has told him. He knows that the school has taken these efforts. If you're a kid and the school has taken these efforts, might that also indicate to you that those safety concerns have been corroborated? So no, it's not just Fatima making statements and everybody just taking her word for it. Those statements have real value. And the people that are involved or subject to them, I submit to you, know when danger is most likely to them based on their relationships with the people that they are involved with. The school doesn't call her parents, and the school doesn't call her parents because they have a safety concern. So in what world would you, as an official who has a history of interacting with a child, call the person to let them know that you found their child so that they can come home and take them when you have a safety concern? Ms. Robinson said it wasn't imminent, and then she described imminent means like he's not strangling her right in front of me. I don't need to call 911 at the moment because he's not right here, but we can make another set of arrangements for her. Absolutely appropriate. When they talked about, when Mr. Kading talked about, well, Isaiah hit him because he was mad. Isaiah said, I mean, I was mad, yeah, after I got punched, as I think is a reasonable, I submit to you, is a reasonable response. He doesn't say, I went and attacked him because I was mad. The question was, well, when Mr. Ali punched you, you were mad, weren't you? And he was like, yeah. That is an absolutely reasonable response for a kid to say, this adult punched me in the side of the head. He was trying to attack his daughter. I was trying to intervene to keep her safe, which Isaiah is also entitled to do. And the defendant punched me in the side of the head. So yeah, I was kind of mad about it. Fair. But then when he stumbles back, and you see how far in the video from the front of the bus, how far he stumbles as a result of that, he stands back up, he looks around, and Dad is already taking Fatima into a headlock and a chokehold. So when they go, they're not going over to push him down and start kicking him. They're trying to get Fatima out. And to be fair, they're kids. So if we're arguing that the execution of said non-existent plan by kids wasn't the greatest execution, that's probably a fair statement. But it doesn't mean the intent is any different, right? It's very clear that they're all screaming, they're all kicking, and despite all of that, Dad doesn't release. Even when Mr. Denicola is there yelling about it, even when Mr. Wagner shows up. That is not, those injuries to Fatima are not because they're just wrestling on the ground and he's trying to protect her. Nothing about what he is doing is trying to protect her, and you have that testimony. And you have the description of the injuries. That armbar hold that was described to you, that is very specific. That's not simply hands. It's not like, oh, we all got caught up and we were all tangled. It was this, and he was locked in. And Mr. Denicola described it as his hands were tied together and he could not even pry his fingers apart. He was actively resisting having his fingers pried apart. Defense counsel argued that all of these kids had all watched the video, all these people had come in and they'd spent all this time testifying about the video, and so therefore that's why all of their testimony was the same. Ladies and gentlemen, that is akin to interviewing people that have left the Grand Canyon and taking issue with the fact that they all called it real big. They all described what they saw. They described her going pale. They described her lips going blue. They described her, well, two of them saw her seizing, what Dr. Gilbert would describe as seizing. They don't know that that's what they're seeing, but that's what they've described. They described her being unconscious. All of those things are described to you because that's what they observed, and from their vantage points. And some of them didn't describe things that other people identified. And to that end, Mr. Denicola and Mr. Wagner and Mary Wagner also didn't describe all of the same things. But the things they did describe that were the same, that overlap, is because that's what happened, and that is consistent with the video. So statements to the contrary don't make any sense, right? We've described, you heard Fatima say she thinks as she's coming into this conversation, it's calm, but all of the other students are watching and they're like, it looked really angry and aggressive to me. So what does that tell you about the environment that Fatima is in? That what feels like a calm conversation to her with her dad is described otherwise by the objective observers watching, that is not calm. You have evidence of the intent for days. And Mr. Kading said, there's no evidence of any intent here. You do. And the actions are, in fact, the evidence of your intent. When you look at that assault one, for example, it says that whether the defendant acted with the intent. And if you walked up and somebody was strangling someone into unconsciousness in that same type of hold, and they said, don't worry, it's fine, I'm not trying to kill him. Don't worry, it's fine, I'm not trying to hurt him, they're fine. And you've watched their lips go blue, and you've watched their eyes roll back in their head, and you've watched them seize. Would those words mean anything to you? I'd submit that they would not. You would not believe that because of what you were observing with your eyes about the acts themselves. They speak louder than any words that Mr. Ali could have provided at the time. Don't get caught, please, into the idea for great bodily harm under assault in the first degree. The great bodily harm has to be inflicted. That is not the instruction to you. The instruction to you is that the force used must be likely to cause great bodily harm or death. That the force used. And you have an overwhelming amount of evidence of that specifically. Mr. Ali knows exactly who these individuals are. He's spoken with Mr. Barnes. They've spoken about Fatima and Isaiah specifically. He knows that his wife is subject to, I submit to you, a no contact order with Isaiah.
I'm going to sustain the objection.
He knows who these individuals are.
Overruled.
He knows who these individuals are. He's spoken with Mr. Barnes. He knows that Fatima is in a relationship. In fact, he's told, and Mr. Barnes testified about that. He said, I'll do my best. We can try and keep these kids apart. That's what Mr. Barnes told you. But what are we going to do? Like, they're in love, but I want to be respectful. And I want your wife to stay away from my son. That was his testimony on the stand. And then as they're standing there, Isaiah is rubbing her back and essentially saying, it's okay, right? And you heard Noah's testimony. Noah says, I said, inshallah, it's love. What are you going to do? They're in love. And that he did not like that. Mr. Ali did not like that. He knows exactly. There's no indication here that Mr. Ali is dense and he doesn't recognize contextual clues, especially when there's been a direct conversation about it. That information is all information that Mr. Ali has. So if anyone also is directly under the point of Mr. Ali's ire, again, that would be Isaiah. So do you think that punch then is delivered with a bit more force because of who it is being delivered to versus a push? Maybe the reasonable alternative is a push to that. But he doesn't do that. He punches him in the head. And again, why? because he's mad. The standard for reasonable doubt is not a doubt. It's not a single doubt. That's not the standard. That is a misstatement, in fact, of that law. Go back to your instructions. The standard is whether it is a reasonable doubt, not any possibility, not any doubt. And in fact, if you have an abiding belief in the truth of the charges, then you don't have a reasonable doubt. When you came into this case, you didn't know anything about the facts whatsoever. You knew nothing. So if you're coming to that place now where you're like, I believe that I have an abiding belief in the truth of the charges, that the state has proven that to me beyond a reasonable doubt, and I submit to you I have met my burden. Certainly do not lower the burden of the state, but also don't make it greater than what it actually is. And that is the instruction before you. Not any doubt, not a single doubt, but a reasonable doubt. Council used the exception, or excuse me, the example of making a basketball hoop that, so he must have intended it, that you can only intend a strangulation by putting your hands. Anything else, bless you, anything else is not evidence of intention. I submit to you it is a strange or maybe even an absurd scenario where somebody whoops-a-daisies their way into an armbar hold, a rear naked choke. That's not an accidental event. That is a exceptionally intentional event. You can be, let me back up. Defense counsel said, you know, these are parents that are, they're at the end with Fatima. They're struggled, they've had a hard time. As I said during my first closing, everyone can relate to that, right? Parenting is hard, and that people derive sympathy from that, and we certainly, individuals can understand that. But it does not matter for the purpose of this trial as it relates to the actions that those defendants took. You can be the worst kid in the absolute world, and it still wouldn't justify what these two parents did to Fatima on that day. You do not get to strangle your child. You just don't. So that is, parental discipline does not allow for that. Parents have a lot of leeway, and that's, I would argue that's probably true across the country, but in the state of Washington, parents have a lot of leeway in how they restrain and discipline their child. But those rights are not unabridged. You don't get to do whatever you want and then couch it under the guise of parental discipline. And here, Mr. and Mrs. Ali grossly exceeded what that looks like. Fatima was strangled for approximately 45 seconds. And if you think about how long 45 seconds is for somebody who hasn't taken a breath, they weren't anticipating holding their breath, they weren't anticipating being strangled, and it's not just holding their breath, but there's additional pressure and panic occurring at the time. 45 seconds is a really long time. So let's count it out. That's 45 seconds. That's how long her dad was strangling her. It's a really long time, you guys. School is supposed to be a safe place for kids. It's a safe place for Fatima. She told you that when she testified. She's known adults and other students there for 2 years. She's formed relationships with those adults. The school told you they had concerns about Fatima being online and not having access to other adults. These are the same adults, Tracy Arnold testified, that told you they would feed her, they would give her snacks. When Fatima shows up at school that morning, she leaves the house at 4 or 5 a.m. and she just essentially waits, does circles until school opens up. She testified about that. And as soon as school opens up, she goes in. That's where she goes. She doesn't go somewhere else. She doesn't get on a bus to Disneyland. She doesn't do something else. She goes to the school. And defense counsel says she went straight to Isaiah. She ran straight to Mr. Thomas. That was her first period teacher, also Isaiah. That's where her safe people were in that class. She goes to her first period class, to her safe people, her safe adults. And she talks to Mr. Thomas first. Remember, Mr. Thomas calls Isaiah out of class. Mr. Thomas goes and gets her snacks, brings them out to her, and then sends her to go see the counselors. And that's where she spends the rest of that day. She knows these adults, she trusts these adults, and her parents know that about her. We tell our kids to tell someone when they don't feel safe. We tell them to find a safe adult. Tell your teacher, tell your counselor, tell someone outside of your home. And that is exactly what Fatima did on October 18th of 2024. She has been characterized throughout this trial as just an angsty, bratty teenager who just didn't want to go on a family trip. That could not be farther from the truth. She did not just want to hang out with her boyfriend. She showed up, she flees her house, she hides, she goes directly to the school, she tells the school that she needs help. What evidence is there that the things she testified about on that day were a lie? What about that video that you watched, we've now all watched repeatedly, was a lie? Was there anything about that video that she said didn't happen, that was a lie that you saw? I submit to you that there was not. Fatima said she was not safe. That's what she said. I didn't feel safe. I don't feel safe. I told the school I didn't feel safe. Isaiah knew I didn't feel safe. 6.5 hours later, her parents showed up and proved she was correct. So where is the lie in that? She was most certainly not safe. I'd ask you to return the verdicts of guilty. Thank you.
Thank you. Members of the jury, in just a moment, the bailiffs are going to come forward and lead you back to the jury room. When you return to the jury room, the 2 alternate jurors who are remaining will take their belongings.
Okay, just talk about hearing, because he's
All right, so I'm gonna try to find us something else to watch in the meantime, in between time for the next 45 minutes. We were trying to watch this Judge McBurney trial. I know it didn't end it, and they didn't render the judgment on this by now. But we couldn't get past the first day well, I can't even get it out, child. We could not get past the first day at all. Let me see if I can refresh it. Okay.
I believe you testified that what you observed was consistent with you believed somebody being pursued.
So that he didn't observe anything. He's made that very clear.
You can observe all
okay. Just talk about hearing, because he's pushing back on the what did you see or perceive in that way. So
the activity you believe you heard occurred in the area of the vacant lot that at the time was not vacant, correct?
The initial shot seemed to come from a direction not exactly at the building that's no longer there. It was more south of there, up the street toward Lawnmower Man's house. Was it at Lawnmower Man's house? I can't say that. In my room, the Lawnmower Man's house is to my right. That sounded like the first shot was out there. Whether it was directly at Lawnmower Man's house, I can't say that. But it was out there in that general direction. The scream and then the second shot sounded further down toward the lot where the tape is.
and that's also towards the Exxon station.
Yes.
Okay.
That's north. The road is north, south, east, and west.
Right.
I appreciate you being here. I don't want to belabor your visit.
Oh, I'm fine.
Are we, to what degree of certainty do you have that the 2 shots were not simultaneous, that there was distance between, temporal distance between the 2 shots? Are you certain there was one, then a space of time, then another shot, or bang, bang, execution style? Are you thinking distance? Is that what you're testifying today?
Yes. it doesn't take a rocket scientist to figure out the distance between bang, bang and bang, bang. I would like to say something else, if I may.
You can only respond to questions, so if there's not a question, then you got to keep it inside.
Okay.
All right? Mr. Abate, may Mr. Campbell be excused? All right, Mr. Campbell, thank you for your time. Appreciate you coming down here.
You're welcome.
All right.
Thank you for an interesting period.
You're welcome. All right, get yourself carefully off, though. Take care of those photos. That's evidence in the case now. Yep.
Ladies and gentlemen, it's been a pleasure.
We are going to take our lunch break now. This is your first lunch break during the trial. We're going to try to keep it to an hour. So I don't know what your timepieces say, but on that clock, it'd be great if we could be back a little before 1:30 to keep going with the state's case. I've alluded to tomorrow being a little different a couple times, and here's what's different. Because I have another court that I do every other Wednesday morning, we're not going to be starting until 12:30 tomorrow. So you should have lunch, brunch, whatever you do before you get here. We're not call the state's next witness, please. Mr. Rao.
State calls Officer Quinn, Johnny Quinn.
President, raise your right hand. Please swear affirm that testimony you will give is the truth, the whole truth, nothing but the truth, so help you God. Yeah. Lord, I see you.
Hey.
Does the state spell your name for the record?
Name is Johnny Nguyen, JohnnyNguyen.
Good afternoon, Officer Quinn. If it's not somewhat obvious, would you mind telling the jurors where you're currently employed?
I am a police officer for the Atlanta Police Department.
How long have you been officer with the Atlanta Police Department?
About 7 years now.
And what is your current role within the Atlanta Police Department?
I am a patrol officer.
What is the job duties of a patrol officer with APD?
I answer 911 calls.
And in response to 911 calls, what sort of calls would you be responding to?
And it could be anything. It could be from domestic calls, from disputes in progress calls, from larceny calls, any kind of calls,
Food shots fired calls?
and shots fired calls.
In your time as a patrol officer with the Atlanta Police Department, have you responded to shots fired calls?
Yes.
And in your time with the Atlanta Police Department, where have you specifically patrolled?
So I patrol zone 1, that would be West Side Atlanta.
And throughout the tenure with APD, have you specifically patrolled in the area zone 1?
Yes.
Now, in your time as a patrol officer, let me ask you this. What is a signal 25?
Signal 25 is shots fired.
And you testified previously that you responded to plenty of shots fired calls. I'd like to turn your attention to the morning of February 5th, 2024, during the morning hours. Did you respond to the area of Chappelle Road and the intersection of Chappelle and Donnelly Hollowell in reference to a signal 25 shots fired call?
Yes, I did.
Do you remember what time you responded?
I can't really recall. It was really early in the morning, or I think maybe around 6. It was very dark outside still.
Let me ask you this. In your experience as an Atlanta Police Department, responding to specifically 911 calls, is there something that's called a CAD report that's generated in association with a 911 call?
Yes.
What is a CAD report?
It details what the 911 call is for and telling us the location And
provide you with the time in which the call was placed, the time that you would have been dispatched to, or any officer would have been dispatched to a particular area, who called, what the number was, things of that nature?
yes, it'll give us a caller, phone number. Sometimes they remain anonymous. But then also it gives us a place, location, time the call was made, time officers arrived.
I'm gonna approach you with what's been pre-marked for identification purposes, State's Exhibit 5. And for the record, Your Honor, the state seeks to admit State's Exhibit 5, which is the CAD report associated with Officer Quinn's call, which has been authenticated with business records, etc.
Any objection to States 5?
I'd like to see it.
That should happen first.
Right, I'll get you later. And for the record, Your Honor, this has been turned over. Thank you. No objection.
5 is admitted.
So Officer Quinn, in reference to the 911 call that you responded to in the morning hours of February 5th, 2024, was a 911 call placed in reference to what's codified as a signal 25 at 6:38 a.m.?
Yes,
Is that when the 911 call would have been placed by the 911 call?
it says dispatch received at 6:38. So yes,
And were you the officer that responded in reference to that particular 911 call?
yes, yes, I was.
Were you with anyone?
No, I was driving in the car by myself. So
And when you proceeded en route to that location, what is the time that you made your way over to that incident location? Not the time that you got there, but the time that you made it.
So call came at 6:38. I was dispatched at 6:41.
What time did you arrive on scene in that area?
6:46.
Now, at the time, signal 25 shots fired, what are you looking for typically?
I am looking for any victims, injured victims, and I'm also looking for any shell casings and possible witnesses of a suspect.
Is that typically what you do in reference to any signal 25 call that you respond to?
Yes,
Now, with respect to this particular one that you responded to on February 5th, 2024, were you operating a patrol vehicle?
yes,
Okay, and arriving on the scene, did you get out of that patrol vehicle to canvass this particular area to look for any potential evidence of a signal 25?
yes.
And what time of, how would you describe the lighting conditions to you in particular as it relates to what you were able to observe?
It was very dark, still very dark early in the morning. Can't see anything.
Do you see any individuals that you were able to interact with or anything that led you to believe that there was any indication of a signal 25 in that area?
No,
So after not encountering anybody and not seeing anything with your own two eyes, given the lighting conditions, how long did you stay there on scene to attempt to discern whether or not there were shots fired that you were able to observe?
so it says I closed this out at 7:09. So I arrived at 6:46 and closed it out at 7:09. So that's almost 20 minutes.
So for approximately 20 minutes, were you on scene attempting to locate any individuals that you could speak to or any indication of shell casings or any other evidence that you might have that would lead you to believe a signal 25 that occurred there?
Once I get there, because that intersection had 2 gas stations. So I just went inside the gas and nobody was in there and talking to witnesses if they heard anything or seen anything, but no one saw anything.
So you weren't able to discern the approximate location of where that signal 25 may have occurred in
Right.
relation to the 911 call?
Right.
So after 7:09 a.m., what did you do after that?
Heading to the next call.
And at at some point in time thereafter, or shortly thereafter, did you return back to that specific location that you initially had responded to in reference to that signal 25?
Yes, I did.
What was the reason that you were responding to that location?
I believe another officer, he was heading to a call, but then he saw fire and EMS at that intersection behind the gas station. And they indicated to us that there was somebody back there laying in the grass field. So I came to back him up.
And when you arrived on scene, what did you observe?
There's fire, EMS, they checked on the person and he was deceased.
Now, at the second point in time in which you respond to that location, are you the first Atlanta police officer that's on scene, or are there other police officers on scene by the time that you get back to that location?
There was already another officer on scene.
What was your job duties at that point in time when you responded to that particular scene?
We secured the scene and we put crime scene tape up, make sure no one's coming inside of the scene anymore, and notifying my supervisors.
What was the point of setting up crime scene tape at that point in time?
Well, when there's within protocol, the Atlanta police, when there's a death and we're not sure how it happened or anything, for investigation purposes, we don't want anybody getting inside the crime scene, contaminating the scene or anything while we're still investigating.
So after doing that and notifying your supervisors, what is the job description or role of a responding officer at that point in time in a particular scene such as the one that you responded to?
So after I've called supervisors and everything, now I'm raising homicide detectives.
And are you staying on scene, or are you doing that from afar?
I'm staying on scene, but I'm outside of the crime scene tape, making sure no one enters.
And how long would you say you were at that particular scene for?
Maybe 2 hours.
And that would include the time that you first got there after you saw EMS to the time that you got.
Yes.
And what specifically, in addition to what you've already told us that, as far as what you did on scene, what else did you do?
I can't remember if I started a crime scene log or not, but that's just to indicate every person that comes onto the scene and comes inside of the crime scene. I'm just holding the perimeter, make sure no one's coming in to contaminate it. But there was another call down the street that was early on. And when one of my officers was there, the first primary officer was there, when he noticed the decedent, he recognized him from a call way before. And he told me that this individual is.
Without getting into what he said to you.
Okay.
Because we just want to get from your particular observations.
Okay.
When you stayed on scene, did you stay at the area where there was crime scene tape, or did you go to a different location within that general area?
I did walk down the street.
What was the purpose of going down that street?
There was a house on Chapel that called in about someone breaking into their car and that they had someone restrained waiting for police to come.
And so, responding to that particular scene, did you see any evidence of that at that point in time?
I did not see the car that was in the CAD system. I didn't see the car in the driveway, and no one answered the door. So,
Did you personally knock on the door?
yes,
Were there other officers with you?
I believe so.
And after that, did that conclude your particular response to that scene?
Yes.
And did you enter into, did you go back into service at that point in time, or was that the end of your shift?
I honestly can't remember.
Do you remember around that time back in February 2024, were you day watch, morning watch, or evening watch?
I was day watch.
What are the typical hours for day watch?
I was working from 6 a.m. to 2.
6 a.m. to 2 p.m.?
2 p.m.
Okay. Thank you, sir. I have no further questions.
Mr. Bass.
Thank you, Judge. You received a dispatch regarding a 6:38 911 call of shots fired on February 5, 2024, correct?
Was it February 5? Yes.
When you arrived on scene, your eyewitness testimony is that it was very dark outside, correct?
Yes.
Dark enough where you could not distinguish features of people walking, correct?
I believe if somebody walked up to me, I would be able to see them walking towards my way.
How close?
Maybe from 25 feet away walking towards me, I would be able to notice. I could hear footsteps and everything. I could see people.
I'm trying to gauge what it looked like. You were there, we weren't. Outside of your patrol car, the illumination from headlights, inside lighting, it's dark. How are you being able to distinguish somebody walking up to you? What light are you using?
Well, yeah, it's dark outside. I'm in my patrol car with my screen illuminating into my face. I guess you're right. I wouldn't be able to see anyone. I don't know.
So without your screen illuminating your face, you would not be able to see anyone. That's what you're saying?
You asked me that again?
What did you just say? I'm sorry. Can you repeat what you said?
With me being my car, the outside setting being dark, my car being dark, and the screen is illuminating in my face, I guess I would have not seen people walking from a distance coming up to me.
Thank you. And is it reasonable to say you got there after 6:38? It's getting lighter as the time increases. So before 6:38, at the first 911 call, it would have been even darker, meaning even harder to distinguish people, correct?
Correct.
You were working Zone 1 on February 5, 2024?
Yes.
Is that the area that law enforcement attributes to the area that includes the Donald Hollowell Chapel Road intersection? That's within that description used by Atlanta Police, correct?
Yes, it's within Zone 1.
Zone 1 has, at that time, I don't know if it still does, but at that time, numerous Signal 25 shots fired calls, correct?
I wouldn't be able to know to tell you that. Like that day.
How often, roughly per week, did you get a shots fired call? Early last year, January, February, March, in that time frame? 10 times a week, more?
Off of experience, maybe 2, 3 a week, maybe. During the hours I work.
And that's you personally?
Yes.
So other officers would also be receiving?
No. It's when a shots fired call come up, whoever's available, we all try to go together and try to help each other out. It's a high call.
But on February 5, 2025, you left a secure vehicle. You deliberately placed yourself in a non-secure setting without cover in the dark investigating a Signal 25, correct?
Yes.
Why didn't you wait for backup?
Short staff. There is no time for waiting. Shots fired call come up and we're short staffed. Someone could be hurt out there. So then got to get there.
Yeah. That may be heroic, but it's not good for your safety. So I commend you. That's heroic.
Thanks.
During your investigation of the shots fired call, based upon your experience as a law enforcement officer, your post-certified training, your wisdom and knowledge, you found it significant and important to go inside of each of the 2 service stations on the corner at that intersection to see if there were witnesses, correct?
Yes.
Would you expect a detective taking over the homicide investigation to have done the same thing?
I'm gonna object to being argumentative.
Would it be proper police procedure for a homicide detective to get statements from all available witnesses?
I'm gonna object to lack of foundation.
Would it be
There's
proper
no
for a
indication.
police officer?
He's changing his question.
Would it be proper for a police officer investigating a crime to get statements from any witnesses in the area of the crime?
If there's any cooperating witnesses,
How would you know if a witness is cooperating or not unless you sought the cooperation?
I don't know how to answer that.
How could you ask a witness to cooperate without first ascertaining the possibility that the witness may be a witness?
Someone can walk up to us and tell us that they saw something or heard something.
Did you notice surveillance cameras inside of the Exxon station?
I can't remember.
If there were, would it have been important to check those cameras to see who was in that area immediately before the incident?
Yes.
Do you know if there were surveillance cameras on the front side of the Exxon station?
I wouldn't know. I don't remember.
If there were, would it have been important to have gotten the footage to ascertain witnesses who may have been cooperating or may have been assailants?
Yes.
If there were cameras on the east side of the Exxon service station, would it have been important to get the footage of the east side cameras to see if there were witnesses who may have cooperated in the investigation?
Yes.
Why did no one respond to the first 911 call that was placed from 516 Chapel Road, the automobile break-in? Why did nobody respond to that?
I'm gonna object to speculation. There's no foundation laid.
Do you know of any police officer who responded to the first 911 call at 6:03 at 516 Chapel Road?
No.
You spoke to another officer who indicated to you that he was familiar with the deceased Cordelia Skelton. Yes, the deceased Cordelia Skelton. Do you recall that?
Yes.
Who was that officer you spoke with?
Officer Pitts.
Adrian Pitts?
Yes.
Have you discussed this case with Officer Pitts this week?
Yes.
How many times?
Oh, just one time.
When was that?
Yesterday.
You called him, he called you?
I believe I called him. We were both supposed to show up for court today.
Did he say anything about being under subpoena by me?
No.
Without telling us what he said, did he tell you how he was familiar with Cordelia Skelton?
Yes.
Thank you. Nothing further.
Mr. Rao, anything else for Officer Nguyen?
I swear you got a tough job, right? So that morning when you responded and you got out of your vehicle, what were you using to make observations, if any, of any particular evidence of the shots fired call?
I have a flashlight.
Did you operate that flashlight?
Can't remember.
Okay. And to your knowledge, after getting out of the vehicle, did you notice anyone at any distance coming up to you or on that roadway on Chappelle Road, walking in that area that you ultimately found the deceased bodies.
No, I don't think I made any contact with anybody outside.
Is there any reason you wouldn't have been using your flashlight to look around? I know you don't remember specifically, but it was a long time ago. But is there a reason like, hey, I was being stealth investigator, so I'm going to be in the dark or?
Well, if it's a shots fired call and the assailant's possibly still out there, I don't want to display myself out in the open. Or simply, I can't remember, maybe the battery was dead.
Okay.
So,
And then you indicated thereafter that you went to the gas stations just up the corner to locate any potential witnesses. And correct me if I'm wrong, your testimony was that no one provided you with any information or any indication that they were a witness to the shots fired call. Is that correct?
correct.
Is that because you asked?
Yes.
And after that, you returned on scene and assisted the other responding officers with the deceased individual's body and maintaining crimes. Is that correct?
Yes.
I have no further questions.
Anything else, Mr. Bass?
No.
Jurors? What happened to your wrist?
Car accident.
On the job?
Yeah. Trying to respond to a call. Someone ran me off the roadway.
Thank you. All right, counsel. Officer, wait right there. We'll be right back. And the interpreters here, can we do? Officer Nguyen, let's start first with body cam. Would you have had a body cam on you that early morning of February 5th, 2024?
Yes, sir.
What makes it start recording? or is it always recording?
So it's in buffer mode, so it's on, but for it to start recording is either I turn it on myself or my lights and sirens turn on in my vehicle, or if I draw out my weapon.
Okay. When you would have been walking down the street that morning doing the searching that you were doing, would the body cam have been recording things?
Yes.
Okay. You explained to the jury you were actually at the scene twice. Is that correct?
Yes.
What time did you come back to the scene after you closed out your first? You responded to the signal 25.
Yes.
And you clear that, can't find anything, you leave. When was it that you came back?
Well, I can't remember. When I came back, it was broad daylight, so you can see everything now.
But it wasn't 2 minutes later.
No, it wasn't 2 minutes later.
By then, you didn't need a flashlight to see what was going on.
Right.
Okay. And when you were there the second time, were you also going up and down a street looking for things, or what was your role at the scene when you came back?
So on the second time, like I said, I create the crime scene, make sure no one's entering the crime scene, and basically hold it down until homicide units come.
Okay. And does that mean you were walking on Chapel or on Donnelly Hollowell, or where would you have been moving around to create the crime scene?
Chapel.
Okay. And did you put up crime scene tape, or would that have been a colleague who did that?
I believe it was me and the colleague. We were the first two there, so we put it up.
And that colleague was?
Officer Pitts.
All right. Mr. Rao, any other questions for Officer Wen?
Officer Quinn, you indicated that you were operating your body cam footage at that particular time. Is that correct?
Yes.
Your Honor, I believe the body camera footage has been authenticated under this record's exception. So with respect to Officer Quinn's body cam, the state seeks to admit it under State's Exhibit 82.
States 82. Okay.
I would object to any footage not at the actual location as being not relevant.
So what we'll do right now is admit 82. I don't know if that is an unbounded 6 hours of body cam. And that can be made part of the record in terms of what jurors will be able to view. We'll certainly circumscribe that to pertinent parts of the recording. So not 3 hours later or conversation had back at the precinct, but things related to visit 1 or visit 2. I think I'm granting your request. I suspect Mr. Rao's not going to play 6 hours of it right now.
No, Your Honor, it's a 17-minute clip, and I'm pressing play at 6:40.
So before you publish it, I don't see anything on the screen yet anyway. Two things. One, I will admit States 82, which is Officer Wen's body cam footage in toto. It's admitted for the record. In terms of what is published and available during deliberations, we can sort that out later. Number two, ladies and gentlemen, this is where the technology works least well in the courtroom, is when we're trying to play the video. Photos usually come up pretty well. Audio works all right. So it's not user error if it's choppy or you see the mouth move and the audio doesn't come for 3 seconds. That is your taxpayer dollars not at work in this courtroom because they don't get us good Wi-Fi connections, et cetera, et cetera. So I apologize on behalf of both sides.
So we're having some technical difficulties, Judge. So given the fact that it's admitted, we'll select to play it at a different time.
Okay, assuming you can figure out how to do that. And I don't mean you personally, but we can make the system work. All right. Anything else for Officer Nguyen?
Not from the state.
All right. Mr. Bass?
Yes, the state officer Nguyen has what purports to be footage from your patrol vehicle where I can see your laptop headlights, so you're inside the car. That's what they're looking at. Is there in existence footage from when you get out of the police car? You're now not illuminated by the dashboard of your laptop. So we can see what you saw on February 5th. You have body cam footage when you get out of the police car and you're looking around at that time. Have you ever seen that? Do you know if it existed? First question.
Yes, it should exist.
Second question, did you ever produce it to the state?
I was never asked for any videos or anything.
So you're clear, jurors, body cam doesn't come from individual officers to the state. So that's not the way it works. I'm not saying the state ever got the body cam, but they don't say, Officer Nguyen, we need your body cam. Officer Nguyen, when you're done using your camera for the day or the week, you dock it somewhere and what happens?
We dock it at the precinct and it just uploads into our evidence.com.
So there's a server that contains whatever your camera recorded each day.
Yes, sir.
Okay. If you have it on a thumb drive, we can play it from here. If you don't have it on a thumb drive yet, we can do it at another time.
We'll let you do it another time.
Okay. All right. May Officer Nguyen be excused.
Yes.
Thank you, sir, for your time.
Thank you, Your Honor.
The next witness needs to be Mr. Jaimes.
Yes.
Great. Ladies and gentlemen, the state's next witness, and I'll let Mr. Bate state his name in a minute, is requiring the use of an interpreter. We've got an interpreter here. Once the witness is here, I'm going to swear him in, and the actual evidence is what the interpreter says, not what the witness says to him in Spanish, but what is translated into English by our translator. Okay? When you're ready, Mr. Bate.
They call Mr. Saul James.
Okay. And Mr. Bernal, if you'll come on up here, please.
And interpreter just introduce himself as interpreter.
Please do.
Bueno, mi nombre es Juan, yo soy el intérprete de hoy. Muy bien. Bien. ¿Cómo estás?
We'll do. I'm going to swear the interpreter in first. Do you want to swear the interpreter in? You do it? All right, Mr. Bernal. Raise your right hand. Do you swear or affirm that you will translate from English to Spanish and Spanish to English faithfully and to the best of your ability?
Yes.
Great. Can you ask Mr. James or Mr. Jaimes how he pronounces his last name?
Sí, James, ¿cómo es que se pronuncia su apellido? James. James.
All right, Senor Jaimes, would you please stand up
James, póngase bien.
and raise your right hand?
Y levante su mano derecha.
And the interpreter will be translating the English into Spanish for you. Even if you understand the English, please wait for the interpretation before you answer.
Y el intérprete le interpretará a usted del inglés al español. Y si usted entiende inglés, por favor, espérese a que se le haya interpretado lo que ha sido dicho. Muy bien. Ok.
Great. You're up.
Levante su mano derecha. Usted jura o afirma de que el testimonio de la será la verdad, completamente la verdad, y sin omisiones, y declarar con la ayuda de Dios. Sí. Yes. Gracias. Puedo tomar siempre. ¿Podría decirnos su nombre y deletrearlo para que conste en las cartas? Sí. Yes.
Saul James.
Saul James. Sí. Yes.
Can you spell your last name, please?
¿Podría usted, por favor, deletrear su apellido?
Sí. ¿En inglés o en español?
Yes, in English or in Spanish?
You can say it in Spanish and the interpreter will say it in English.
Usted puede decirlo en español y el intérprete lo interpretará al inglés.
Ok, James.
Ok, James.
Okay, can you spell that?
¿Podría deletrearlo?
J.
J.
A.
I.
N.
N.
J.
J.
J. A.
A.
I. M. E. S.
E. S.
Thank you.
Gracias.
Mr. Abate.
Hey, good afternoon.
Buenas tardes.
You told me James.
Usted dijo, James. Yes.
Okay. Now, can you tell the jurors, how old are you, sir?
Muy bien, ¿puede decirle a los juristas qué edad tiene usted?
55.
55.
And can you tell the jurors, where are you from?
¿Y podría decirle a los juristas de dónde es usted?
De México.
From Mexico.
Okay. And can you tell the jurors how long have you lived in Atlanta?
En Atlanta,
¿Podría decirle usted
Ajá.
a los juristas por cuánto tiempo es que usted ha vivido en Atlanta?
por 29 años.
For 29 years.
Okay. And yes, you and I have spoken before. Is that right?
Y pues usted y yo hemos hablado previamente. ¿Es eso cierto?
Sí.
Yes.
Can you tell the jurors when you and I spoke, did we speak Spanish or did we speak English?
¿Podría usted decirle a los juristas cuando usted y yo hablamos, si es que hablamos en español o hablamos en inglés?
En inglés.
In English.
And do you, in the time that you and I spoke, did you understand what I was saying or the questions I was asking?
Y las veces que usted y yo hemos hablado, usted entendió lo que yo estoy diciendo, entendió las preguntas que yo le hice.
Sí.
Yes. And at any point, if you ever had difficulty, did you alert me or did you let me know?
¿Me lo hizo saber, me alertó acerca de eso?
No. ¿Cómo de qué? ¿De problema?
No. No, like, what do you mean, like a problem?
So if I said something you didn't understand, did you tell me you didn't understand?
Si es que yo llegué a decir algo que usted no entendió, ¿acaso usted me hizo saber que no entendía?
Yo entendí todo.
I understood everything.
And when you're at home, can you tell the jurors, do you primarily speak to the people who live in your house, your family members, in Spanish or English?
Usted habla principalmente con la gente que vive usted ahí en su casa con usted, es decir, su familia. ¿Usted habla principalmente con ellos en inglés o en español?
En inglés.
In English.
Okay. Now, can you tell the jurors, what do you do for a living?
¿De qué trabaja usted para ganarse la vida?
Construcción.
Construction.
And can you tell the jurors where you live?
Usted decirle a los juristas, ¿dónde es que usted vive?
En 503.
At 503
Chapel Road.
Chapel Road.
Okay. And how long have you lived there?
¿Y por cuánto tiempo es que usted ha vivido ahí?
Por aproximadamente 3 años ahí, pero la casa la tengo por 15 años.
For approximately 3 years living there, but I've had the house for like 15 years.
Okay. So it's fair, you've owned the house for 15 years, but you've only lived there for the last 3?
Entonces usted ha sido el dueño de esa casa por 15 años, pero ha estado viviendo ahí por los últimos 3 años.
Sí.
Yes.
Were you living there last February 5th of last year, 2024?
Febrero del año pasado, febrero de 2024.
Sí.
Yes.
Now, let's see. Now, on the screen before you, it states Exhibit 7. Is that the street that you live on?
Y
Can you?
en pantalla, frente a usted se nos aprueba del estado número 7. La calle sobre la cual usted vive.
Sí.
Yes.
Okay. And can you point to the jurors? Is your house going to be on the left side of the street or the right side of the street?
Y usted podrá mostrarle a los ojos está en el lado izquierdo o el lado derecho de la calle.
Derecho.
Right side.
Okay. And could you put an X on the screen where it would be?
¿Podría usted
I
poner
think you need to fire that for him.
en pantalla con una X indicando dónde es que usted vive?
Pero lo digo mal.
Tell him he can touch the screen and with his finger, he can draw the X.
Well, I look a little bit further down.
Okay.
Usted puede tocar la pantalla con su dedo y tachar una X.
No, pero más para acá de este lado.
No, but it's a little bit further down on this side.
No puedo mirar la cosa.
I can't see that. I can't see the house.
Okay. So your house would be on from looking at the screen where you put the X on the right side of the street, but it's further down outside of the frame of the picture.
Entonces, nosotros, al ver aquí la fotografía, usted indicó de que su casa está a la derecha,
pero su casa no está en vista de la cámara.
No, no está en la cámara.
No, you can't see it in frame, within the camera frame.
Okay.
Is your house closer to the Exxon station or the other direction?
Yo, su casa está cerca a la gasolinera Exxon o en la otra dirección.
See that red roof at the end of the street? That's the Exxon station.
¿Ve usted el techo rojo? Es la gasolinera.
Is your house in that direction towards the red roof, or is your house in the opposite direction?
Su casa queda en esa dirección, en dirección de la Exxon o en dirección opuesta.
Del lado.
On this side here.
Okay.
Okay. So would you say, Mr. James or Mr. Hamid, that your house is closer to where this red and white State's Exhibit 7 is?
Usted diría de que su casa queda más cerca aquí, al pie de la página donde se muestra el enumeramiento de la prueba del estado número 7?
Sí.
Yes.
Okay. And do you have neighbors, sir?
Señor, ¿tiene usted vecinos?
Sí.
Yes.
And I want to show you, it's already been admitted as evidence, State's Exhibit 37.
Y permíteme
State's Exhibit 37?
traer la locación para la prueba del estado número 37. ¿Puede verla? Sí. Yes.
Where is this house in relation to yours?
¿Y dónde es que queda esta casa situada en relación a la de usted?
The courtroom with their counsel and counsel for the state. So we are back from our lunch recess, and I would like to colloquy with Mr. Robinson about whether or not he has chosen to testify. Have you all had sufficient time over this 1-hour lunch recess, and of course before, to make that decision? All right, Mr. Robinson, if you'll come forward here, sir, to this microphone and raise your right hand to be sworn. All right, Mr. Robinson, you of course have been present throughout the entirety of your trial, and you've seen all of the evidence and witnesses that the state is intending to introduce against you. Is that correct? And you understand, sir, don't you, that it's the state's burden to prove this charge against you beyond a reasonable doubt. That means that you do not have to prove or disprove anything in this case. Do you understand that? That also means that you do not have to testify, again, because you do not have to prove or disprove anything. You have the absolute right to remain silent. Do you understand that? On the other hand, of course, you also have the absolute right to testify if that's what you wish to do. Do you understand? Now, you have two very skilled attorneys whose advice you should listen to and consider. But at the end of the day, the decision about whether or not to testify or not testify is yours and yours alone to make. Do you understand that? That is, Ms. Kawas can tell you one thing, Mr. DeCoste can tell you another, but only Hakeem Robinson can decide if you want to take that stand and testify. Do you understand that?
Yes, ma'am.
If you choose not to testify, I will instruct your jury, as I already have in the beginning of trial, that in every criminal proceeding, a defendant has the absolute right to remain silent, and that at no time is the jury permitted to draw any inference of guilt on you exercising your right to remain silent. Do you understand that?
Yes, ma'am.
I would also tell them that the fact that you did not take the witness stand must not influence them in any manner whatsoever, or influence their verdict in any manner whatsoever. Do you understand?
Yes, ma'am.
On the other hand, if you choose to testify, you will take that witness stand, you will be sworn in to tell the truth, and you will be treated just like any other witness. You will be examined by your attorneys. You would then be cross-examined by the state attorneys. And if you have any convictions for felonies or crimes of dishonesty, then that fact would be able to be brought out against you to impeach your credibility. Do you understand that? And so that we're all on the same page, state and defense, does Mr. Hakeem Robinson have any convictions for felonies or crimes of dishonesty?
I believe he has a crime of dishonesty.
Okay. You have that judgment and sentence, and you've shown that to defense counsel?
I don't think I've shown it to them, no.
We know
Right, but,
I believe that's the only one, but I am aware of that.
okay, so you're not contesting that?
No.
All right, so let me explain to Mr. Robinson what that means is if you were to testify, The state would be allowed to ask you 2 questions. They would say to you, Mr. Robinson, have you ever been convicted of a crime of dishonesty? And if you are answering truthfully, you would have to say yes. Then they can ask you, how many times? And if you're answering truthfully, the answer would be 1. Now, if you say no, or I don't know, or hemming and hawing on that, they then would be able to actually introduce the certified judgment and sentence, which will indicate what the crime is for. Otherwise, they would never get to know. They're not entitled to know what the crime is for. Do you understand that process? Okay. Have you had enough time to consult with your attorneys about whether or not you wish to testify?
Yes, ma'am.
And have they answered all your questions to your satisfaction with regard to that issue?
Yes, ma'am.
Do you need any more time to consider your decision? Have you made a decision about whether or not you wish to testify?
Yes, ma'am.
And what is your decision?
Not testifying.
You're not testifying? Has anyone pressured you or threatened you in any way in order to get you to make that decision? Has anyone promised you anything in order to get you to make that decision? Have you made that decision freely, willingly, and voluntarily?
Yes, ma'am.
And is that a decision that you and you alone, Mr. Hakeem Robinson, is making here today?
Yes, ma'am.
All right, thank you, sir. In addition to having sat through the trial and seen the state's evidence, you've also gotten to see your attorneys cross-examine the state's witnesses. You've also gotten to see your attorneys present witnesses and evidence on your behalf. Is that correct? And are you satisfied with their representation so far?
Yes, ma'am.
Are there any other witnesses you wished that they would call that they haven't called?
Yes, ma'am.
And who is that?
Oh, I mean, no, ma'am.
Oh, okay. So you're satisfied with the witnesses that they've called on your behalf? Okay. Are there any exhibits or other items in evidence that you wished that they would introduce that they haven't introduced? Understanding the CAD report is coming in here in just a moment, so that will be introduced. Other than those items, anything else that you wanted them to introduce that they have not introduced? Okay. And again, you're satisfied with their representation? All right, sir, thank you. You may resume your seat. All right, then that being the case, when the juries come back out, I'll allow the defense to introduce that edited CAD report that I'd already ruled on. That will be defense exhibit number 4. So we have going to the jury, just so the record's clear, we have defendants exhibit 1, 3, and 4. And that is as to Mr. Hakeem Robinson. Okay, is that correct?
Yes, sir. And just so I'm clear, what was marked originally as 2 prior CAD report, which was not introduced to go back to the jury, that was then supplemented, not supplemented, but exhibit 4 is what is the redacted CAD.
Correct, correct,
Now we have exhibit 1 that's been moved in, exhibit 3 and 4, but we have no exhibit.
correct. All right, and then after the CAD report is entered, the defense will rest in front of the jury?
Yes, Your Honor.
Okay, so that we don't have to bring him out, move the CAD report in, rest, and then send him out again. Would you like to make your second JOA at this time?
Yes, sir.
All right, go ahead.
Allow Ms. Quas is making that. I don't know. Is the charge conference also happening before close?
Yes, it is.
All right, I just needed to have her. But I did want to stop the flow for it. I know Ms. Quas came in.
Okay, go ahead, Ms. Kawas.
Thank you, Your Honor. So at this time, with the defense for Mr. Robinson formally resting his case after presenting the witnesses that we did present, the standard at this time, as the court is aware, has changed. Prior to making this motion, the second motion, I do want to renew all previous motions and objections that have been made up to this point. At this time, the standard has changed in that no reasonable juror, based on the evidence that's been presented to this court, could find Mr. Robinson guilty
Okay, does the state wish to respond?
Not unless the court has any specific questions.
Oh, I have no questions. All right, I do acknowledge the standard has changed. At the same time, I also acknowledge that issues of witness credibility, as all counsel here well know, is an issue for the jury's determination. And whether they believe the defense witnesses or whether they believe the state witnesses is not for me to decide. That is for the jury to decide. So that being the case, I'm going to deny the second motion for judgment of acquittal. All right, then I guess we need to do charge conference then, so that when the jury comes out, we will, well, the state will let the defense rest in their presence. And let me just ask again, is there a rebuttal case from the state?
No, Your Honor.
Okay. And then we'll be prepared to go into closings, but then let's do charge conference now. And I'm going to begin with Whitaker, so I know Mr. DeCoste isn't here at the moment. So this.
Basically stands for the property. It's actually what is yellow key flag on Halliburton is Lena. And it basically states that when the defense calls witnesses that were on the state's witness list, we are allowed to comment on the fact that the state failed to call them and we had to call them instead, and in an attempt to tailor their evidence. Case law is clear. It is not in any way, shape, or form flagged in any way, so I'll send that to you. And then I'm also going to be making up Halliburton argument as to one specific witness, Raekwon Howard, and I just want to premise what I'm going to be arguing so everyone can have time to respond. Our argument would be is that we should be allowed to comment on the state's failure to call Raekwon Howard as a witness. He is a witness that is peculiarly within the control of the state. In that, if you recall, Your Honor, I filed a motion to exclude Raekwon Howard for his invoking his Fifth Amendment privilege during his deposition. You denied that motion, and then we came here, and the state failed to call him. We can't call him because he has several open cases in the state of Florida. I can't confer immunity on him. The state can, which would have allowed him to have been able to take the stand, answer questions without worrying about incriminating himself. So I am not in a position to be able to call him because I have not conferred immunity on him. I believe that this applies particularly just to this witness, because there is no way for the defense to be able to put him on the stand. So I will be arguing that Halliburton actually supports our position that we should be able to comment on the fact that the state did not call Howard because we are not able to.
All right, why don't you send me those cases so I can review them, but let me go ahead and begin, and I'll give the state an opportunity to respond, but let's begin with Mr. Whitaker's jury instructions, if we might. All right, so I did receive the latest draft version, and that's the version we're working off of. So both for state and Ms. Schlacks, on behalf of Mr. Whitaker, I like to go page by page, and I want to hear either consent or object to each page of the instructions, because as you know, one hard copy will go in with the jury during deliberation. So let's begin with the cover page. Any objection?
No, Your Honor.
No, Your Honor, unless I say something, I have no objection since I provide.
Okay, thank you. Next page begins members of the jury. Any objection?
No, Your Honor.
Statement of the charge. Any objection?
No, Your Honor.
Or charges, excuse me. Hold on, I'm not.
I agree with Mr. Mizrahi's suggestion. I do not think under the facts of this case that it makes sense to instruct on justifiable or excusable.
So you want those eliminated?
Yes, Your Honor.
Okay.
Agreed.
All right, so that entire highlighted area will be removed. And are you making these corrections as we go? Because I will need a clean copy of this.
And Ms. Bledsoe, our paralegal, is sitting in the third row. She is doing it probably faster and better than I can, because she corrected all the formatting errors that existed.
Okay, very good. Thank you.
Yes, we are doing it. We are both doing it.
Okay.
So it'll look like it is, and the court can look at the screen and see how it's going to look.
I don't have a screen that's showing me anything. It's not on my screen. Do I need to press a particular button?
Yeah, We all have it, yeah.
Okay, now it's on my screen. All right, then we have the instruction on murder in the first degree.
No objection as presented.
Okay,
We'll take away the highlighted or a principle.
Yes.
okay.
Just the highlight, not.
Just to highlight those three words in element number 2? Okay. When there are lesser included crimes or attempts, do you want to take away the word or attempts since that's not charged or focused here in the title?
No objection.
Senator, I think attempted first-degree murder should be part of it. Mandatory lesser included offense.
It's not mandatory. It is-
Not attempted.
Yes, we'd ask for attempted.
Oh, you did ask for attempted?
We would.
Okay.
Honestly, I did look these over. I honestly, that just went right over my head, but yes, I absolutely think that should be part of the instructions on the facts that are alleged by the state.
All right, I'll hear from the state on that.
Your Honor, there's no evidence that this is an attempt. The victim was killed at the scene by the act that would constitute the attempt. I think it's.
Yeah.
I mean, I just don't, I'm looking, my understanding is that the only mandatory lessers are,
Second degree and
second
manslaughter.
and man, which I've provided. We're going to look at it right now together.
Yes, it's not a category 1 mandatory lesser.
I would have to concede that it's not mandatory. In fact, I don't even see it as an option under category 2. Is there a second page, Alan?
Yes.
Okay, I will concede that it's.
Okay. So let's just remove those 2 words on the title of attempts or attempts. And so do you agree with second degree murder and manslaughter as the 2 lessers to be given?
Yes, Your Honor, I concede that I'm not entitled to that.
All right. And to the instruction itself, are you agreeable to that?
Yes, Your Honor.
Very good. All right, then we have the instruction for second degree murder that's covered on 1 page. Any objection?
No objection as viewed right now. You can take the highlight out.
All right, so we'll take out or principle under element number 2, and with that edit, any objection?
We're taking out the highlight, not or principle.
Correct.
Isn't that what's highlighted?
Yes. So she's agreeing to the highlighted part.
Oh, you are agreeing to it. Okay, all right, then leave that in. Is that also with first degree murder?
Yes, Your Honor.
Okay, I misunderstood. All right. Then on manslaughter on the next page, which is an instruction with 2 elements, any objection?
No objection to taking the highlight out and including the language or a principle as to the second element. Also, no objection to removing the justifiable or excusable homicide.
All right, so that's both a line in paragraph 2 and a line in paragraph 3. All right, very good. All right, then we have burglary with assault or battery in count 2. One thing I noted is there were some words missing in after element 2 in that first paragraph that says you may infer after the word crime there should be inside a dwelling. It just says crime dwelling. Inside a dwelling, correct. And then in the third big paragraph, you have and or, which is always problematic in jury instructions, and considering it's burglary with assault or battery, I would suggest that the and needs to come out.
No objection to that suggestion, Your Honor.
All right, well, I just need to find it.
It's in the third line of the third paragraph. So take out and, correct. Okay, with those edits, any objection from either side? All right. Then we have the principles instruction on the next page. And I had a question about this in terms of its placement. Is principle only applicable to the first degree murder case? Or the state's theory is it's as to both cases?
It's as to both.
Okay, so it will come after both instructions.
Yes, Your Honor.
And does the defense agree with that? I mean, I'm giving it either way, so.
Right, no, the placement I'm not concerned about.
All right, what about the language? Because there's some highlighted language in the principal's instruction. Because he could be a principal to the crime charged or to any of the lesser included crimes.
I would ask for lesser included offense to be taken out. I think it just is confusing.
But then would that lead the jury to believe that principal only applies to the crime charged and not to any lesser? Because it does apply to the lessers.
No, it certainly does.
What I think I would add, though, is instead of saying or lesser included offense as the evidence supports, since they're being presented with different lessers or any lesser, I would just add the word any before lesser on both of those sentences. That's my suggested clarification.
Well, and isn't the state seeking this for the burglary as well?
Yes.
So wouldn't you just want it to be, it is not necessary for a principal to know every detail of how a crime will be committed? Because before that.
Well, the instruction requires you to name the crime. Well, let me say required. It is a very strong suggestion, and it has in brackets that you have to name the crime charged. We can do a crime, if you all agree to that, but.
Now, this instruction does not.
Yeah, I understand what the point is.
Yeah, this instruction is only as to first degree murder, not burglary. So if the state's proposal is that it applies to both crimes, then we need to clarify this.
This part of the instruction deals with the concept of how the murder occurs, where burglary, the defendant has to have a conscious intent that the entry be done with the intent to commit a crime therein.
Right.
So the details of how that occurs applies really more to first degree murder than to burglary. I think we can fashion it with both. It's just, I believe this is a standard with regard.
Yeah, this is the standard.
I'm saying with regard to first degree murder. So I don't think, let me pull it up, but I do not believe that,
Yeah, you're right. This is a standard instruction for being a principal to murder, not necessarily to be a principal to a burglary.
that's the reason why I did it like that, because it's the concept, yeah. So it says for first degree, for murder.
Right.
Has that special, it says only, and it says in attempted homicide cases, or homicide cases.
Well, then
Although the next paragraph says that he doesn't know if it says it's not necessary for the principal to know every detail. So I think it's perfectly allowable and permissible for the court to say to know every detail of how the murder in the first degree or burglary with assault or battery were committed, or any lesser included offense, I think we can do it.
I'm fine with that.
It's just wordy.
Yes. Words that I'll have to say, but that's okay.
And obviously, I like instructions to be simple. I don't think this is an issue because the state's evidence is the defendant made entry, made the assault. So the principal theory, although applies to the burglary, is not nearly as important. So I don't think it's necessary to give the burglary, and we're fine giving the instruction that we gave.
So without adding the burglary language?
Adding the burglary and just
just
eliminating not the words, but the highlights. And I think we could put or any lesser included offense, or any lesser included offense. I think that's
Your
easy.
Honor, actually, I would request that final paragraph is not included, because it actually dictates that that paragraph is for situations where the criminal statute includes a higher degree because a firearm, deadly weapon, or weapon was carried during the commission of the crime. So it's trying to capture those situations where perhaps I conspired with Mr. Cooper to, do some kind of robbery. I didn't know he was going to bring a firearm. And so.
Can you pull up the instruction again? I thought it was a preceding paragraph.
I'm looking at the standards on the Florida Bar website, Your Honor.
All right, let's see.
I'll go ahead and read it into the record. Before that paragraph that we're discussing, it actually says, oh, well, the court can see it, it's on. And that's not the situation. There's no weapon alleged in the burglary. There, of course, is a weapon alleged in the homicide.
So what are you saying? Because the state has alleged 775 language involving a firearm in the indictment for first-degree murder, but they have not alleged that for the burglary. So that's what the state is saying. They're not going to include the burglary language in this instruction. They're willing to forego that, but since this is a first-degree murder and does involve a firearm and is charged with 775 language, I think it would be appropriate to give as a principle.
Okay, so I guess the only question at this point is how we deal with lessers.
Right, so the suggestion was, as is highlighted, I don't disagree with that. I think it makes sense to say, doesn't need to know every detail of how the first-degree murder or any lesser included offense as the evidence supports, or as the evidence establishes, or as the evidence justifies. Those are the languages used in the instructions otherwise. I think it's appropriate to say that because the principle theory would apply to second-degree murder and to manslaughter.
I would have to concede that it does.
All right. So if you will make those slight corrections, just add any, there we go. All right, thank you. All right, date of crime instruction, any objection? Next page.
No objection.
I'm getting there, I'm just making the corrections, right?
All right.
Others. I'd like to make.
Venue instruction, any objection?
No objection, Your Honor.
We have the standard plea of not guilty, reasonable doubt, burden of proof instruction, any objection?
No, Your Honor.
Weighing the evidence instruction. Number 7 and 8 are duplicative. 7 should be pressure or threat, not inconsistent statement. You put that in there twice accidentally.
Yeah.
But with that correction, I believe 6 applies, 8 applies, 9 applies. I don't believe there's been
Yes, Your Honor.
any testimony of reputation under 10 and actually no testimony on 7.
Your Honor, there was testimony in regards to 7. Mr. Barner was impeached by myself.
About being pressured or threatened?
Oh, I'm sorry, I thought.
Yeah, 8.
It's sort of inconsistent.
8 is prior inconsistent statement, and I will give that for sure. But what I'm saying is 7 and 10, I don't believe there's been any testimony to support the giving of those factors.
I concede on 10. I would ask, based on all of the evidence and the cooperation agreements that were in here, I think one could logically argue that Dominique Barner and Abdul Robinson Sr. do feel the pressure and threat of their pending charges. They've also received a benefit in order to testify that has to be considered, but their current situation, I would say that that is worthy of the jury's consideration when they're evaluating credibility.
All right, any response from the state, or you agree we can give 7?
I agree we can give 7, but I need to get the language right.
We need to get 7 corrected. All right, so 10 is the only one we're eliminating from the factors for consideration. All right,
Just give me, I know we want to go fast, but
okay.
I'm trying.
Something like, has any pressure or threat been used to?
I just want to get it directly from the.
Sure.
You have the language?
Yeah, he copied it from the standard.
Oh, my God. Oh, my God. Obviously, I didn't do it.
Maybe not.
I just read it. understand. Go ahead, read it. Read it.
Read it. Has any pressure or threat been used against the witness that affected the truth of the
Well, you
witness?
go way too fast.
Yeah, I don't think you can type that fast.
Oh, sorry. Had any pressure or threat
That,
been used against the witness
yeah.
That affected,
that affected the truth of the witness's testimony?
and it's apostrophe S on witnesses. Sorry.
No, that's not right. That's right. Right?
Okay, and did you eliminate number 10?
Did.
Okay, on that next page also? Oh, yeah, unhighlight those. All right, on the next page, the defendant becoming a witness, obviously he didn't testify, so you can eliminate that paragraph. The other thing I noticed on the paragraph beforehand, there's just some ors missing. So on line 2, you must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, or, right there.
And strangely enough, Your Honor, I only know this because it's also part of my PowerPoint, there isn't the word or.
No, but they're brackets.
Oh, so then you're.
So they're not ands, is what I'm saying. Yeah. And there's another or. Can you go back to that paragraph?
I can. The gallery was telling me what to do, so.
Oh. All right, so or has been promised immunity from prosecution or hopeable treatment in his or her own case. So before the word hopes, if you'll add an or.
Trying.
Huh?
Our Dell desktop is very,
It froze.
it locks up on us.
Okay. There you go. Did it unfreeze?
Okay.
And Your Honor, in regards to the next page, defendant not testifying, I agree, defendant not testifying.
Yeah, those are the two paragraphs I give.
I
Okay. We just need to unhighlight them as soon as we get there.
Okay.
Okay, yeah. So you agree to defendant not testifying instruction?
Yes, Your Honor.
Okay, next page, rules for deliberation. Those are the standard 8 rules. Any objection?
No objection, Your Honor.
Cautionary instruction, any objection?
No objection, Your Honor.
Notes instruction, any objection?
No objection. I apologize, though, there is one instruction.
On notes?
Single defendant.
Oh, that comes later.
Yeah, it's coming.
It does. Yeah, it's coming. Verdict instruction, any objection?
No, Your Honor.
Okay. Then we have the verdicts, and there are 2 of them. There's verdict count 1, any objection?
No, Your Honor.
Verdict count 2, the only suggestion I would make again is removing the and or. It should just be or on both of the special findings. Well, on one finding, and the other it says nor, it should just be or on both of
No
them.
objection to that change, Your Honor.
All right. Otherwise, any objection to verdict count 2?
It should say or nor.
It should be or. There's not a neither preceding it, so there shouldn't be a nor.
I got it.
Okay. All right. Then we have single defendant, multiple counts instruction. Any objection?
No objection, Your Honor.
Verdict and submitting case to jury instruction. Paragraph 3, I eliminate because I do not let them have cell phones, tablets, or laptops in the courtroom. So with that edit, any objection to that standard instruction? All right. And then, of course, I did receive from the defense the request to include the motion for independent act instruction. That's 3.6L in the standards. Any argument you wish to make?
Your Honor, just based on the facts that they have been produced by the state of Florida, alleged involvement in this homicide, the undisputed testimony has been that supposedly there was some kind of plan which in some way Mr. Whitaker acquiesced to, but then ultimately did not do it. Therefore making it the independent act of the actual shooter in this case. And I believe I cited to the court, if I didn't, I just made an error in the email. The case of Gary E. State, found at 330 Southern 3rd, 118. It is a November of 2021 decision from the 2nd District. And talking about, under their analysis, and in this particular case, the issue was a requested jury instruction, which was denied. And the court, in reaching their decision, talks about this discretion of the court is limited in criminal cases because the defendant is entitled to have the jury instructed on his or her theory of defense if there is any evidence to support this theory, and the law of the theory is recognized as valid under the law of the state.
Okay, I'll hear from the state.
Yes, Your Honor, the key word there is any. And the state is very cognizant of the fact that we should not have a reversible error based on jury instruction. However, there has been zero evidence that this was somehow an independent act. No one has testified that the defendant was a limited participant and did not contemplate what would happen. The independent act instruction has to accompany some piece of evidence, and here there is none. Otherwise, we would give the independent act evidence in conjunction with every time you give the principal instruction.
Right.
Not the state law.
And what is the evidence, Ms. Schlax, that you can point to that supports the giving of the independent act instruction? That said what specifically?
And I will somewhat paraphrase, but specifically in my cross-examination, Mr. Garner ultimately said that he was not aware. I'll start with, I guess, the absence of evidence. He was not aware of any statement that Mr. Whitaker ever made indicating a desire for Mr. McCormick to die, and any kind of statement even acknowledging the plan. His testimony was limited to, we all just knew. And then I actually brought out in cross-examination more than that his testimony is, well, I just assumed there were conversations before they picked me up. Everyone just knew what time of day it was. Then his only statement is at the apartment complex, he claims it was spoken about. He doesn't attribute any of those statements to Mr. Whitaker, but in a very general group sense, it was spoken about that when Charles McCormick walked out of his apartment, that Leroy Whitaker and Hakeem Robinson would both jump out of the car and actually ambush him. And he kept using the phrase, run down, I think was the phrase. He then indicates that they go to the complex. He says, again, there's no discussion. And then ultimately, he alleges Mr. Robinson jumped out of the car and ambushed. He doesn't speak about when this plan supposedly changed. He doesn't attribute any kind of statement or act by Mr. Whitaker. According to Mr. Barner's testimony, Mr. Whitaker is literally just...
Well, I think he said that Mr. Robinson got excited and jumped out ahead of time.
I don't know, but he doesn't attribute Mr.
Well,
Whitaker to anything.
At that point, no. But what about the burglary? Because you include this as part of the burglary. And the testimony from Ms. Buckley was that two people went in, both people assaulted her. And according to Mr. Barner, that second person was Mr. Whitaker. And of course, both Mr. Barner and Mr. Whitaker's DNA was found on her clothing or on her person.
I would concede this would be for me to even attempt to argue in regards to the burglary charge. But I do think, based on Mr. Barner's testimony himself, that he has provided us with ample ammunition to be entitled to this.
And Your Honor, can I say something?
Okay, one more thing, and then I'll rule.
Um,
Because your request did request it for both homicide and burglary, but now you're conceding this does not apply to burglary. Okay.
Everything that Ms. Schlacht just argued is arguing against the principal instruction. Is what the cross-examination against Mr. Barner is whether or not he had a conscious intent that the act be done and participated in some way in making that accomplished. Everything she just said. Independent act occurs when a person is a participant somehow in the crime, and when they participated in, let's just say, the petty theft from Walmart, and then the defendant goes in after a petty theft and decides to kidnap and murder everyone in the store that was not contemplated and outside the foreseeable context of the agreed upon plan. So the cross of Mr. Barner goes directly to whether or not the defendant is a principal, not that he was subject to an independent act.
All right, having read the Gary case and now having read this independent act instruction and recognizing that if there is any, as we learned, scintilla of evidence that supports a defense theory, the instruction should be given. I don't see that being the case here. I'm not going to give the instruction. All right, so that is denied. Anything else on behalf of Mr. Whitaker or the state in Mr. Whitaker's case? So let's get a clean copy of the instructions otherwise. Anything else?
No, Your Honor.
Okay, then let us move on to Hakeem Robinson's jury instructions. All right, who's going to be handling the instructions? I am. Okay. So similarly, as we just did with Mr. Whitaker, we'll go page by page. So tell me if you consent or object, the cover page. Members of the jury page. Statement of the charge. Then we have the introduction to homicide with justifiable and excusable.
I would agree that the instructions to justifiable and excusable.
All right, so we'll take out that entire highlighted portion.
Can't get anything. It's just glitchy.
All right, then we have the instruction on first-degree murder, which I think we need to remove the language or a principle on element 2. Okay, otherwise, any objection to that instruction? Then lesser included crimes or attempts. Again, I would suggest removing or attempts, but otherwise that would be the instruction and the 2 required lessers of second-degree murder and manslaughter. Okay. And the instruction on second-degree murder, just removing the or a principal language off element number 2. Any objection to the remainder of the instruction? Manslaughter instruction, eliminating the highlighted language of justifiable and excusable. Do you agree with that? I agree. Okay. All right. And with the rest of the instruction? Right, so let's remove that page altogether. Can you just move it up a page? There's a blank page, Mr. Mizrahi.
I can.
Okay, then we have date of crime. Can you just, on that, says the state must prove the crimes were committed. He's only charged with 1 crime, so let's just remove that S.
I got most of them. I missed that one.
Thank you. Venue instruction, any objection? Plea of guilt, of not guilty, reasonable doubt, and burden of proof instruction, any objection?
No objection. Is this the page, Your Honor, that you agreed when discussing Mr. Whitaker about the or?
No, this is not the page. This is just the standard one that I've read already. No objection? Okay, weighing the evidence, we have similarly 7 and 8 are duplicative. We need to add the 7 of pressure or threat.
Got it.
Okay. And would you agree that 10 does not apply? There's been no testimony of reputation evidence. Okay. But we'll give 6, 7, 8, and 9.
Yes, and I think I had the same problem, but I can see that Mr. Mizrahi is switching it out for the
inadvertently left out, yeah.
Just give me a second to catch up.
Why are you eliminating number 9? That was fine.
I was eliminating the,
Oh, okay, I got it.
just give me a second to cut and paste.
It does say has a witness been convicted of a felony, I would rather that it, include also a false statement.
I don't think we had testimony of anyone being convicted of false statement. Yeah, felony, yes, but not misdemeanor involving dishonesty or false statement. That's all right. We'll just have number 7 typed in.
I don't know if it's faster to do it that way or not, but
Yeah, that was
that's the way I
better.
did it.
Okay, we are on the next page of that same instruction. Oh, there we go.
Almost.
Almost. Okay. Moving along, similarly, Mr. Robinson decided not to testify, so we can remove the paragraph about the defendant becoming a witness. And then this is the page where we were adding the ors. So if you can do that in that 3rd paragraph.
That's in the you must consider the testimony.
Correct. There we go. And then the next instruction on defendant not testifying, any objection? No, no. Yeah. Yeah. Thank you. All right, we have rules for deliberation, any objection? Cautionary instruction, any objection? Notes instruction, any objection? Verdict instruction, we just need to do instead of as to each crime charged, as to the crime charged, since he's only charged with one offense. With that revision, any objection to this instruction? Okay. Then there's the verdict with the 4 options. Any objection?
Yes, Judge, the defense would request that since Mr. Robinson is presumed innocent unless he is proven guilty, that it should start with either jury find the defendant not guilty and then follow with that. So I would request that line be put first.
Okay, and I get those requests sometimes here too, that'll be denied. It's the state's burden, they have to prove the main crime charge, so we put that first. Thank you. And last instruction, verdict and submitting the case to the jury. Again, I don't let them have electronic devices, so paragraph 3 can be eliminated, but otherwise, any objection to that instruction? All right, that will conclude the charge conference. And if I can get, obviously, 1 clean hard copy of each and clean hard copies for counsel. I don't need to wait to have them before we start closings, obviously, but I do need them by the time we charge, which at this juncture might be tomorrow. I'm hopeful that we can get through all the closings today. If we can't, we'll see how we go. I don't know how long y'all are going to be, but I'm not going to charge them today and let them start deliberating at nighttime. So my hope is that we can do all the closings today, and then I'll bring them back tomorrow at staggered times to instruct them on the law. The state is going to give 1 joint closing, and then we'll excuse Mr. Robinson's jury for the defense Whitaker's closing and any rebuttal the state might make to it. And then I will excuse them for the day and tell them to be back here tomorrow at 9 o'clock. At that point, we'll bring in Mr. Robinson's jury, let the defense do their close, and the state can do any rebuttal to it, and then I'll excuse them and have them come back at 9:30 tomorrow where I can instruct them.
And Your Honor, Mr. Robinson and present during or it would just be Mr. Whitaker during her close and
I mean, y'all can stay here and listen if you want. Sure, I'm not saying you have to leave the courtroom. You don't have to, but
and I would leave it up to Ms. Schlatt if she would want my client to be out or.
okay. Well, if you're leaving it to Ms. Schlack, she can decide if she wants Mr. Robinson in the back or seated there, but the attorneys, of course, can stay. I don't have an issue or a problem with that. Yes.
Just so I can gauge, and I don't have to interrupt while the other attorneys are going, is there a time that Your Honor is thinking of going until, because it will let me know, like, I'm not going to be going today, or I am?
I guess I'll have a better indication of that after I hear the states. I mean, I have no idea how long you're going to go. We've been going till 6:15. I mean, I'm not keeping them here till 8 o'clock at night. So you know, we'll see. If we might have to go till 6:30 to finish it up, I don't mind going beyond 6 o'clock. Ideally, if we can put this all in, it's 2:30 now, so I would hope that in the next 3.5 hours, we could do all the closings that are necessary. I will say before closing, again, just so we can all be on the same page, and I know there's some additional matters that the attorneys raised, I do expect everyone to act professionally, civilly, and according to your rules of professional conduct. There shall be no name calling of defense counsel or the defendants. There shall be no denigration of defense counsel or the defendants or of the defense theory of the case. You all know what you can and can't say. There shall be no send a message arguments. There shall be no golden rule violations. There shall be no just what we call bad behavior. You all know how to behave. I expect you to continue to behave. While during the course of the trial, I did not allow, as we discussed at sidebar, any objections of improper, because certainly that's not a proper objection to evidence. That is a proper objection during closing. So if either party believes that an improper argument is being made, you absolutely may stand up and say improper. I do need grounds for an objection, so don't just stand and say objection. I need grounds, but improper is a proper objection during closing. Does everyone understand that?
Yes, Your Honor.
Yes, Your Honor. Yes, Your Honor. Okay. Anything else we need to address before we bring the jury out to commence with closings?
Yes.
Okay, let's start it in order. State?
I just need a moment to load up PowerPoint real quick.
Okay, that's fine. Mr. Whitaker? Okay, we'll do that. And Ms. Kawas? Understood. And so, Mr. Mizrahi, have you had an opportunity to read the Lena case? That's 901 Southern 2nd, 227.
I have not, Your Honor, and obviously the defense claims they've listed all these witnesses as well, so there's that.
Well, let me read the case and see if that makes a difference.
And certainly that argument should not be made to the unlisted witnesses.
Right, I think they said it was only to be made to regarding Raekwon Howard.
This argument is to, for example, Jarvis Roberts, Michael Williams, and the two police officers
Understood. That's what you meant, Mr. Mizrahi?
Yes, and
Okay.
there's a distinction. I'm glad that
For the sister.
there's a distinction between Howard and the state witnesses. Based on the Lena case, although I haven't jeopardized it yet, I believe that argument is permissible for them to say, these are state witnesses, they didn't call them, we had to call them.
Right, to witnesses that they call. What Halliburton addresses is witnesses that neither side calls, and the defense says, where is so-and-so? If they're peculiarly within the province of, or the jurisdiction of the state, right?
The only witness I think that falls into that category is witness Raekwon Howard. So Lena is only applicable to the cases that, the state witnesses that we call in our case.
Okay, understood.
And then for Halliburton, we believe we should be able to make that argument as to Raekwon Howard. He is peculiarly within the control of the state in that he currently has open cases with the state. He refused to answer questions in our deposition. We cannot confer immunity on them with any of our subpoenas, including a trial subpoena. So our inability, we can't call him as a witness. The only ones that could call him is the state because they can confer immunity on him to be able to testify in this case. They made a big deal about this witness. This is the incident where they, which came to our knowledge on the day that Barnett testified, that he is now saying, oh, there was this call to Raekwon Howard right before the murder, and he confessed to the murder. We objected to that being a discovery violation. We had no idea that he said, never mentioned that before. We, of course, now our hands are tied. We can't call Raekwon Howard to the stand to put him on to rebut that evidence in any way, shape, or form.
But let me ask you, and if I recall, because this is different than a prior motion to compel I had involving Dominique Berner and Abdul Sr., who refused to answer some questions, which you all certified. I had a hearing on. I determined they didn't have to answer those. With Raekwon Howard, along with Torgon Williams and Antoine McLaren, it was not a motion to compel answers. It was just a motion to exclude them as witnesses. I excluded Antoine McLaurin because other than provide his name, he would give no other information. So I excluded him as a witness. Raekwon Howard and Torgon Williams gave information, answered questions. When they invoke their Fifth Amendment rights is when I believe the attorneys were getting into the facts and details of their pending cases that would have implicated them. And what I said was certainly if they testify, the fact that they have pending cases is admissible, what the minimums, maximums are is admissible, facts and details of them, I was not going to compel them to disclose, nor would I exclude them for those reasons, but they did give answers to other questions. So I don't know if we have to parse out Raekwon Howard's testimony with regard to whether he's available to you or not, or whether he's peculiarly within the state's purview or not. But if it has to do with a phone call made in the car to him, alleged to have been made in the car to him by your client, I don't know that that comes under the Fifth Amendment right to remain silent. He did not invoke for that question. Okay.
So if you recall, when we did this motion to exclude, the main issue, and I actually brought this up, was normally we wouldn't be able to go into the facts and circumstances surrounding pending cases unless they're relevant. We've now established through the trial the relevancy since the state put on Natalie Gant as a witness who testified that Raekwon Howard tried to kill her and Torgon Williams months later.
I don't know that Natalie Gant testified to that.
He did, he came back across.
Okay, but how does that make the phone call in the car relevant?
So here's the
I mean, how is that relevant?
Because I shouldn't be, if I wanted to put him on, limited in the fact that, oh, I'm only going to put on his testimony about the phone call. I should also be allowed to explore, for example, the fact that he's an impeachment witness to Natalie Gant, because Natalie Gant wasn't the person holding the firearm, it was Torgon Williams. I would have not been able to go into that testimony with him because he would have then invoked his right to remain silent. It's unfair to say that, oh, well, you could have called him for the limited purpose of addressing the phone call. If I wanted to call him, I should be allowed to explore everything, including any bias that he may have or any reason to color his testimony. He would not, on the advice of his counsel, and that case is still open, would not answer, and it's not to the other open pending cases, Judge. That one is peculiar because it's him being accused of trying to execute two one of which testified. So I'm now in this weird position of, oh, well, you can put him on, but you can't go into all this stuff that the jury should know about him and what he did, and, just present questions on that limited issue.
How does that make him peculiarly within the purview of the state?
They can give him immunity and put him on the stand. I can't.
All right.
They could have given him just a subpoena. No promise of, hey, listen, we're not gonna do anything more than give you immunity, which is inherent in their subpoenas, just for the testimony here. Allow me to then say and be able to explore with him, you tried to kill Natalie Gant and Torrigan Williams, who are from opposing groups, which they made as an issue. But more importantly, too, Gant isn't the one that had the gun. It was Torrigan Williams. And she lied.
But doesn't the law preclude either of you, both of you, from putting a witness on the stand knowing that they are going to invoke their Fifth Amendment right in front of a jury at trial? Neither you nor Mr. Mizrahi would be able to call him as a witness knowing he was going to invoke on the specific facts of that pending crime that he has.
That's the thing, Judge. He doesn't have that liberty of just, well, I just don't want to. He has immunity. So what would happen there is the court would inquire and say, we have to compel him to answer the questions because it's not a legitimate assertion of a right. If the state is agreeing that anything you say won't be used against you. So you can't assert your Fifth Amendment privilege on your immunity. So that's where that makes him peculiar to the state where they're the only ones that can confer immunity on him. Just because he says, well, I'm not going to answer any of those questions. I think the case law is clear. The next step would be, would move to compel him. The court would then say, well, does he have immunity? If you have immunity, you can answer the questions. You're not properly asserting your Fifth Amendment privilege if there's a promise that it won't be used against you.
All right, how do you respond to that, Mr. Mizrahi? If you and only you have the authority to grant him immunity, how is he not peculiarly within your control?
Well, first of all, he could still invoke. I mean, if every person that we conferred immunity that had a pending charge, we would take sworn statements of every criminal defendant, confer use immunity, and then we know what their testimony is going to be at trial. The invocation is anything he say can be used in his pending criminal case. Me giving him use immunity doesn't absolve him of that, of not against this whole concept of conferring immunity. Maybe that works in a case where there's not a pending charge, or we give transactional immunity, but this is a collateral matter that has nothing to do with this particular case. It is impeachment on a collateral matter. As the court has pointed out, Raekwon Howard could be subpoenaed as easily as anyone else could be subpoenaed to come to this court and testify about what he knows about this case. And that is not peculiar within the state. We didn't even try to do all these things. They could have done it. We could have had this hearing on this Gantt issue that came up in the middle of trial. But whether or not they're calling a witness to impeach about whether or not he shot at one of the state's witnesses is so collateral to this case. It should not be admitted. They should not be allowed to make that argument. It implies that Raekwon Howard's answers would not be consistent with Mr. Barner's, which in fact they are.
All right, so I think I've heard enough from both sides. Based on the Lena case you gave me, I'm going to allow you to make the arguments as to the witnesses you did call. Based on Halliburton, I'm not going to allow you to make that argument with Raekwon Howard. I'm not finding that he's peculiarly within the province of the state to have been able to call him despite your arguments regarding immunity. I am also going to find that that is a collateral matter. I understand he's been accused of trying to kill two of the witnesses in this case. That doesn't make it material to this alleged phone call that he may or may not have made or had with your client. I do find that to be collateral, not material, and it would be in violation of Halliburton. So I won't allow you to make that particular argument as to Raekwon Howard. I think it's abundantly clear. And let's try to avoid as many sidebars as we can, please, during this closing so we can have a smooth and orderly closing argument for all parties. So at this time, if there's nothing else, can we bring out the jury, please?
And they have to rest, I think.
They do. They have to rest, and they're going to introduce their CAD report and then rest, correct? Okay, do you have that? I have the exhibit here. Let me hand it to you so you can formally move that in the presence of the jury. That's defense exhibit number 4. Okay. Let's bring the jury out, please. again for this delay. Things come up, they have to be dealt with by the court outside your presence, and so we have done so, but I assure you the case will be moving along much quicker from this point forward. I do have to ask during this lunch recess if any of you read, watched, or listened to any newspaper stories or even saw anything on social media with reference to this case. If so, please raise your hand. All right, and I see no hands raised. Did anyone attempt to speak to you, approach you, say anything to you about this case or the people or places involved in this case? If so, please raise your hand. All right, and I see no hands raised. Thank you very much. All right, we're still in Defendant Hakeem Robinson's case. Mr. DeCoste, you may proceed.
Thank you, Your Honor. Defense offers into evidence what's been pre-marked as Defense 4. I can approach.
Okay, yes. All right, Defendants 4 will be accepted into evidence.
May I show it to the jury on the overhead?
Yes, you may.
And going to the next page.
Okay, thank you. All right, thank you very much. All right, ladies and gentlemen, now the state and both defendants have rested their cases. The attorneys are now going to present their final arguments to you. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments as they are intended to aid you in understanding the case. Now, each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing. And of course, a little unusual in this case is we have two juries. So the state is going to give one closing argument to both juries. Then Defendant Whitaker will give its closing argument only in the presence of Defendant Whitaker's jury. You all will then be excused, and then Defendant Hakeem Robinson's jury will hear the closing argument from Mr. Robinson's attorneys, and then you all will be excused. This is our tentative schedule. So then I think that will take us through the rest of the afternoon, and tomorrow we will return at 9 o'clock for Defendant Whitaker's jury so I can instruct you on the law. Tomorrow, Defendant Robinson's jury will return at 9:30 so that I can then instruct you separately on the law. And then you will retire to each deliberate your separate verdicts. So while we are now nearing the end and likely will not be here, well, I don't know, but we had told you this would take to Friday. We might actually end a little early. I do want to still stress the importance that you must not talk about this case among yourselves or with anyone else. This case is not over yet. You still have arguments and the law. Those are two very important parts of the trial. So do not discuss this among yourselves until I excuse you to deliberate your verdict. But at this time, I'll call upon the state for its joint close. Thank you.
Please the court.
Yes.
Why are we here? We're here today because on January 15th, 2020, a group of individuals, a family, co-defendants, Leroy Whitaker, Hakeem Robinson, their good friend Dominique Varner, and a few others, fulfilled their collective, premeditated design, their plan to execute Charles McCormick. What was the reason? It was personal. There was no justification for it. Charles McCormick did not deserve to die. He made a song. That song was disrespectful. But it's not just that it was a song. It's what the song referenced. Specifically, who it referenced. Willie Addison. Because Willie Addison wasn't just another person. You heard from Hakeem Robinson's sister who Willie Addison was. He was blood. Brothers. And Leroy Whitaker, Hakeem Robinson's cousin. Their blood. And Willie Addison's blood was spilled on January 15, 2019, along with Abdul Robinson Jr., Hakeem Robinson's brother, Oregon Williams, Abdul Robinson Sr., who you know as Blue, and a couple other people in the vehicle. Hakeem Robinson and Leroy Whitaker were not in the vehicle. And you know that from way back in the opening statement. I wasn't hidden from you. But they didn't have to be. Because again, it was their family that was in that vehicle. It was their family that was killed, and it was their family that was severely injured. It was his brother, Hakeem Robinson's brother, that was shot in the head. And in the hospital for months. Had to learn how to walk again. And then Hakeem Robinson and Leroy Whitaker listened to Smokin' on Willie. And it's not just the lyric of Smokin' on Willie, it's who's singing it. Because it's Charles McCormick, who's part of Sixth Block. Keep in mind, ATK, Hakeem Robinson, Leroy Whitaker, they don't like Sixth Block. They're rivals. They hate one another. And then you have a rival, someone you hate already, smoking on your brother. And that lyric buries its way into their minds, into their memories, into their blood. They're not going to let it go. They're not going to let something from Sixth Block go regardless, let alone something so personal as family, brothers, blood. Can't let that go. Some exhibits, States 40, States 227. On the left, Hakeem Robinson's Instagram account. Rest in peace, big brother. You know I stood on all 10 about you. Don't speak on Willie. That's exactly what Charles McCormick did. He spoke on Willie. He said, smoking. And then, next to it, on Abdul Robinson Jr.'s account, gravesite. When is that posted? Take a look at the date. January 17th of 2020. 2 days after the murder of Charles McCormick, which took place coincidentally exactly on the 1-year anniversary of Willie Addison's death. 365 days in a year. And he dies on January 15th of 2020. The bullseye on the calendar, and he was the target, and they took him out. Dates 229. That's just a short clip of the song that you all heard. That's probably the most important part of it. And I guarantee you that that lyric, as much as you all remember it from hearing it before, those who knew Willie, who loved Willie, who considered him blood, they heard that every day. Here's another photograph, States 229. Willie Addison, Boss Booth. Surrounded by Hakeem Robinson, Abdul Robinson Jr., and there's Torgon in the middle. Family. You heard from Hakeem Robinson's own sister. They all heard about it. They all knew about it. They, Hakeem Robinson, Leroy Whitaker, were upset over it. They were really upset over it. And you know who else told you that? Father, Abdul Robinson Sr. And if you could set aside your personal feelings and emotions regarding that individual for a moment, and just think about that one statement that he told you. We were aware of that song. We were upset by it. Hakeem Robinson and Leroy Whitaker were upset by it. Abdul Robinson Jr. was upset by it. You can detest Abdul Robinson Sr. He can still be telling you the truth. And how do you know that that statement from him is truthful? Because Hakeem Robinson's sister from that witness stand earlier today told you the exact same thing. Just as she corroborated him that Hakeem Robinson was living with him. They were all living at the same house on Brown Jersey Court. January 6, 2020, this is States 30. Recognize those faces? Cousins, January 6, 2020. In a criminal case, you have heard, and the judge will go over the law with you at the conclusion of this, it is the state's burden. We have to prove the charges. We have to prove them beyond a reasonable doubt. Key term there is reasonable doubt. It's not beyond all doubt, not beyond a shadow of a doubt, a forced doubt. It's beyond a reasonable doubt. You would have to have a doubt that is reasonable. But if you have an abiding conviction of guilt, the case is proven. And I'm going to suggest to you that it has been proven, and it's not even close. We're going to go through the evidence here, but just very, very quickly. I'm not spending much time on this. Count 1, first-degree murder. Both Hakeem Robinson and Leroy Whitaker have been charged with that, as you know. I don't believe there's going to be any debate, there hasn't been throughout the trial, that what happened to Charles McCormick on January 15, 2020 was first-degree murder. It's captured on video. Person gets out, runs him down, and guns him down. Not justified, there's no defense. Clearly premeditated. So there is no doubt, no debate that this crime was committed. The one and only question is, who is responsible? And if you remember, back in opening, brings us back to the two questions. For January 15, 2020, where were they and what did they do? That's what the state has to answer for you through the evidence. The state has answered that with a mountain of evidence in this case. One additional instruction I want to talk about briefly before I get into the evidence is the instruction on principles, which I anticipate you will see from the judge. And that is because more than one individual was involved in this crime. One person pulled the trigger, not just one person is guilty. Because this wasn't a crime committed by one person. There were, as you all know based on the evidence, 3 individuals in that Nissan Altima. 3 individuals. And they all, to a man, wanted this to happen. When you go to commit a crime like first-degree murder, you don't bring along staff. You bring along co-defendants, family, those who want the same thing that you want. And so the law of principles is, even if you didn't pull the trigger in this, you are still guilty if you intended that crime to occur. And you did something, said something that encouraged the other individuals to commit that crime. You intended the crime to happen, and then you did something or said something that encouraged or assisted the other individuals to complete that crime. And then you are to be held accountable just as if you were the one who physically pulled the trigger. So let's talk for a moment about the evidence. There were witnesses in this case, because this did take place at a shopping plaza on a Wednesday just before 11 a.m. But it's a very large shopping plaza. And you can rely on your own memories as you deliberate and talk about the evidence and the witnesses and their testimony, and look through the exhibits, including the video. And I encourage you to look closely. Almost every single one of the witnesses in this case, very far away. They were at the other end of the shopping plaza, away from express employment. There were 2 witnesses who were very close to what happened. Ashita Saunders, who owned and was working at Express Employment, who knew Charles McCormick, who her company was helping him get a job, said goodbye, and you recall what she told you she said to Charles McCormick as he began to walk out the door. You remember? Have a good day out there. And she stood at the door, and she watched through the glass as the person she knew, who had just gotten a new job, walked towards the parking lot where neither one of them knew Hakeem Robinson, Leroy Whitaker, and Dominique Warner were waiting in that stolen Nissan Altima, a car they had no right to be in, but they wanted a car that couldn't be connected back to them. And so they waited. And that is where States 187 comes in. Front door of Express Employment. And you can kind of see through the glass where that desk area is where she said she was standing, just as Charles McCormick began to walk outside. And she told you she was there, and she saw from the corner of her eye that shooter, that gray and black Nike hoodie come running towards the parking lot, from the parking lot towards Charles. And Charles ran back initially for the front door of Express Employment. Then, as you see in the video, he turns. What does she tell you? He's coming towards the door. We lock eyes. I see him, he sees me. So he turns. He had a choice. He could have run inside that public office, putting everybody in there, putting the Saunders at risk. But he didn't. He ran around the corner and never made it very far. What did Ms. Saunders tell you? I saw them, couldn't identify anybody, can't identify Hakeem Robinson because his face was covered. 79 degrees outside, but he's wearing a hoodie and it's pulled up and his face is covered. And she gives a description. She says, looked like he had some hair underneath the hoodie. Wasn't a low cut. And we all know Hakeem Robinson did not have a low cut back in January 2020 because we have video. We have photographs showing exactly what his hairstyle was like in the days leading up to this. And she said, I can't put a number on it. She didn't say the shooter was tall. She didn't give a number. But what she could do, what she did do is say, Charles McCormick, the person she knew, the person she just talked to, the person she just walk out her door, shooter was bigger than him. Was taller than him. Not as thin. And how tall was Charles McCormick? According to the medical examiner, 5'10".
Objection, mischaracterization of testimony.
Overruled.
5'10". And the shooter was bigger than him. And she got a clear front row seat to that event as that shooter, Hakeem Robinson, chased Charles McCormick down right in front of her. Close to this. It's not strangers. It's not 30, 40, 50 yards or more away. It's right there. And it's someone she knows. Shooter was taller, was bigger. What did Victor Kruger say? He doesn't know anybody. He just happened to be checking out his mail. He's sitting in that truck. They run past him. And again, this all does happen very quickly. What does he say? Shooter to me looked like, I don't know, just under 6 feet, maybe 5'10", 5'11". 5'11" or 6 feet. An inch. An inch. We know how tall Hakeem Robinson is. He's 6 feet. Just a tad over barefoot, according to laser scans. Victor Kruger could be 5'11". Pretty close. Again, keep in mind, shooter doesn't stop, say, measure me. He's running and gunning. This happens very fast, but the two closest witnesses, the two clearest fields of vision, both say very consistent descriptions. Bigger than Charles, who's 5'10" according to the medical examiner, and Victor Kruger, 5'10", 5'11", maybe just under 6 feet. Very, very consistent. Parking lot, 187. This is a still shot. You have the video. You'll be able to look at it. You see all the witnesses? You have to squint. How far away are you? You know how tall they are? Keep in mind it's a video. But do you have any idea how tall those people are? Do you even tell what they're wearing? then this happens in 10 seconds or less. There's more gunshots than there are seconds that it takes for this crime to be completed. And you hear from a few witnesses who are way down there by Bailey's. Mr. Williams, well, the guy looked like maybe he was crouching. You know what happens when you crouch? You get a little small. Maybe 5'8". But then what did he say? Although sometimes I see people and I think they're smaller than me, I'll walk up and what do you know? They're taller than me. Jarvis Roberts says he's at least 25, 30 yards away. Saw it for about 2 seconds. That was his testimony, 2 seconds, because he hits the ground. He's way over there. Maybe 5'8", 5'9", somewhere in there. 2 seconds of an individual running and gunning, not standing straight, not standing up, and you're 30 yards away, which automatically means the object appears small. Common sense. The further you get away from something, the smaller it looks. Anybody ever had an eye test? With a little tree in front of you, where they blow the puff of air, it starts getting further and further away? Team Robinson on January 2020. There were some questions. You don't have photographs of him when he was arrested to see what he looked like. Well, when he got arrested in September 2020, what he looked like really doesn't matter. You know what matters? What he looked like on January 15th of 2020 when this murder took place. Defense 3. January 14th, 2020. The day before their plan was fulfilled. Willie's Day. This is a preview of Hakeem Robinson and what he looked like. He looked fat. You see the hair? See the legs? Still Defense 3. Same day. Keep in mind, the individual in red, sergeant that testified, said he was what, 6 foot, 300 pounds at the time? Himself, not Hakeem Robinson. There's Hakeem Robinson. States 230, January 5th, 2020. 2 individuals I think everyone will recognize. Leroy Whitaker, and that's Hakeem Robinson. And the other. Leroy Whitaker's 5'6" on the laser scan. Clearly shorter than Hakeem Robinson. And then you put them side by side, and Hakeem Robinson starts bending over. Still, January 5th, 2020. There they are together. Hakeem Robinson, Leroy Whitaker, cousins, blood. Approaching Willie's Day. And look at the hoodie on Hakeem Robinson. Does that shape on that head look somewhat familiar? Anything any of you have seen in this case? About now, states 187 and 230. Hakeem Robinson, Leroy Whitaker, left and right. And in the middle, the shooter. Wearing a gray and black hoodie. Gray and black hoodie you have all seen and will see again, worn by Hakeem Robinson. Pretty good shot of the firearm, too. And we'll come back to that. States 248. Team Robinson's height, measured by lasers, 6.0302 feet barefoot. And if you recall, there were some questions of the expert about, from defense counsel on cross, about, did you tell him he was going to get measured for his height? Did you tell him to stand perfectly straight and put his feet together? Keep in mind, those are two things that shooter never did for any of the witnesses that the defense would like you to believe their estimation of. But it's simply spreading your right and left foot apart is going to affect one's height in any observable way. How in the world is running going to affect it? It's going to make you look smaller, right? And to the right, you see Leroy Whitaker and Dominic Varner, 5.6233 feet, 5.5873 feet, very close to one another. State's 248, still shot from the dash cam. Charles McCormick and the shooter, side by side. Does the shooter look a little bigger, like Ms. Saunders said? How about height? You can ignore the head. Look at the shoulders. Equal distance from the camera, almost the same body position. 5'10" Charles McCormick, Team Robbins. Still states 248. Saw and heard from the expert who did the laser scans and then the 3D kinematic model. Shooter on the left, Hakeem Robinson's body scanned model, right? This shows shooter, Hakeem Robinson, his, the shooter's kinematic model, and then the 3D laser scan of Hakeem Robinson, Leroy Whitaker, and Dominic Varner. Dominic Varner, Leroy Whitaker, 5.7 feet, excluded. Doesn't match up. Hakeem Robinson, not excluded. States 243. This is on November 25th, 2019. Gray and black hoodie. Keep in mind, it's not that Nikes aren't owned by other people. And if all the state had was this photograph or this video of Hakeem Robinson in a similar black and gray hoodie, this case wouldn't be so black and white. But it's not. It's just one piece of the evidence. And you have to look at all of the pieces in totality. And they all point to Hakeem Robinson and Leroy Whitaker. States 197.
It's Ksoo!
Ksoo's Instagram account. Instagram Live. Black and gray hoodie. You see his hair. See him moving around. Back to the firearm for a second. Stage 243. This is the Bang It Out music video that was filmed on December 11th, 2019. A month before the murder of Charles McCormick. And look at the fire distinctive looking, I would suggest. And look at the map, the data for where this video was filmed. You see it close to Mosh. Where did Abdul Robinson Sr. say? He said, I was there when that was filmed. Over there by the chart house. Right over there in that same area. He knew where it was filmed. And it's filmed on December 11th, 2019. Going back to the expert's testimony when he did that comparative analysis between the firearm depicted in that music video as well as a known firearm he went out and procured for his testing, which is in the center. And then looking at the images from the dash cam. Points of comparison. Does it look similar? Even if you ignore the expert's testimony and you just look at these images, what does common sense tell you? What do you see with your own eyes? The Nissan Altima. This is one of the most important pieces of this case because it was stolen, not owned by Hakeem Robinson or Leroy Whitaker or Dominique Varner. So a car they should not have been in, and their evidence of them should not be. And you know beyond any doubt that that Nissan Altima was the car used to commit this crime and flee from it. You know beyond any doubt that it was occupied by those involved in this crime. States 77 and states 187. On the left, that crashed Nissan Altima after it fled from Officer Collins. And on the right, a still shot from the dash cam showing the car that was used, occupied by those who are responsible. Same car. States 187, and this is just a few seconds.
That's the car right there, right there.
Victor Kruger. He saw the car, saw the shooter get back into it, and as you hear, that's the car right there. So there's no doubt that that Nissan Altima was the one that was transporting the guilty from that scene. Let's talk about Officer Collins for a second. He followed that vehicle, not knowing Charles McCormick had been shot and killed, knowing shots had been fired. So he pursued it, turned his lights and sirens on, telling that vehicle, the occupants, to pull over, to stop, and they refused. Varner, who admittedly was in that car driving, and admitted to flying, driving recklessly, reaching very high speeds, going through a residential neighborhood as he was trying to get away. Get away himself, but also those who were with him, his friends. Hakeem Robinson, Leroy Whitaker. And Officer Collins, because part of the testimony and the cross-examination has to do with the description he gave. That he advised on the day of this incident that the shooter that he saw get out of that Nissan Altima and run west, 5'5", 5'8", 5'9", somewhere in that range. But where was he when he saw that individual? And on the map, you see 1, 2, 3, 4 little addresses. Number 1, 1233 Townsend. That's where the Nissan Altima crashed. Officer Collins testified he was further up the map, 1 Townsend, just past Alderman, that intersects with Townsend. when he saw the person running, he was about half a football field away, about 50 yards. And he saw him for about 2 seconds as they darted across the street. And I think we've already covered, but what happens when you're at distance? What happens when someone is running? They appear small. And then factor in, it's a 2-second glimpse. States 80, that Nissan Altima looking back towards the direction that Officer Collins was coming. Based on the map that you were just shown as in evidence, and this perspective, can you even see where his car would have been in this photo? Because he was further back. Just use this visual as context. You see a car, past a patrol car at the top of the screen. Doesn't look that big. Past that, houses. Imagine being further back and looking at an individual fleeing from the Nissan Altima and seeing him for 2 seconds. States 190. Still shots from the Belmead video that you saw, that's in evidence. You can look at it again. And when you look at it, and you can take note of these times if you want. At 11:03:23, the shooter on the image to the left runs between the houses and passes that car. Camera doesn't move, car doesn't move, just the shooter. And then look at the image on the right. 11:06:05. Almost 3 minutes later, that's Officer Collins. He wasn't right up on him. And you saw Officer Collins. 6'4", he testified. So look at the two images, and on the right, Officer Collins, as he goes past that same vehicle. How do their sizes compare from this image? Is the shooter consistent with someone who's 5'5"? Or is it more consistent with someone that's approaching Officer Collins' height? Someone closer to 6 feet. Maybe 6'1" with shoes. Going back to that Nissan Altima, States 87. It's not just the car, but it's what was found in it. DNA fingerprints. On the Glock, at the top of the slide, not on the handle, not even on the front of the slide, on the rear of the slide, fingerprints belonging to Hakeem Robinson. His prints on that gun in that car. Now, the analyst can't say at what point in time that fingerprint got put on the gun. Dominic Carter can. The expert couldn't. But common sense tells you, based on even the line of questioning, fingerprints can get wiped off. They can get wiped away. You're going to find a fingerprint on the slide of a Glock left behind in a car that the suspects just fled out of. But that print, maybe that's been on that gun, and that gun's just been passed around. And yet you get a print on the top slide, clear enough to identify, and it belongs to Hakeem Robinson, who, coincidentally enough, DNA is found on that rolled up white t-shirt next to it. Greater than 700 billion. The analyst says we stop at 700 billion because we can't comprehend numbers bigger than that. Can you imagine if you were told you had greater than a 700 billion chance to win the lottery? It was over 700 billion times more likely that you were going to win when you purchased that ticket and lose? Would you have an abiding conviction to go out and buy that ticket? Would you think you could lose? Well, I suggest to you that this piece of evidence, the loss of Hakeem Robinson, because it's over 700 billion times more likely that that's his DNA. on that shirt next to his prints on that gun in this stolen Nissan Altima that was just used to flee the scene of the murder. States 88, that same shirt, rolled up, balled up, and it's a size large. States 89. You have the shirts, you can look at them. The one in the back's a medium, where Leroy Whitaker was, a little bit smaller. Also, States 92, see a rifle in the floorboard, and then that white shirt, that medium-sized shirt, with Leroy Whitaker's DNA. Again, greater than 700 billion. I want to talk for a moment about the firearms. All right, you got the Glock. You already saw where the fingerprint was on it. And that gun, Dominic Varner says is his. Serves him no purpose in the world to admit that gun is his. He's just feeding the story. Why say that's his gun? How does that help? Does it serve any purpose? No. But yet he's admitting that not only was he involved, but yeah, that was my gun. And he's just telling a story based on what he knows in discovery. He knows Hakeem Robinson's prints on it. Why not say that was Hakeem Robinson's gun? It's got his prints on it. But he doesn't. He says, that was my gun. He admits it. And again, you don't have to like Dominic Varner. I'm not saying he's a good person. He's a criminal. He's just their kind of friend. And if you're going to plan a murder, who do you take with you? Is it not a Dominic Varner? You want someone you can count on. Their friend. Someone who shares the same goal. H92, again, is that rifle. What I really want to point out, States 103. Because Dominic Varner says that rifle is Leroy Whitaker's. And it's in the back seat next to the item with Leroy Whitaker's DNA. And he didn't pull the trigger, Leroy Whitaker, but he is a principal. He knew what was going to happen, and he wanted it to happen. And this rifle tells you that without speaking a word. Look at it. It's an assault rifle. Okay? It's set to fire. That tab, set to fire, tells you everything about the intent for that weapon is to be used. Not only is it set to fire, there is a live .223 caliber round chambered. One small muscle contraction of the finger away from discharge. States 104, that live round. Leroy Whitaker's live round. Leroy Whitaker's intent. If that one wasn't enough, 107, 26 total rounds. 26 individual statements of intent. Leroy Whitaker didn't have to say a word in that Nissan Altima to be guilty. You show up with a loaded AR-15 and chamber a round, set it to fire. You don't have to vocalize anything. Your actions have made it more than clear you're in agreement with what's about to happen. And if he didn't know what was about to happen, why is he bringing a rifle? Because they were on a hunt. So you bring the tools of the trade. 1214 Timber Lane, States 189. Leroy Whitaker, Dominique Varner. Right after they have fled the murder, Hakeem Robinson's gone west, they go east. And they leave their guns behind. Leroy Whitaker not just a spectator, he's an active participant. He wasn't. He was roped into all this, had no idea what was going to take place, no idea what was about to happen, didn't want it to happen. Stayed in the car. He could have got out, laid down in the front yard, put his face down, spread his hands, because officers were coming, and said, "Officer, officer." But he didn't. Consciousness of guilt. They're getting out of there. Left the guns behind, left the DNA behind, left the fingerprints behind, and then Dominique Varner and Leroy Whitaker are not leaving anything else behind. They're getting out of there. And from that moment, where do they go? 1033 Townsend Boulevard, where Dominique Varner and Leroy Whitaker both collectively committed burglary with an assault or battery. To commit a burglary, to prove that, the state has to prove, in this case, because again, Varner already pled to it, admitted to it, to what he did, but Leroy Whitaker did the exact same thing. We have to prove Leroy Whitaker entered a dwelling, Buckley's home, and at the time of entering it, he had the intent to commit an offense therein, other than burglary or trespass. It's not like Leroy Whitaker was homeless, and it was 30 degrees outside, and he needed a warm place to sleep, and he thought this was an abandoned home, nobody's home, and I'm going to sneak in, commit a trespass so I can sleep, protect myself from the elements. That is not what happened. He was protecting himself, but not from 30-degree weather or rain. He was protecting himself from the police. The police who were on his trail, were trying to find him, trying to find Hakeem Robinson. And so, just like Dominic Varner, who behind the wheel was fleeing at a high rate of speed to escape, this is just a continuation of that, on foot. So, with the intent to thwart the police, to escape the police, to resist the police, to ignore their orders, to stop, Leroy Whitaker and Dominique Varner both entered the home of Barbara Buckley without permission and with the intent to hide from the police, and that is a burglary, plain and simple. But they went a step further, because there's an assault or battery. You're also, I believe, here from the judge that you can infer that there was an intent to commit a crime inside that dwelling if it was done stealthily and without the consent of the owner. What did Barbara Buckley tell you? She didn't invite him in. She didn't even know they had entered. That's stealth. She thought her cat shut the door to the bedroom. States 114, the enclosed patio that Dominique Varner and Leroy Whitaker entered as the police were closing in. Then states 115, the back sliding glass door to the home. And then once inside, states 125, that bedroom to the front of the house, door open, and when that door got opened by Miss Buckley, looking back at her from states 126 in that closet, Dominique Varner and Leroy Whitaker. Two people she didn't know, had never met, had never been in contact with. Then the assault and battery by both Dominique Varner and Leroy Whitaker. Both, not just one. Both. So if you find Leroy Whitaker guilty of burglary, you have to determine, was an assault or a battery committed? An assault is simply an intentional and unlawful threat by word or act to do violence when they have the apparent ability to carry out that threat. So, for example, when Miss Buckley is thrown down on the ground and she's cowering on the floor, and Leroy Whitaker asks Dominique Varner, "You want me to hurt her?" That's an assault. That comes after the battery. The battery is just an actual and intentional touching or striking another person against their will. Did that happen to Miss Buckley? States 133. He was 57 years old at the time. Home alone, because her husband was at work. She hadn't left for her shift yet. States 121, front door to her home that she opened, telling Leroy Whitaker, Dominic Barner, get out of my house. Opens the door, begins to yell for help. They're not going anywhere. The police are outside. They can't go outside. They have to pop. Consciousness of guilt and proof of the burglary. And States 110. Closed front door, and you can see the brick wall next to it, the little planter box, and there's a metal railing just inside. The metal railing that Miss Buckley told you, she reached out with her hand and grabbed. Kind of a death grip. So much so that even though she's 57 and they're much younger, when Dominic Barner grabbed her to try and get her back inside, couldn't quite get her. So who came to the rescue? Who assisted? Leroy Whitaker. He came and helped break Barbara Buckley free from that rail, pull her back in her home, where they threw her to the ground, and Dominic Barner, admittedly, put his hands around her neck and began to choke her as Leroy Whitaker asked if he should hurt her. And then she complied. That is a battery during the commission of the burglary, and that proves that Leroy Whitaker, just like Dominic Barner, no different than Dominic Barner, is guilty of burglary and assault or battery. And again, States 135. Slight abrasion in Miss Buckley's neck. Wrist, States 137. DNA from those locations matching Dominic Barner. Again, he admits it. No mystery. States 143 and States 189. What States 189? Notice it. He flips his leg on that chain link fence. It catches. And he falls to the ground. And then what do they find on Miss Buckley's clothing? Her pants. Blood. DNA. Whose? Leroy Whitaker. Greater than 700 billion. His blood, after he jumps the fence and catches his leg, on her pants in her home. She's never met him before that day. Doesn't know him, didn't invite him in. They shouldn't be there. That proves beyond not just a reasonable doubt, but all doubt that Leroy Whitaker, along with Dominic Barner, are both guilty of this crime. Let's talk a little bit more about some of the evidence. And we'll start with Leroy Whitaker's phone number, 803-3671. You'll have all these records back there. There's a lot to go through if you choose. But States 227. Leroy Whitaker's Instagram account, you can see the account name highlighted in yellow at the top, Aki Scotty. You see a phone number, 904-803-3671, verified. Leroy Whitaker. And you can see at the bottom right-hand corner of the photo, at Aki, and then it kind of cuts off, Aki Scotty. Page 437 and 1057, text messages on that account where he gives out his phone number. And look at the dates, December 19th, 2019, before the murder, text, 904-803-3671. January 31st, 2 weeks after the murder. Laugh my off, we will have tea. FaceTime you later. 904-803-3671, same phone number. And then, of course, you have this, States 241, a text message sent from 904-803-3671 with the attachment of this photograph, Leroy Whitaker, to 624-3684, Abdul Robinson Jr., Kareem, Akeem's brother, so let's look, States 246. The maps, in this case, done by Special Agent Corley. And with regard to 904-803-3671 and 624-3684, again, that's Abdul Robinson Jr. And on this map, which we've talked about again in a few moments, you'll see the 478-305-9583, which I believe evidence is proven is associated with Hakeem Robinson, was used by Hakeem Robinson that day. But let's look at the calls. Where are they pinging off of? Between 10:17 a.m. and 11:05 a.m. Leroy Whitaker's 803-3671, as well as Abdul Jr.'s 624-3684, are pinging off the tower. And if you look at the sectors, pointing back towards that red icon, 7001 Merrill Road, the scene of the murder. 478-305 number is also pinging off that same tower based on a data file, placing it at the scene of the murder at the same time as well. Next slide, again showing those same numbers between 11:30 a.m. and 11:51 a.m. So after the murder. After that Nissan Altima has crashed, and they're trying to get out. Leroy Whitaker's 803-3671, being right around the area, Townsend Boulevard, 1033 Townsend. Got the time in advance record associated with it, and they show kind of how they intersect, that they're in those bands, somewhere in there. And you see Townsend right above it, as well as the 478-305-9583 pinging off that tower. Just as if Hakeem Robinson using that phone were trying to get out at that time. And where is 624-3684? Abdul Robinson Jr. He is up higher on the map. Going back. He is up near the top by the 7001 Merrill Road, but also in that area, the Dalehurst Drive, where Torgon was living, where Abdul Robinson Jr. returned and was waiting. You also have the next slide, again showing Leroy Whitaker's 803-3671 number, Abdul Jr.'s 624-3684, as well as Abdul Jr.'s 478-491-2831 number, because he had two. And if you recall, those numbers he gave out on his Instagram account in messages, both numbers. The 904-624-3684 and the 478-491-2831. Gave them out, just like Leroy Whitaker did on his Instagram. And you can see where they're pinging. And you can also notice that we have in blue another phone number, 904-866-2370, which belongs to Abdul Robinson Sr. Blue. And this shows up by Townsend at around 12 o'clock. If you remember, Leroy Whitaker and Dominique Barner held Miss Buckley there against her will in her own home for about an hour or so. Murder happens a little before 11. Car flies, crashes, they run. So shortly after noon, that's when Abdul Robinson Sr. is showing up, because it's after the phone calls from Leroy Whitaker to Abdul Jr., Hakeem's brother, cousin, Blue's other son, asking for help sending the pin drop information, which takes you to Townsend, 1033 Townsend. That's when he's showing up to pick them up. And Abdul Jr. is pinging again back over near Dalehurst Drive. Leroy Whitaker. His phone records put him again right there in Townsend by his home before he leaves after getting picked up by Abdul Robinson Sr. Hakeem Robinson, 2 phone numbers. One that there's no dispute over, 904-704-1595. Second, the state suggests is 478-305-9583, so write them down. We're going to start with the 704-1595. This is the phone whose account information is in his mother's name. And if you recall, his sister, when she testified, she said, Dad, he did give, well, he took care of his sons. He did give them phones. But Abdul Robinson Sr. also told you that this number was in Hakeem Robinson's mother's name, and you'll see the subscriber information in every Walters. This is mom's name. This is his main number. A number that can be tracked back to him. His mother's name. And so, stage 243 on that number, you see on December 28, 2019, a text message, I just got to Jacksonville. So he's back in town on December 28th. He was in town on December 11th as well because he filmed the Bang It Out music video. Maybe he left and went out of town after that. He was back by December 28th. You know what else happened on December 28th, 2019? Abdul Robinson Jr., Hakeem's brother, gets a text from Dominique Barner. Who's it about? You could read it for yourself. And it mentions McCormick by name. Same day, Hakeem Robinson's back in town, and they're talking about McCormick. Let's look for a brief moment at Hakeem Robinson's 704-1595 phone, the phone that can be tracked back to him. Look at the activity and recall the testimony from the experts. There's all kinds of activity on that phone, especially in the early morning hours of January 15, 2020. And it's UTC time, so please remember you guys subtract 5 hours. 11:06, subtract 5 hours, and that's 6:06 a.m. My math's right? 6:06 a.m. It continues, and then line 42, 12:11. So 7:11 a.m. More activity. Next activity, not till 18:10, which is 1:10 p.m. So from 7:11 in the morning to 1:10 in the afternoon, this phone, his main phone, his phone that can be tracked back to him, the phone that Donnie Shipes can get a hold of him on, doesn't want to miss out on a deal or anything. For some reason, for the next 6 hours, that phone, that known phone, is off. It's off. No activity, no calls, no data, no instant messages being received, nothing. And then when you look at the logs, January 15, 2020, sometime between 5:55 a.m. and 1:10 p.m., hour one events. If you remember, the last activity, 7:11 a.m., and then 1:10, 1:11, right after a power one event. Oh. Wonder why that is. Is it also the same reason you use a stolen car to commit a murder? Something that can't be tracked back to you? So let me make sure my known phone doesn't come back to me at that point in time either. let's look at the two numbers, 478-305-9583, 478-491-2831. Again, Abdul Robinson Jr., his brother, through his records, admits to using 478-491-2831. Abdul Robinson Sr. said the other number belongs to Hakeem Robinson. And I got it for him. I put it on my account. I'm the authorized user. Look at the subscriber information for both numbers. What's the activation date for both numbers? November 12th, 2019. Same for both numbers. All under Darrell Watts, as Blue told you. That's the account he was using. Again, you don't have to like him, but these records don't lie. Page 239 shows some contact or attempted contact between the two 478 area code numbers on January 15th, 2020. One at about 9:13, 9:16 in the morning, so before the murder. Around the time that they would have been stalking Charles McCormick at his apartment complex, because remember he signed in at 10:08 a.m., so that's beforehand. They're in two different cars. And then after 16:54, which is 11:54, 11:55, shortly after the murder, but when Hakeem Robinson needs help, attempted contact between the two numbers. Not phone a friend, phone a brother. States 240. Again, 904-866-2370, Abdul Robinson Sr., Blue's identified number. He admitted it. You have the cell phone exam showing that it's his phone, showing the cell phone location when he shows up at Townsend, where he was coming from. You had the video showing that red-orange Dodge Challenger showing up. And what is this? A selfie photo that he was taken of him, and he sends it to 478-305-9583. He's not sending himself a photo of himself. He sends that to both 478 area code numbers, Hakeem Robinson and Abdul Jr. Looking at his outfit. Sends it to both of them. He's not using 478-305-9583. His son is. Going back to the maps for 624-3684 and 702-918-4911. You recall that's Dominic Barner's number. And what does Barner tell you? I call Abdul Jr. at around 4:40, 4:45 a.m., letting him know Charles McCormick's back. You have the cell records. It confirms that Dominic Barner communicating with Abdul Robinson Jr. on his 624-3684 number around that time. Look at the records from the FBI in Eastern Standard Time, 4:44 a.m., 4:45, 5:01, 5:26. Those are calls between Dominic Barner and Abdul Robinson Jr. And then where does the map place those two devices? Barner in green is down by 3830 University Boulevard, where he was living. This is between 4:42 a.m. to 5:26 a.m. Abdul Robinson Jr. up there near Brown Jersey Court. And then it travels down Dominic Barner's address. Dominic Barner told you what happened. These records corroborate. You don't have to like him. But again, that doesn't mean he's not telling you the truth. The next slide shows both of Abdul Robinson Jr.'s phones, the 624-3684 and the 478 area code number, being in the same area. 5201 Atlantic Boulevard. Where did Charles McCormick live? Over there off Atlantic. What did Barner say? We all went over there. Next slide shows how the 478-305-9583 number that was using data and was pinging initially over there by Merrill Road at the time of the murder, then begins to travel out. Also, in that same area at the time was Leroy Whitaker's number and Abdul Robinson Jr. Next slide shows how the 478-305-9583, that device traveling from Merrill down to the area of Townsend, right where Dominic Barner told you Hakeem Robinson was because he was with him and Leroy Whitaker, before it then begins to travel south again. And keep in mind, he's on the foot. He's still trying to get away. And he goes west down through the residential neighborhood where there's a nature preserve. And that's the location that he's allowed to traverse that takes him out to Arlington Expressway, where he then gets his ride. Page 242, this is that preview location of in that area of Lone Star Road that was deleted off of Abdul Robinson Jr.'s cell phone. How do you erase maps? Remember that search? You got a little thumbnail that stayed in cache and you couldn't delete that he received from Hakeem's 478-305-9583 number in that area as he's trying to get the location where he can get picked up. That nature preserve, stage 248, where Miss Gant took then Detective Smith to that apartment complex and said, this is where I picked Hakeem Robinson up. The defense would like you to believe that she was coached to know what to say. If Miss Gant were just rehearsing a story, she's given more details. I didn't even remember what Hakeem Robinson was wearing. I mean, that's easy. Not with these people anymore. Not with Oregon anymore. But I remember and that location is right where Miss Boston lived. She confirmed a person in a black and gray hoodie that she recognized because of the alert on her phone about a shooting and looking for suspects came from the woods. Now she says 5859. I think we've dealt with that issue. But again, she got a quick glance. She's upstairs and runs inside. But what's key is right before that, she saw a white female in a silver car driving around the neighborhood, driving around that apartment complex, looked like she was lost, looked like she was looking for someone. And she said the lady was holding her phone up, looked like she was using her phone, like she was looking for someone. When Natalie testified, when she talked about the phone, you remember she was had the phone up. Just like Miss Boston and Miss Rock. They don't know each other. So I said, I've never seen that lady before. Confirms that Natalie was there and that she picked up who she said she did. And then on this slide, this is between 12:22 p.m. and 12:40 p.m. That 478-305-9583 number in red. You can see it's up there, closer to Dalehurst. Almost as if he got picked up by Natalie, taken back to Dalehurst, and then was leaving to go home. And it's funny, it's about 30 minutes later, across the river, his known phone comes back on. I wonder where the 478-305-9583 phone went. Across the river, I don't know. And then, between January 15th, Brown Jersey Court. Look at all the phone numbers back in that area. Leroy Whitaker, just like Blue and Barner say. Joel Robinson Jr. shows back up, pointing to his device, both of them. Barner's number shows up over there, like he said. Team Robinson's no numbers back on. And then this slide just shows where Abdul Robinson Sr. Blue was at around the time of the murder. He's way across town. He comes from there all the way over to Townsend after being notified that they need a ride, which is also reflected in the next slide when you see that blue number showing up next to Townsend. Spend much time on this, but Abdul Robinson Jr., 904-624-3684. Again, this is the call log. This is Dominic Barner's number, January 15th, 2020, 13 calls between the two of them. Incoming or outgoing. As Barner said, I was letting you know, Mormons here, they come and get me. Device locations associated from the phone itself. For Abdul Robinson Jr., States 241, starts off Brown Jersey Court. This slide is interesting. Eastport Road and Palm Lake Drive. Meza apartment complex. What did Barner say? We went to an apartment complex to get a stolen car. And it makes sense why you would park a stolen car in an apartment complex. You can park it in the back. There's lots of cars around. It's harder to find. And it was off Eastport Road, Palm Lake Drive, apartment complex. And at about 6:17 a.m., that time's been corrected, January 15, 2020, Will Robinson Jr.'s device is showing up over there according to his own cell phone. And it goes over toward Dalehurst. Oregon lives. This is off at the landing, close to where Charles McCormick was living. And then back to Dalehurst, around the time of the murder, just after the murder, 11:45 a.m. Then back at the end of the day, 1:22 p.m., shows up Brown Jersey Court. And here, so far, States 241, you see some of the pin drop information between Leroy Whitaker's phone, Abdul Robinson Jr.'s phone, and that location information. 1033 Townsend Boulevard. This Buckley's home. This is another instant messaging just showing that same location information. When this is between Abdul Robinson Jr. and Abdul Robinson Sr. And Sr.'s response, I'm about to leave them. What'd he say? They didn't come out right away. They had to wait. He's in the right place, and they still had to wait. Getting impatient. There's police in the area. Sends it. I'm about to leave. That's 1033 Townsend Boulevard. This is for the 478 numbers. And I just wanted to show this. On January 15, 2020, FaceTime audio, FaceTime video, iMessage authentication, that process that takes place to make sure when you're trying to communicate between the two devices, they're applicable, it will work. And remember, FaceTime communications, those types of calls aren't reflected in the records. So if he FaceTimes, sends an iMessage, the location, it's not going to be reflected in the records. House of Pain, creation date, November 14, 2019, 2 days after both 478 area code numbers are activated, one for Abdul Jr., one for Hakeem Robinson. 2 days later, this House of Pain iCloud account is activated. Same address as Hakeem Robinson's other iCloud account. And it has the 478-305-9583 number. 2 two-factor authentication. And then from Hakeem Robinson's Instagram account, nail salon post that we're all familiar with, and upload IP address, the first four groupings of numbers for the carrier are what matter, because that's what's assigned by the carrier. The rest are randomly assigned by devices. Not the same, because it's the same device, you randomly assign. But the first four groupings, that's what matters.
It's characterization.
Overruled.
This first four grouping of numbers that matter is the same as the registration IP address for the House of Pain iCloud account, activated 2 days after he got his phone. House of Pain, page 230. And there's a lot more, and it's in evidence. You can look at it, but we picked out some of the photos just to show you. December 28th, the day you got that account. This House of Pain iCloud account. Same day, Garner and his brother are texting about McCormick. There's Hakeem Robinson and Leroy Whitaker. Selfie photo, December 31st, 2019. Series of photos showing Hakeem Robinson's Instagram story posting to this iCloud account. Another photograph of Hakeem Robinson, Ksoo 23X. House of Pain, sure. Did his father start it? Sure. Does that mean he won't use it? No, he won't. He's wearing a shirt. And photos you've seen with a hoodie in the shade you've seen next to a person you've seen January 5th, 2020, but it was taken on January 4th, 2020, 11:48 p.m., and it gets uploaded to this iCloud account 3 hours later. Remember the time difference from California to Jacksonville? It's uploaded to that iCloud account almost immediately after that photograph is taken. His iCloud account. January 6th, Hakeem Robinson, Leroy Whitaker, cousins. January 9th, a selfie of Hakeem Robinson. January 14th, day before the murder, having a good time. Talked on this, so I'll be brief here, but States 177, this is just a photograph of that apartment complex in Arlington Expressway, just on the other side of the curve that we made it out of. Natalie picked them up. And if you recall, when she testified, when she finally pulled in, he's coming up from below, just 2 stories here. And Miss Boston says, I'm upstairs, and I run in, he's way down below. That cooperates. Now, States 194, talk about a few posts by Mr. Hakeem Robinson after the murder. And there was some question as to why would someone post something admitting of what they had done? Sometimes people are stupid. And when you're 21 years old, you can make some good decisions, and then you can make some decisions that make your father quite a big bad man. Even bad calls. And when you've escaped the crime that you committed with people you were tight with, and that gun is long gone, that 478 area code number that you don't think can be connected back to you is long gone, well, I can post whatever I want and just say whatever I want. That feeling of invincibility, 21 years old.
Why you so long?
Ksoo homicide and singing the chorus and down right after Charles performance. 96, 2 days later, also posted Team Robinson's Instagram account. Video of Charles McCormick. Bye-bye. On 95. Now, it was suggested that you didn't have context for this. Five days later, that dash cam context. Did run him down. Well, he might have got a blister. Maybe he needed a pedicure. I don't know. Very, very briefly here, because this case is not dependent on either Dominique Barner or Abdul Robinson Sr. It's not. And we have said and will continue to say, you can think whatever you want about them. We're not asking you to like them. Just evaluate what they said based on the other evidence. Does that evidence corroborate, regardless of what you think of it? And if it does, make your determination. You cut him out completely. Don't you still have enough? His DNA, his prints, his phone location, Leroy Whitaker's DNA, his cell phone location. In that car, right after the murder, and at least with regard to Hakeem Robinson, he tells you what he did. He posts it. He brags about it. And again, with regard to the testimony, also remember Hakeem Robinson's sister, because she confirms the important parts that Abdul Robinson Sr. provided. Gives him phones, living with him. They knew about the song. They knew about Willie. Willie, they even asked, well, it's like stepbrother. No, we're blood. We're blood. So were they. And because Hakeem Robinson wanted it, Leroy Whitaker, his cousin, wanted it too. And that's why they're both guilty.
All right, thank you, Mr. Cooper. All right, ladies and gentlemen, I'm going to give each of you a recess now since it's been about an hour and a half. So I'm going to ask Hakeem Robinson's jury to go into their jury room. Please leave your notebooks down. Your recess will be a little longer as we hear from Hakeem Robinson's close, so make yourselves comfortable. We'll bring you out here just as soon as we can. And for Mr. Whitaker's jury, we're going to give you a bio break now, and then I'll bring you out here just as soon as we can to start the defense close. Thank you very much. All right, both juries are out of the courtroom. We'll be in recess. Thank you.
In front of, across the street here.
Okay. Now, can you tell the jurors, on February 5th of 2024, do you remember anything woke you up?
¿Y se acuerdan ustedes del 5 de febrero de 2024? Si es que algo lo despertó a usted. Sí. Yes.
And what woke you up that morning?
¿Y qué es lo que le despertó a usted esa mañana? Un balazo.
A shot fired.
Okay. Was it a shot or is that a gunshot?
Un balazo, diría usted que es un balazo como de pistola. Sí. Yes.
Okay. And can you tell the jurors, where were you in your home sleeping?
¿Y podría usted decirle a los turistas ¿Dónde es que usted estaba durmiendo dentro de su casa?
En la parte de atrás del porche.
In the back part, on the porch.
Okay. And can you tell the jurors, after you heard the gunshot and you woke up, what did you do next?
¿Y podría usted decirle a los juristas qué es lo que usted hizo después de haber escuchado el disparo?
Me puse zapatos.
I put on shoes.
Escuché unas personas que hablaban.
I heard that some people were speaking.
Y me metí a la casa.
And I went inside the house.
So, por la ventana, miré, del otro lado.
So through the window, I saw on the other side
3 personas.
3 people.
Una persona, abajo en el zacate, en el pasto.
One person was down on the grass.
Y 2 personas paradas.
And 2 people were standing.
Okay. And do you remember about what time it was in the morning when you were woken up by the gunshot from you walked in your house and heard the people?
¿Y se acuerda usted más o menos a qué hora sucedió esto en la mañana cuando usted escuchó el disparo y vio a la gente por medio de la ventana?
Sí, como a las 6:30, estaba un poco oscuro.
Yes, like around 6:30, it was still somewhat dark.
Okay. And you said that you came into the house. Were you, I guess, where is the place that you were sleeping at your house that you, I guess, came into and walked through your home?
Entonces, usted dijo que usted se lo y entró a la casa. Entonces, ¿podría usted decirnos de dónde es que usted o cómo es que usted entró a la casa?
Porque es mi casa.
Because it's my house.
So let me ask you a better question. So where you were sleeping, was the room and porch in the back of the house or the front of the house?
Entonces, permítame hacer una pregunta mejor. El porche donde usted está viviendo, el porche que queda en la parte del frente de la casa.
De atrás.
In the back.
Okay. And you said you, I guess, traveled through your house and you looked through a window. The window that you looked through, where is that in your house? The front or the back?
Entonces, por una ventana. Entonces, al entrar en su casa, entró a ver por cuál ventana. Era una ventana de delante, una ventana de atrás.
De frente.
Front.
Okay. And when you looked through your window and you said you saw somebody laying on the ground?
Usted dijo que cuando lo vio por la ventana, vio a alguien que estaba en el piso, acostado.
Sí.
Yes.
And
Objection, I'd ask that to be taken down, and I'd like to make a motion outside the presence of the jury.
37 is in evidence already. It came in through Mr. Campbell.
Is leading the witness.
Well, I'm going to leave the photo up. He can ask non-leading questions if you want to object to questions, but this is evidence and it's publishable. So
The statement from the witness was that he saw the body in the grass. The body was found in grass. The prosecutor trying to move the body back toward the defendant's father's house. That's not an evidence.
okay. You don't need to interpret right now. Thank you. Let's let Mr. Abate ask his next question, and then you let me know if you've got an objection to that question. The photo can stay up. It's in evidence, and people are going to attribute what they attribute to it. And you can repeat a question if it didn't get answered. Why don't you ask a question?
I didn't even ask a question.
Okay, well, let's do a question and we'll see what happens.
Now, do you see states at 37, the photograph in front of you?
Sí. Yes, yes.
And when you're looking out the front window, is this the house that you can see?
Y cuando usted por su ventana de enfrente, ¿es esta la casa que usted puede ver?
Sí, la puedo ver.
Yes, I can see it.
And you told the jury a few minutes ago that when you looked out the window, you saw someone laying on the ground. Do you remember that?
Que cuando usted vio por la ventana, vio a alguien que estaba acostado en el piso. ¿Es eso correcto?
Sí.
Yes.
And can you, in using states at 37, can you put an X if it's in the photo where you saw the person laying on the ground?
Utilizando una prueba del estado número 37, usted podría tachar con una X donde usted vio a esta persona que estaba acostada en el piso.
Pero ¿cómo le hago?
It's like right here. How do I do this? Con una X. Around here.
Okay, so we're looking at states at 37 for the record. It's on the right-hand side, at the very edge of where it would line up with the porch.
Al filo donde se alinearía con el porche.
Con la ventana.
Through the window.
Right. So, what else did you see? Was that the only thing you saw? The man lying on the ground?
¿Qué más vio usted el hombre recostado sobre el piso.
Sí.
Yes.
Okay, and you told the jurors a few minutes ago, you also heard talking?
Hace unos minutos usted le dijo a los juristas de que usted tenía escuchado de que alguien estaba hablando.
Sí.
Yes.
And other than the man that was laying on the ground, could you see, was there anybody else outside in the area?
Sobre el piso. ¿Había alguien más en el área?
Sí, dos personas.
Yes, two people.
Okay, now can you tell the jurors where were the two people you saw in relation to the man that was laying on the ground?
¿Dónde es que estaban estas dos personas que usted vio en relación a la persona que estaba sobre el piso?
Juntos, más o menos así pegados. O sea,
Next to them, they were like right next to them, like next to them.
And you said they were standing up?
Yes.
Okay, and did you, I guess after you saw three people, did you keep looking out the window?
¿Usted continuó viendo por la ventana?
Sí.
Yes.
Okay, and as you continue to look at the window, can you tell the jurors what the three people did next, if anything?
Tras verlas por la ventana, si es que hicieron algo.
Solo se levantaron a la persona
They just got up and they picked up the person
y se fueron caminando juntos
and they went off walking together,
como para la gasolinera.
like towards the gas station.
Okay, and from your house where you are looking out the window, how can you see the gas station?
Y de su casa donde ustedes están viendo por la ventana, ¿usted puede ver la gasolinera?
No.
No.
Okay, how long did you watch the three people go off? When did you stop watching?
¿Por cuánto tiempo es que usted vio a estas personas? Pues sí, ¿por cuánto tiempo es que usted las vio?
Iban caminando como de aquí ahí a donde los alcanzo a mirar, son como unos minutos y algo, es nomás porque ya para acá ya no puedo mirar.
Well, when they went off walking from basically from here to there, like right about there, it was maybe about a minute and a half.
And let me ask a better question. Did you continue to watch people walk away until you couldn't see them anymore?
Bueno, y pues permítanme hacerle una pregunta. Entonces, ¿usted continuó viendo a estas personas? ¿Ya no pudo mirarlas?
Sí.
Yes.
Okay, and after you couldn't see them anymore, can you tell the jurors, did you stay, I guess, at your window, or did you go anywhere else in your home?
Y pues, permítanme preguntar esto, si puede decir a los juristas, de que si después de que usted vio a estas personas caminando, y si después de que usted ya no las pudo ver, ¿usted se quedó ahí en la ventana o se fue a alguna otra parte de su casa?
Me fui a la cocina.
I went to the kitchen.
Okay, and while you were in the kitchen that morning, did you hear anything further that caught your attention?
Sí.
Yes.
Can you tell the jurors, what did you hear?
Otros dos balazos.
Another two shots.
Okay, when you say shots, you mean like gunshots?
Balazos como balazos de pistola?
Sí.
Yes.
After you heard the gunshots, can you tell the jurors, what did you do next? Did you go back to the window? Did you stay in your kitchen?
¿Qué usted hizo después de haber escuchado los otros dos balazos? ¿Se fue a la ventana? ¿Se quedó en la cocina?
Volví a mirar, pero ya no estaba, no fue ahí.
I went to go back and look, but they weren't there.
And how long did you look out your window? Did you ever see anyone again?
¿Y por cuánto tiempo es que usted miró por la ventana? ¿Llegó usted a volver a ver?
No.
No.
Okay. And I guess do you remember if you looked out your window for a couple of seconds, minutes? Do you remember?
¿Se acuerda? Usted al ver por la ventana, miró por segundos, minutos, ¿se acuerda?
Y la primera vez, como por 5 3 minutos, yo creo, la primera. Y la segunda solo nomás fui a mirar, pero ya no había nadie.
The first time it was for like 5 minutes, 3 minutes, but for the second time I just went to look and I didn't look again.
Okay. Now, the three people that you had seen, did you know them?
Las 3 personas que usted vio, ¿usted las conocía?
No.
No.
Okay, and you said prior to them going off, could you hear what they were saying?
Antes de que ellos se fueran. ¿Usted podía escuchar lo que ellos estaban diciendo?
No.
No.
And later that day, did officers or detectives come to your home?
Más adelante, ¿acaso oficiales o detectives fueron a la casa de usted?
Sí.
Yes.
And when they came to your house, did you have an opportunity to speak with them or have a conversation with the detectives?
Yes.
And did you tell the detectives what you told the jury here today?
Sí.
Yes.
Thank you for your time, sir. I don't have any further questions at this moment.
I have a question before you start, Mr. Bass. The man who was on the ground, did he stand up and walk away? Or did the other two people carry him?
Estaban en el piso. Él mismo se pudo levantar y caminar sí mismo, o los otros dos lo levantaron y lo cargaron.
Iban muy pegados, no alcancé a mirar si lo llevaban cargando, pero iban así muy pegados.
They were very, very close together. I couldn't tell because they were like really, really close together.
Thank you. Mr. Bass.
Do you need your interpreter to understand what I'm saying in English?
¿Usted necesita su intérprete para entender lo que yo le estoy diciendo en inglés?
Yes.
Did you need an interpreter when I spoke with you about this incident 2 weeks ago in English?
¿Usted necesitaba un intérprete para hablar conmigo con respecto a este incidente hace 2 semanas?
A veces sí, a veces no.
Sometimes yes, sometimes no.
I walked with you down the street as you were walking to the Chevron, speaking in English and receiving answers in English. Do you remember that?
Nosotros estábamos caminando y nosotros estábamos hablando en inglés. ¿Se acuerda usted de eso?
Sí.
Yes.
And you also remember telling me that you did not see anything, correct?
¿Usted se acuerda de haber dicho de que usted no había visto nada, correcto?
Sí.
Yes.
And after speaking with the prosecutor, you now have this story to tell, correct?
Y después de hablar con la fiscalía, ahora tiene esta historia para contar, ¿correcto?
Sí.
Yes.
¿Quiere que le diga por qué?
Did
Would you
you
like me to tell you why?
wait for my question, then respond?
Espérese a que le haga la pregunta y le voy a responder.
Did you see a fight in the driveway between any persons on that day?
La pelea en el driveway entre algunas personas.
No.
No.
Did you hear a 911 call being made by somebody in that driveway at roughly 6:03 on February 5th, 2025 from that driveway? Did you hear that call being made?
Said 2025.
My bad. 2024.
Thank you, Ms. Rivers.
Se escuchó una llamada hecha al 9:00 a las 6 con 3 el 5 de febrero de 2024. El 5 de febrero de 2024.
No.
No.
Did you hear the person on the phone saying, I am holding down the person, send the police, he tried to break into my car? Did you hear any of those words?
The objector, he's already answered that he didn't hear any aspect of the.
All right, since he didn't hear anything, don't start creating scenarios of what he could have heard because he said he heard nothing.
Is it your testimony today that you heard 3 shots total that morning?
De que esa mañana usted escuchó 3 tiros en total esa mañana.
Sí.
Yes.
Have you at any point in time prior to today told anyone, law enforcement or the prosecutor or me, anyone that there were 3 shots on February 5th, 2024?
tocando con la fiscalía, la fuerza policial. Yo tengo algo más de 3 balazos disparados ese día, el 5 de febrero del 2024.
No, yo no. Yo escuché 3.
No, not I. I heard 3.
Tell us the time that passed between each shot.
Son entre cada tiro.
Como número 1,
Like, well, first there was one
cuando desperté,
when I woke up,
y cuando se fueron caminando para la gas,
and then when they went walking to the gas,
cuando me metí a la cocina,
when I went.
Jury's out. We were about to begin Mr. Whitaker's closing. But I've been advised that between Mr. Whitaker's closing and the state's rebuttal, that will take about an hour. And so it is now 4:45. That will take us to 5:45. So I think I am going to excuse Mr. Robinson's jury for the evening. We will not get to Mr. Robinson's close today, because if it is going to be an hour and a half, I don't want to begin that at 5 o'clock, or excuse me, at 6 o'clock, because then the state is also entitled to a rebuttal of that close. So I'm going to excuse them now and tell them to be here at 9:30 tomorrow, because while we're going to finish Whitaker's closings today, I'm going to instruct them at 9, and they will begin deliberating. And while they are deliberating, we will conduct the closings for Mr. Robinson, and then I will instruct that jury, and then they will begin deliberating. So I'm going to bring them out now, if there's nothing else to raise by anybody before I do so. You just need to be here at 9:30. I'm going to be instructing Whitaker's jury from 9 to 9:30, so unless you want to be here, I'm not ordering you to be here. 9:30 is for Mr. Robinson. All right, are we ready to bring Mr. Robinson's jury out so they can be excused?
Just one question.
Yes.
Okay. They emailed it, we're all set, thank you.
Okay. All right, let's bring out Mr. Robinson's jury. We have a slight change of plans. Having spoken to the attorneys for Mr. Whitaker, between the close that's anticipated and the state's rebuttal on that close, that's going to take about an hour, and it is now 4:50. That means it would be 5:50 or perhaps even 6 o'clock before we begin with your close. So we're not going to do Mr. Robinson's close this evening because that's too late, because then the defense would be entitled to give their close and the state a rebuttal to that close. So I am going to excuse you for the evening and ask that you all return tomorrow here in courtroom 407 at 9:30 a.m., a little later than our usual start time, 9:30 a.m., where we will then do the closings from both the defense and the state's rebuttal, and then I will instruct you on the law and then excuse you to deliberate. So during this evening recess, please be very mindful not to read, watch, or listen to any stories on the television, anything that might appear on your social media accounts if you have social media. Also not to speak to anyone about this case, friends, family, those that might be curious, those that might try to approach you as you leave here today or arrive tomorrow morning. And that's because this case has to be tried by you only in your collective presence and in the presence of Mr. Robinson, his attorneys, the state attorneys, and the court. We're going to take your notebooks, we'll lock them and secure them, return them to you when we reconvene. And of course, tomorrow, what I would also add is, I think the majority of you have been eating lunch, I should say all but one of you have been eating lunch in the jury room. Once I excuse you to deliberate, I'm not going to let you, your recesses will all be in there. There's not going to be going out and roaming the halls. So if you could, I would request you all bring your lunch to eat lunch tomorrow, because it may be that by the time I conclude with instructions, it'll be lunchtime, and I'm going to excuse you to begin deliberating at that time. And you can do a working lunch. You can eat lunch and deliberate at the same time, but I don't want a 1 hour lunch recess where one is absent, but the rest of you are in there. So hopefully if you all could bring your lunch and then eat lunch together and deliberate a verdict at that time. So with that said, I wish you all a good evening, and I will see you back here tomorrow at 9:30. And at this time, I'm going to call upon counsel for Mr. Whitaker for her closing argument.
Thank you, Your Honor. May it please the court.
Yes.
Would you please? Thank you very much, officer. I appreciate you. May it please the court, counsel. You may have realized that we stand every time you enter this court. We do that out of respect. This courtroom is literally majestic. The great state of Florida behind your honor. Your honor is robed. You have two flags. The state of Florida flag. This hall. And I point that out to you, ladies and gentlemen, because you have sacrificed. You have sacrificed your time. Time away from your family. Time away from your jobs. Time away from your pursuits. Be to sing. When we're in this hall, when we're here, not on the internet in a nice moment. We're not in some kind of chat room where everyone's spousing their opinions. Put on and on about beyond and to the exclusion of a reasonable doubt. And I want to briefly go over that actual instruction, word for word. One of the things we've been doing while you guys have been stuck behind closed doors, not pursuing your own interests, we've been working on what exact words, what law, plainest and as you can see, a reasonable doubt, the defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving, and the state always carries that burden, of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. And they go out of their way to define it whenever the words reasonable doubt are used. And this is what I want you to pay attention to. You always hear, and it's common because it is within the law, prosecutors say a reasonable doubt, or we even have a slide from the state's presentation. Reasonable doubt is not possible, speculative, imaginary, or forced doubt. That statement is an accurate statement of the law. If you add the rest of the sentence, and the rest of the sentence is, ladies and gentlemen, if and only if you have what's called an abiding conviction of guilt, one which does not waver or vacillate, because if it does, even if you have a conviction, but it's not stable, it's one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt. And you must find the defendant not guilty because that doubt, which could be imaginary, forced, speculative, it's reasonable because you don't have that abiding conviction imagine most of us. What do people see when they look at this image? Do they see two faces? Do they see a face? When you have equal explanations, is it a face beyond a reasonable doubt? Is it a fake two faces beyond a reasonable doubt? Ultimately, you all decide. You all decide never let you forget this image as you think about the state's obligation. Because I want to talk to you about what their actual evidence was. And we heard, and I will tell you at the outset, probably should have started with this. You all not making a determination in regards to Mr. Not asking that. There was an argument to evidence. So let's talk about what evidence actually applies. Leroy Whitaker and is worthy of your consideration. I would suggest you know basically kind of 4 categories of what we heard that had any application in regards to Leroy Whitaker. We have DNA records, we have cell phone records, we have Abdul Robinson Sr., AKA Blue, and we have Dominique Barner. Let's kind of start with some of the most straightforward evidence. And I will say it's straightforward. The DNA evidence. Now you've got to consider what that tells you, what that helps you to determine. We have 2 different kinds of DNA evidence. DNA evidence that was found in the car. We have DNA evidence that's alleged to have been found in the front room. Now, the DNA analyst, if you will remember, was very, very clear. DNA is transferred. You might remember the example of I can hold an object, give that object to another person. They have it. They place it somewhere I've never been. It doesn't tell us when DNA was left. It doesn't tell us how. You've heard this statistical significance that she gives 700 voters. But remember where that number actually comes from. It comes from the community. They actually created a database with, if you remember the number, 1,197 people have had their DNA analyzed and put in this database. They use that to determine, well, out of these 1,197 people, only 2% of those people had a certain DNA characteristic. And then they try to extrapolate that. Okay, the rest of the world must be like that too. And that's why I say, you keep saying no 2 people have the same DNA. That we don't. Ultimately, you all decide, no, I think the DNA evidence is pretty compelling. What does it tell you? Does it tell you which one you're going to murder? No. At best, if you wanted to believe every word scientists, in this case, from the Florida Department of Law Enforcement. Their whole job is to aid law enforcement. If you even wanted to believe every single word, what does it at best? That Leroy Whitaker was in a car? That Leroy Whitaker does not tell us. If we have cell phone records, and ladies and gentlemen, it sure seemed like we spent a lot of time establishing IP addresses. IP addresses. Who called who? Did we have that kind of testimony? In regards to this alleged phone used by Leroy Whitaker? Hold out for you. You're the fact finders. You all, evidently in evidence, do they tell you? They tell you, and remember his testimony. I've drawn these maps, and I put up these arrows, and it's, anywhere in this area, 1.5 to 2 miles radius, where this land is. So is it truly helpful? Because let's think of these population centers. We saw from all the photographs how many people are out at that Merrill Road. These phone numbers give us the exact location. Let's assume for a second we was chose to stop as a group. Phone records are helpful. We think the phone records tell us where Leroy Whitaker's phone might have been traveling. Let's say we further even decide, you know what? I think that evidence was pretty compelling. I think it shows that he was at Merrill Road, and he was at Townsend Road, and he was at Oakland's house. Does that count a first-degree murder? No. Then we have Mr. Abdul Robinson. Mr. Abdul Robinson Sr., and we know he's a cooperator, just like John Clark. Done it before successfully. He comes in. And what does he say? Says, I had a certain phone number, and I got some calls that day. One was from my son, Abdul Jr., one was from Leroy Hurst. Somebody I know because he is the name of Whitaker's gun. And remember the testimony, for 5 years, they had this guy's iCloud. They have everything he's ever posted. They have every photo he's ever taken. You're telling me that someone who owns a gun like this, someone who's so down with, hey, it's the middle of the day, let's go and stop somebody and shoot him in broad daylight. If he is that person, we don't think there aren't 50 photos of him with this gun? This Mac Daddy gun? He's not putting out a picture of himself with it? We don't have some video of him flashing around? We don't have anything of that. Detective Smith, 5 years, and that's the piece of evidence. All guns have serial numbers. Detective Smith ever tried to trace this gun? It didn't just magically appear. There's all these bullets. They're huge. Was a search warrant ever conducted on Leroy Whitaker's house? Or he asked Detective Smith that? For the interviews of his family, surely somebody has seen Leroy Whitaker with this gun. This isn't just some handgun. This isn't some just revolver in the back of your pants. This is a Mac Daddy assault rifle. And if you're the kind of person that uses instruments like that to gun people down, you're damn proud of them. And of course you know. No. As a claim of Dominic Armour. Oh yeah, that's what you would say. I imagine you might hear an argument. Well, we think there's 3 people in the car. There were 3 guns. Were there? Who testified to that? Even Dominic Armour himself. He said, I know I had this and Leroy had that other gun. Shooter had some other gun. We know supposedly the shooter left with his gun. Just because there's an extra gun in the car, it automatically, logically, beyond a reasonable doubt, is Leroy Whitaker? Without any other evidence? Think about all the things Detective Smith could have, but didn't, or maybe did, and just the evidence isn't available for this rifle. Because we know there's no fingerprints. We know there's no DNA on it. We know there was no search warrant for his home, any interviews of his home. We know he didn't attempt to trace this gun in any kind of way. And most importantly, you know the biggest thing you didn't have? This might have been a little helpful. You didn't have an iCloud or a phone from Dominic Armour. It is important to remember how and why Detective Smith explained that. Why didn't you get an iCloud for Dominic Armour? Why didn't you try to get the physical phone by August of 2020? He's a state
multiple different family members involved in the Robinson. Mr. Robinson himself told you he had 11 children. So where was this evidence that Leroy Whitaker has this big motive? We've heard they, we've heard we, all those kind of group words. Actual evidence that Leroy did. Because again, a lot of other evidence that we've heard in this
up something outlandish, you're gonna pepper it. Work off 2 murders. He's gotta work off an aggravated fleeing. He's gotta work off a burglary with assault. What does he need? Convictions. Wants convictions. And so doesn't it just make it easy for Dominique Bonner to say, yeah, and by the way, Leroy Whitaker was totally part of it too. He was all in. Those are the magic words. You heard him explain. Did you do an arrest warrant after you got these phone numbers? No. Did you do an arrest warrant after you got the DNA? No. Because what do those things do? Those things tell us he was in a car, he was in a house, he was there. And the one thing you're never going to get an instruction on, ladies and gentlemen, is you're not going to receive an instruction that if you're at the scene of a crime, you're guilty. What is required for the state of Florida to actually prove? To be a principal, it is far more number one, things that must be proven on to the exclusion of. Meaning, not wavering, not vacillating, finding conviction. That's where it comes The other thing that I will tell you is probably the most telling. I'm going to get into Jacksonville Sheriff's Office. We heard a little bit about it yesterday. Is that as an investigative technique, Jacksonville Sheriff's Office can do something that's called surreptitious tape. So you have two suspects. And they'll do this oftentimes when two people are arrested together. They might put them in the back of a police car on the camera. Same with the interview rooms. Put them in there. Part of the timeline. The timeline is somewhat critical. August 27th, 2020, Dominic Varner agrees to be a state witness, provides a sworn statement. All of the arrest warrants are completed at that point. Jacksonville Sheriff's Office didn't charge Leroy Whitaker with murder until Dominic Varner said the magic words. But then you have them, right? You've got those magic words. Dominic Varner is now at your disposal. He wants to do anything. Dominic Varner and Leroy Whitaker into a room and turn the tape. Good at. You heard from Mr. Varner. He was right next door to Duval County Jail. Why wouldn't they want to? Absence of that evidence. Wavering? Are you vacillating? You don't get to the other side. As women. Another technique they could have attempted, and we heard they evidently thought well of it because someone wore a wire on Dominic Varner. Why not on Leroy Whitaker? Why not? We're about to charge a 19-year-old young man with first-degree murder that you've heard from Dominic Varner. He had to make sure that he cooperated. He did not want to go for mandatory life. He has to say something. And so it becomes Leroy Whitaker was involved. He was all in. I can't give you any details. I can't point to a text message. We just saw some text messages between evidently Abdul Jr. and Dominic Varner. Was Leroy Whitaker copied on that? Do we have text messages from Leroy Whitaker and Dominic Varner or anyone even mentioning Charles McCormick's name? Do we have any kind of posts that Leroy Whitaker acknowledges ATK, acknowledges 6 Block, acknowledges some kind of rivalry? No, we've only heard they have a rivalry. They were upset about Willie Addison's death. What has been shown to you about Leroy Whitaker? Ladies and gentlemen, I submit to you nothing. We have magic words from Dominic Varner, not supported by a single other piece of evidence. I want to skip to this slide because it is an important instruction in that the framers that actually set out these instructions, and they spent a lot of time doing it, they actually put this in the law because it's that important, because they recognize that you must consider the testimony of some witnesses, snitches, with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, has been promised immunity, or hopes to gain more favorable treatment in his case may have a reason to make a false statement in order to strike a good bargain with the state. May, as kind of an aside, because I know you guys have been here long, I'm going to tell you about my husband's and mine's first date. Because strangely enough, our first date was to see the movie Indecent Proposal. I don't know if you ever saw that movie. It was with Robert Redford, Demi Moore, and but essentially you had this married couple, and Robert Redford ends up propositioning them that if Demi Moore will have sexual intercourse with him. And I have to tell you, as a first date, it was kind of an amusing movie to watch. Prompted a lot of fun conversation afterwards. We're still married, so it all worked out. But I think about that kind of scenario in the scheme of it's not mine. Something's far more important. He's 31 years old. 10 years? Or we know it's much less than that. If he ends up getting 20, he's got 5 years left. He doesn't have any remaining toys, so he ends up getting out even less. He has to do all that. That's a long time to be. What would Dominic Barner do? You know, he told you what he did back in the day. He was able to get probation when he testified against his friend Mark Clayton. Said, absolutely, willing to do it. I needed to get out of jail. Dominic Barner. Anything. But he needs convictions. And he needs a lot of them. Because he's got 2 separate murders. He's got to atone for. He's got an aggravated fleeing, and he's got burglary with assault or battery. Dominic Barner needs convictions. It's not going to be sufficient, not for his sentencing hearing that he has planned, just to say, oh, well, yeah, we went into the house. No, Leroy Whitaker needed to be part of it. He needed to be part of it so that Dominic Barner can have one more conviction to try to hang his hat on of why he should get out of jail. As he said, well, I think I should get the 20 years because I'm bringing justice for the family. And with that, you do have to recognize, and I mean this in all sincerity, homicide detectives work very, very hard. I'm confident of that. And I don't think Detective Smith is any stranger or anomaly of that. I'm sure he works extremely hard. But there is pressure on homicide detectives. Because as I asked him, they're the ones that have to go and sit down with the family to explain, your loved one's not here. And so there is pressure to get anyone that was a part of the death of their child. That pressure is understandable, but it doesn't erase their obligation that they do actually have to prove it. It's not enough to simply say, he was in on it. I'm sure there were conversations. Because at the very end of the day, ladies and gentlemen, even if you wanted to try to believe Dominic Barner when he claims, well, once we got to the apartment complex, there was this discussion that both Leroy Whitaker and the shooter were going to shoot. Both were going to do it. What do we know? We know Charles McCormick was killed by a lone gunman. So even if you believe every single thing the state has presented to you, the reality is he didn't do it. They've shown nothing, not through photographs,
not through Instagram posts, not through phone calls, not through text messages, not even through Barner's testimony, any evidence that Leroy Whitaker had any intent for Charles McCormick to die. I am going to sit down in a few moments, and I ask you to indulge me for just a few moments while I go through my notes. Because let me tell you the worst thing for a trial lawyer, and it doesn't matter what side you're on. You sit down, and 2 seconds later, I'll think of something that I was dying to tell you that I just simply forgot. Another difficulty in terms of that lack of evidence, and reasonable doubt can come from it, there was zero investigation in regards to this car. And Detective Smith, again, was like, well, it'd been gone for 2 months. But again, they're trying to ask you all to convict of the highest charge in the land on Dominique Barner's testimony alone. Nothing else they presented proves the principle or even alleges it. He didn't even have probable cause until Barner said those magic words. Why? Because being at the scene of a crime is not a crime. You need to do more. And they've literally not shown you anything. But why wouldn't? Detective Smith, you have this car that's stolen. 2 months ago, did you even bother to talk to the person who owned the car? No. Did you even talk to the last person who drove it to understand how exactly it might have gotten stolen and if there's any potential leads for us to figure out where this car was for 2 months? No. Detective Smith, you have, as a Jacksonville Sheriff's Office tool at your disposal, these license plate readers, various spots in Jacksonville that you just type in the license plate and it will tell you, hey, on such and such day at such and such time, this car passed this intersection. Here's a photograph of it. Was anything done like that? Would that have been helpful? Ladies and gentlemen, I suggest it might, because we have a complete lack of evidence. The most simple thing, and if you think about the allegations are that all of this involves this big drill music, rap music. Ever turn the car on and figure out if anybody actually connected it? No, our software can't do that. How about just manually looking if there's a phone attached? Not done. That's a lack of evidence, ladies and gentlemen. We have no evidence of social media posts of Leroy Whitaker, of rap lyrics of Leroy Whitaker, of notes in his phone of Leroy Whitaker, text messages bragging, none from Leroy Whitaker, text message to Leroy Whitaker, talking about McCormick, talking about being with them. None there. We have no evidence, besides Barner, that that's his gun. We don't have anything tying him to the gun. We have no investigation as to the serial number of where this gun came from, how it might have gotten into whoever's hands had it, how it got in that car. None of it. We just assume. It's almost as if Leroy Whitaker is almost a footnote, an afterthought. Oh yeah, and Leroy Whitaker. Oh yeah, he was all in. We don't have any actual evidence that he ever manifested any desire for Charles McCormick to die, that he ever did anything besides potentially sit in an Altima car. That's what they've shown you. Detective Smith told us all we ever asked from Dominique Barner was the truth. He didn't ask him anything. The last question that I asked Detective Smith, if you remember, because we had these questions about how even after arrest, the investigation continues. And on September 11th of 2020, Detective Smith had executed that arrest warrant that talks about phone records, that talks about DNA, and most importantly contains those magic words, because Dominique Barner has come forward. But if you remember, my last question to him was, after the arrest, number one, of Dominique Barner, did you, Detective Smith, ever sit down with him and say, okay, let's really talk about this. Let's make sure that there aren't any other investigative leads now that I have full access to you, like your phone or your iCloud or anything else. Never spoke to him. And even worse, I asked him, after that arrest warrant, did you ever, I know your investigation supposedly continued, did you ever develop any other evidence or theory of principle of Leroy Whitaker? And vacillate. Leroy Whitaker was involved in this homicide. Leroy Whitaker manifested some intent. We have no evidence of that. My greatest wish for you as jurors, after you ultimately leave our hall of justice, is that you feel pride about your experience. Pride of being part of the system that we all do cherish. Pride in a system that upholds the law and is bound by the law. And you all are bound by the law. The burden of proof in this case is beyond and to the exclusion of a reasonable doubt. And to illustrate just how much, just how high of a burden, really think that all of these things, if we were somewhere not in a hallowed hall of justice, and we thought to ourselves, you know what? 3 guns, 3 people, I think it's pretty logical that gun must have been his. If you think, you know, their family, yeah, he probably did know what time of day it was. Those are all guilt, most likely. Legally, that's not guilty. Guilt, likely, not guilty. Probably guilty, not guilty. Possibly guilty, not guilty. Suspected, not guilty. Perhaps not guilty. May not be guilty, not guilty. Possibly not guilty, not guilty. Unlikely guilty, not guilty. Probably not guilty, not guilty. Less than likely guilt, not guilty. Not likely guilty, innocent. When the state falls short, ladies and gentlemen, your constitutional burden is to find him not guilty. On behalf
All right, thank you, Ms. Schlack. State rebuttal close.
May it please the court.
Yes.
Counsel. There is a lot of pressure. There's a lot of pressure on the state of Florida and on Jacksonville Sheriff's Office to bring justice. Charles McCormick. Justice. Barbara Buckley. For the horrible crimes committed against them. And the defendant is not guilty because bad things happen to good people. You better believe that there's pressure. Because what the defense will have you believe is that these two crimes will go without justice, full justice, based on DNA evidence in multiple locations with a 700 billion times more likely ratio that it's this defendant than anyone else in the world. And his phone records would put him every single step of the way exactly where he's supposed to be and totally corroborate what that other criminal said. If he ran from the scene and beat a woman to make sure he got away. Innocent people don't run away and break into the houses of citizens on Townsend Boulevard because they're just along for the ride. We heard an hour closing argument from Ms. Schlack, and God bless her. She is upholding the defendant's right of counsel to zealously represent him within the bounds of the law, and she did that. And she spent 59 minutes and 30 seconds talking about Charles McCormick, and about 5 seconds talking about Barbara Buckley. Why do you suppose that is? Why were these crimes charged together? And Ms. Schlack is right that you're to consider their verdict separately. We considered all the evidence in the case. The evidence against Hakeem Robinson and the evidence against Leroy Whitaker for both charges together because you can't unwrap it. This is one criminal episode. And the evidence against Barbara Buckley 1,000% proves he was involved in the murder. Why else do you break into a woman's house and grab her and say, I'm going to hurt her? Why on earth do you do that? Unless you're with the big gun. And that's why it wasn't discussed. Because if you analyze this case in total, there is no reasonable doubt. She talked about the evidence is DNA. The evidence is cell phones. The evidence is blue, and the evidence is barter. She left out a really, really important thing. And that is your God-given common sense. Your ability as a human being to realize that 2 plus 2 equals 4. That you can make logical inferences from the evidence to speak to what the truth is. How many barter can lie all day from the witness stand, but you have judgment. Now, I'm going to go through a whole bunch of things that prove that Dominique Barter didn't lie. He's a liar. And a criminal. So first, I want to talk a little bit about the objective truths that have nothing to do with Dominique Barter or Abdul Robinson. The Addison family and ATK was dissed by the victim in 6 Block in a song making fun of their loved one That limits the number of people in the world. Mr. Cooper is going to pull up proof. Ms. Schlack said there's no evidence that Scotty is involved in ATK. There is the fact that his Instagram has ATK on it. Could you just circle that, show me what I'm talking about? Life of ATK with big ATK written. Huh. I know, listen. I consider Mr. Cooper far better individual ethics than I am. You saw that they did most of that. We threw a lot of stuff at you, and I get it, and these things are missed. I don't think the Schlacks was trying to mislead you. We're from the same generation. But it's in there. Testimonies uncontroverted. This Robinson, who we heard from today, said, oh, they're not just friends, they're cousins. They're blood, and we were all Mr. Whitaker is in for a penny, in for a pound, just on motive. That should not be in dispute. He is objective that he is part of that group. Now, is he as big as Hakeem Robinson? No. Is he a rapper? No. But he's with them. We see the pictures of them together. We see videos of them together. They are hanging out thick as thieves. So the number of people that were willing to kill Charles McCormick, who's showing up at an employment service, is limited. It doesn't mean it's Leroy Whitaker exclusively. No, it doesn't mean that. But it's limited. That's objective. Number two, that both defendants, and remember, the evidence against Robinson corroborates the evidence against Whitaker and vice versa. That's why we tried them together. And I agree with Ms. Schlack's point that the verdicts are separate. That's why we have two juries. But you have to consider all the evidence and see how all the evidence fits. Both the defendants had the opportunity. The whole point of the cell phone evidence, Ms. Schlack is right. It's not GPS. It doesn't put him everywhere at the exact possible location. You know what it doesn't do? It doesn't exculpate him. It doesn't show he's somewhere else. In fact, it shows he is everywhere the Dominique Barber says he is. Cell phones. Mr. Whitaker's cell phone stuff is actually the TDOA, the bands, and actually gives us a little bit more precise. And if you remember that testimony, he is at every location. He is at the Maryland Road, he is at Townsend Road, at both of them. Receiving calls, texting locations, all his phone. We prove it's his phone. People went over this, I'm not going to do it again. The Instagram for the defendant, this Instagram was verified with this number. He has all these little selfie pictures. That's how we prove it's his son. And it's corroborated because it's going exactly what Dominique Barber says it's going. Again, this is objective. Selfie stuff is objective. It puts him in Townsend Road, and it puts him at the scene. And that stuff has nothing to do with Dominique Barber. Oh, and guess what? The Robinson evidence does the same thing. He turns his phone off with his real phone, his burner phone. The data is hitting on all the points it's supposed to be hitting. Corroborating everything. Objective evidence. We know that the Nissan car is the murder car. There is no dispute about that. The Nissan car that crashed is the murder car. That was trailed and followed by the police from the scene of the murder, from the dash cam, until it crashed on Townsend Boulevard and people started running from it. Right? And we know that the shooter fled from the car with the weapon. The same weapon he used to kill, and it's Hakeem Robinson, there's no doubt about that. The same weapon he used to kill Charles McCormick is the same weapon somewhere in Tree Hill Preserve. The same weapon he had in that video that you can see, the video, Bang It Up video, is the same you can see. And that guy ran out with his gun. He's got to get rid of the murder weapon. These guns are, you say they're relevant, they're very important to prove the case. They're not the murder weapon. He took his murder weapon and got rid of it. And that is why Donnie Barner wouldn't let him use his pistol. Because he's like, hey, you're not using this, you're going to throw this away afterwards. You can't even call it a murder weapon. You can't have my gun. You got to use your own gun. Anyway. And so we know that there's two guns left. The murderer took the weapon, and we know that we found two guns in the car. Mr. Robinson was linked to the murder car in three ways. The shirt in the driver's area, his DNA in the driver's compartment, and the print on Dominique Barner's slide of his handgun. Three different ways he's placed in that car. Whitaker was placed in the car in two ways. Leroy Whitaker was on both shirts. One of them was with Hakeem Robinson. Both of these shirts, whether they were worn or not, maybe they were worn earlier, maybe they were worn as masks to cover, we don't know that exactly. But we know that they were kind of balled up, especially the one in the front. Kind of wrapped up right next to the gun. They're wrapped up, and they both have their DNAs on it. 700 billion times more likely. Okay? It doesn't just jump around. It doesn't just jump around. So, that two shirts puts Whitaker in the car. He's in the driver's side and the passenger in the rear part. And Schleck said over again, there's nothing that puts him on to this gun, which was swabbed, tested, we know nothing was on it. That means no one's ever touched it? Of course not. That means DNA and fingerprints are sometimes tough to get. If you touch something, it doesn't necessarily find. Almost, it's not on top of it. It shows in the seat. The gun's right there on the floorboard. You can't sit in the back seat without touching that gun. You have to see it. And Leroy Whitaker's DNA on that shirt. No real dispute about that. We hear a lot of dispute about that. His DNA is on the shirt. A lot of dispute about it. She screams over and over again, there's no evidence. But if your DNA is on the shirt, the backseat, right, almost touching a huge rifle, that's pretty good evidence that that defendant had that gun. Pretty good evidence if you use your God-given common sense. Robinson possessed the similar unique firearm before the crime. We talked about that. Now this is, I can't stress this enough. I opened with this. But Whitaker and Barner were so desperate to get away from this crime scene that they broke in to a woman they did not know, a 57-year-old woman's house, and they left their DNA on her pajamas. But it wasn't just DNA. It was blood. It was blood on her pajamas. And the testimony from the DNA analyst was it was both a single source from the mixture. So I have to explain something. You're gonna find Miss Buckley's DNA on Miss Buckley's body and on her clothes. Right? Give it. You're wearing clothes, you're gonna find my DNA. So she's looking for DNA foreign to the neck, the hands, and the clothes. She tests, or she can find DNA. It tests all tests for blood. Barner's blood and Whitaker's blood. But it's not a mixture of the two of them. hours and hours leading up to all of this? Whitaker and Barner got picked up by Blue. We have the pin track, we have the cells. Blue pled to doing that. He said, Abdul Robinson, I came out, picked these guys up, and they got me on the hook for the accessory after the fact. These are undisputed facts. Robinson is right-handed, wore a black and gray hoodie, just like the one the shooter has. Robinson was very happy about the murder and liked to brag about it. The video proves that the descriptions of the shooter were all wrong. So let's talk a little bit about motives to lie. All of that evidence, I submit to you, we don't need one at all. We still have to analyze what he has to say compared to the known evidence. Is he telling the truth? He is a liar. Why should he be lying? Those are two very different questions. Very different questions. So, Barner, first of all, this is a minor point. Barner and all witnesses, every witness, met with the prosecutors and the defense attorneys before testifying. We heard a lot of questions like, well, how many times did you meet with the state? Yes, that's implying that somehow Mr. Cooper and I are telling these people what to say. We're doing a real crappy job. We meet with our witnesses because we need to know what they're going to testify to. And you know who says it's okay to meet with your witnesses? The law and Judge Salvador. Quote, you will hear this later. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Quote, Judge Salvador, when you're charged to hear this case. No witness should ever be discredited because they sat down and talked to both sides about what they would testify to if called as a witness. That is the law. So Dominic Barner shouldn't be discredited because he met. Dominic Barner, and this is a fact, Dominic Barner wants to get the best deal for himself. I don't think there's any doubt about that. He's doing this for selfish reasons. He's not doing this out of the goodness of his heart. He may say that. You know, I want justice. Okay, whatever. Talk a second about his deal. There is no evidence he's getting 20 years. That is the minimum Judge Salvador can give him. And she can give him life without parole. Anything in between is her decision and her decision alone. This whole concept that we bought this testimony, that's a real bad deal. He just pled guilty, confessed over and over again under oath, 9 hours of deposition, confessed to multiple murders. He knows that this judge can say, I appreciate what you did, Mr. Barner. I'll give you life. That's the deal they're talking about? To strike a good bargain? What kind of bargain do you strike with the state? But his plan, according to the defense, his plan is to lie. When we have that much leverage of him, Judge Salvador has life to hang over him. And he's going to go, you know what? I'm going to make up who did this with me. Just going to make it up. Leroy Whitaker had no idea what he was doing. Right? He was just sitting in the car. We tricked him. I guess is the argument. What if we find out evidence he was lying after pled and looking at life? How would that look in his sentencing hearing? Your Honor, Mr. Barner agreed to testify and cooperate, but he lied about who was involved in this case. He said Mr. Whitaker was involved, and he wasn't. What? That's where you have to critically analyze what Barner's saying. Of course, he wants to make sure that the truth comes out because it'll help him. Help him because the evidence will corroborate the truth, and all that pressure will get justice for these victims. Not makeup. Barner doesn't know that Blue is going to testify. Blue doesn't know Barner is going to testify. Well, maybe he did by the time he flipped. Barner didn't know Natalie Gann and Renata Boston were going to testify. Again, this relates more to Hakeem Robinson, but it doesn't. He says Hakeem Robinson is the shooter. He doesn't know Renata Boston's going to come into this courtroom and Renata Boston's going to say, yeah, it was some dude, I got an alert on my phone. Some dude wearing a black and red jumpsuit came crawling out, walking out of the woods. And some white girl was driving around looking to pick somebody up. And Natalie Gant, who is not, we have no leverage on her. None. Nobody's arrested. Nobody's in trouble. Natalie Gant, just take a sworn statement once we figure out who she is. Take a sworn statement. Yeah, I went and, picked up Hakeem Robinson from the exact same location that his phone's pinging that we have that little map. That corroborates Barner. And that means he's telling you the truth about all this stuff. Barner didn't know that the digital expert Latham was going to do a body morphology and conclude the defendant could be the person behind the mask. Same argument. Has to do more with Hakeem Robinson. This means he's telling the truth. When he says it's Hakeem Robinson, he doesn't know that we're going to spend $70,000 on some digital expert to go, yeah, kind of sounds like him, kind of looks like him, it matches. It's consistent with. Barner didn't know that we would be able to link Whitaker's phone through Instagram and prove everything that he testified to. Barner couldn't have known that the cloud would capture proof that Robinson's burner phone was his and would link Robinson to the murder. I mean, for all of Dominic Barner's issues, I don't think his brilliance is going to be argued by anyone here. So he's supposed to know all this stuff and predict it? Barner could not fabricate the DNA evidence. He could not fabricate the print evidence. That is overwhelming, and it proves this defendant's guilt. Barner didn't know that Robinson's known cell phone would be turned off during the murder, but his cell phone data from his the cell phone from the burner phone would be hitting off the towers. He also didn't know that the cell phone data from the known phone, which we remember when we did the Google searches? The analysts said we don't do that because the data is 95 to 98% reliable, and that's not good enough for us, so we don't chart where the data is, because we know there's some anomalies. We know that there's some anomalies, so we didn't chart that. But the defense went up and put the numbers anyway. You know what that shows? It shows that the known phone of defendant Robinson was at Dominic Barner's house picking him up, and then driving to Atlantic Boulevard where they picked up the Nissan Sentra. And then it magically turns back on when everyone's together and all the crime is over. Kind of interesting. How does Dominic Barner know that? So let's talk about the principal instruction. So we heard that over and over and over again. Mr. Powell's going to pull that up. So again, using your common sense, this is how we prove it's a principle on Charles McCormick. Okay? We're past the verbiage of that. Past proof beyond reasonable doubt, and that is really, I said to you, enough evidence to prove murder, because nobody does that to an innocent woman unless they're blaming the police for a reason. But let's analyze it a little bit more. We know that they were all together for hours. This plot is all night. They're actually sitting in the apartment of Charles McCormick waiting for him. They didn't kill him. They were sitting there for hours. It was like a stakeout. Unfortunately, they're not as good at the police at doing stakeouts because they got distracted and they're playing with their phones or whatever it is. They miss McCormick leaving. But they're there for hours. Mind you, with all these guns, this rifle is not concealable. Hakeem Robinson's pistol rifle is not concealable. They're all sitting in there. Having a conscious intent of the act be done is like going to a football game, being invited to a football game. Hey, we're going to a football game. You want to come? And it's driving all the way to the stadium, sitting there for 4 hours, shaking a pennant in the air, watching the game, having come out. I didn't have a conscious intent to go to a football game. Because I didn't say I wanted to go. I just sat there and cheered. So, we all know they were together stalking the victim. We know that there's a huge rifle in the back seat that he could not have missed. Whitaker, and this is an interesting point. when the crash happens, Robinson goes his way. On the passenger side, driver and Whitaker both go together. Whitaker is leading. Whitaker does everything from that point forward in terms of getting them away. He jumps over the fence first, presumably cutting his leg. Barber's running with him. Then they follow each other, Whitaker leading, into Miss Buckley's home. He is leading the escape, leaving his blood unmistakably on her leg. Barbara Buckley's testimony proves to you on Dominic Barnes. Why are we in this woman's house? What just happened? Why did we shoot that poor man in broad daylight in Merrill Alley? He's like, now you want me to hurt her? Brother? You want me to hurt her? Barbara Buckley doesn't hear a word of animosity, doesn't hear a word of fighting, doesn't hear any conflict between the two. And both of them working together and in conjunction proves what Dominique Barner says. It proves that the defendant is a principal, because what's the common sense? I just witnessed a murder I had nothing to do with, and now I'm breaking into a woman's house to get away? Am I going to work with the person that was obviously in on it? The driver? No. No. They were picked up together, both wearing the Buckley pajamas, having both left their blood all over Miss Buckley. Working together as principals. And they all have the same motive. They all have the same motive. Couple points about the DNA. The defense says, oh, it's flimsy, 700 billion. This is science. This is scientifically accepted in the community at large. This is what DNA evidence is and has been for decades. This is the statistical certainty that they can provide, which is much lower than the actual statistical. Remember, she said it's way more than 700 billion, but we only provide the 700 billion. If you try to count to 700 billion, it would take you 25,900 years to get to that number. You would count 1, 2, 3, without breaks, never sleeping, never drinking, never eating, never dying. It would take you 25,900 years to get to 700 billion. There is no doubt that the blood is the defendant's, the DNA on the shirts is the defendant's. There is no doubt. 3 people, 3 guns, couple of small points. The search warrant of the Whitaker home, he's arrested months later. Remember, we didn't arrest Whitaker for the burglary with assault or battery because we didn't have the DNA for months. Hakeem Robinson was developed as a suspect very early because of the fingerprint. We had those results. Jackson Sheriff's Office lab in the Senate. DNA took months. Once Leroy get a search warrant months later, try to find something, all that time he was out, he had the ability to delete, to get rid of phones. We don't have his phone. To get rid of clouds, to do all kinds of things that he wanted to do to make sure the evidence wouldn't be discovered. Wires and putting people together. The defendant was in jail, charged with a crime that we are trying here today, and had a lawyer appointed to him. He had counsel appointed. So all these neat little tricks that they think we can do, stop by having a lawyer, and he's charged in this case. You know, they say that Barner is a bad liar. He's bad. He's a liar. Then she spent about 20 minutes at the end of her closing saying how Barner doesn't say what my client did. Why on earth is he lying about all this? Not exaggerating. Why doesn't he just say, yeah, I'm down for it. He told me, let's kill that guy. That's not hard to remember. I'm going to kill that guy. I'm going to do this thing. He doesn't say that because he doesn't remember it. He's not bought and paid for. He says, listen, I know he's down because we sit in the car in an apartment complex for 3 hours, hours and hours waiting for this guy to get out. We're all holding guns. That's why I know he's involved. Remember, he doesn't have to say, the principal instruction is act. By word or act. He doesn't have to say, all right, let's all huddle up. This is what we're going to do. All he has to do is be there and clap out of the huddle. Really good analogy. Think about this. God orders calling plays. Everyone's in the huddle. Trevor Lawrence says, we're going to run off tackle right side to ETN. Everyone goes, ready, break. Who talks? Trevor Lawrence. Everyone will. Most everyone's on the same page and they'll jump off the line and we're doing all right. That's exactly what happened here. That is what the principal theory contemplates when it says word or act. Beyond and to the exclusion of a reasonable doubt, maybe the defendant is just the most unlucky person on the face of the earth. That his DNA is everywhere, that he didn't know anything that was happening, and everybody's just coming in here and lying on him. He's just guilty. Beyond and to the exclusion of a reasonable doubt is not possible doubts. It is not x-ray machines at the airport. We talked about that in jury selection. You have a blow dryer or a gun. The person who's checking the x-rays has an absolute duty to confirm what these things are. Right? How are we going to do that other than the presentation of all of this? The law doesn't contemplate all doubt. If there is a possible doubt that a gun is getting on a plane, don't let it on the plane. That is not what the law contemplates. The law says that such a doubt should not influence you to return a verdict of not guilty if you have an embodied conviction of guilt. Reasonable means logical, well-founded doubts. That's what reasonable doubt means. Reasonable doubt, I agree, we have to get you across the river. It can mean that the boat gets wet. It can mean that there's a hole in the boat, but you still get across the river. That's what reasonable doubt is. We have to show you common sense and evidence that this man was a participant in the murder of Charles McCormick and beat and battered Miss Buckley when he entered her home to escape the police. And when you combine all of these pieces of evidence as one and analyze Abdul Robinson Sr. and analyze Bada and say, I don't like him. Arm, they say, checks out. And you have an embodied conviction. It is the same level. Proof is the same as if you steal a pack of gum and you commit first-degree murder. It doesn't change. Not proof beyond possible doubts, all doubts, shadow of a doubts, but well-founded, logical doubts. That is what a reasonable doubt. And you can have pride when you convict this person. is the right thing to do, based on the law, based on the evidence. He's guilty. He's not the unluckiest man on the face of the earth. He just was in for a penny and in for a pound. He did everything he could. He didn't count trail of evidence that he would leave behind. He didn't count on Dominic Barner and Abdul Robinson coming to this courtroom. He didn't count on the cell phone records and Instagram records that would prove where he was and what he was doing. He didn't count on the Ksoo library playing acid and how the tiniest little bit that you leave behind can be discovered by forensic examiners. Didn't count on any of that stuff. Hardest part about doing this is knowing that Charles McCormick's family, Charles McCormick, nothing that we do here change that. Will forever be as he was on that slab of metal. But what we can do, we can provide answers about who's involved, about who's responsible. Telling you this evidence screams that Leroy Whitaker is responsible for the murder. We'll have pride, your jury service, individually and collectively, find that body conviction and kill it. Check that box. Hold that man accountable.
All right, thank you, Mr. Mizrahi. All right, ladies and gentlemen, as promised, then we are recessing for the evening. If you will, please leave your notepads behind. We'll lock them, secure them, return them to you when we reconvene tomorrow. Tomorrow, this jury is coming back at 9 o'clock in the morning here in courtroom 407, where I will instruct you on the law, and then I will excuse you to begin deliberating your verdict. We are almost near the finish line, so it is incredibly important during this overnight recess, as you leave here today or as you arrive tomorrow morning, that you not speak with anyone or allow anyone to approach you or speak to you about anything involving this case. Please make every effort not to watch TV, read the news.
All right, y'all. We done made it. We finally made it to the end of the day. It's been a long one. It is 5:40. So if you were looking for me to do a recap, baby, you got to give me a whole lot of time. It probably ain't going to post until 8, 9 o'clock. I ain't going to hold you. Or I might have to just release it in the morning because there are a ton of things that I need to get to before I do a recap. And I'm sure it's going to take a while for the transcript to develop for me. So I'm going to leave you all just as a gentle reminder that I believe next week is our last week of streaming. So I don't know if we've got, hold on, son. I don't know if we have a good trial to watch next week. That may last a couple of days or just all week. But if we do any streaming next week, I think it'll be our last week of streaming. But thank you to everybody that rocked out with us today. We still have 22 people in here with us. So some of y'all stuck it out. Here you go. You're welcome. You're welcome. Y'all, some of y'all stuck it out. We did the long ride, but tomorrow we'll be back. They'll finish up their charging of Scotty's. They'll finish up their charging of Scotty's jury, and then we'll get closing arguments for Ksoo. So I hope you all have a good, safe, and blessed evening. I will see you all tomorrow.